So we have with us Anita Abraham, Miss Anita Abraham. She is a lawyer and she has been educated in courts of Delhi for the last 12 years. She has worked as an additional public prosecutor for Delhi and the Delhi Airport from 2015 to 2018. Her main areas of legal practice have been criminal law and matrimonial law. Prior to being a state counsel, she was on the panel of the Delhi High Court Legal Services Committee for several years. She has worked on gender and human rights over the years. In the year 2018, she shifted from Delhi to Bangalore and is currently in private practice in Bangalore. And the second speaker with us today is Dr. Bhageshwari Deswal. And she is a PA Gold Medalist, LLB Gold Medalist, a university topper and recipient of University Merit Scholarship during her graduation and the prestigious National Merit Scholarship throughout her LLB LLM. She teaches criminal law at Law Center Faculty of Law, University of Delhi. During her LLM, she was nominated as a member of MD University Court for her academic brilliance. During her teaching experience of 12 years, she is credited with publication of more than a dozen articles and book reviews in legal law journals. She has prepared case materials and e-lessons for students of LLB, LLM and legal literacy course run by Delhi University. A life member of prestigious institutions such as Indian Society of International Law and the Institute of Constitutional and Parliamentary Studies. She is also the president of the All India Law Teachers Congress. She is closely associated with gender sensitization programs conducted by WBC, EU and NGO. So with that, I leave the floor to Advocate Anita Abraham. So sorry, there is a slight change. So Dr. Bhageshwari is going to start the program, so I leave the floor to her. Good morning, everyone.
In keeping with the tradition at HRL, we are starting Clause 89 again today. So now coming to the 2013 amendments, we all are aware about the Nirbhaya case, a case which by virtue of its sheer brutality, it had shaken the collective conscience of the country. And we saw a mass mobilization of people. There were people everywhere on the streets, holding protests, candle marches. What we all wanted was justice for the 23-year-old sprightly paramedic. This led the government to come up with the Criminal Laws Ordinance Act and then finally the Criminal Laws Amendment Act of 2015. Now, it is not that it was drafted just then. A Sexual Laws Amendment Bill was in the pipeline for long, and this Nirbhaya movement, it gave the required impetus. And finally, this Criminal Law Amendment Act, we got this on 2nd April 2013. Now, the important changes that were brought in our criminal laws, that is namely the Indian Penal Code, the CRPC and the Indian Evidence Act, were namely the introduction of newer forms of crimes. Crimes which were hitherto being handled only on the sidelines. We had provisions which were dealing with these crimes in a very basic manner, like on the fringes we were tackling these crimes, like we already had section 354, which was talking about molestation, and we had section 509, which was talking about eve-teasing. But we did not have a specific law to deal with sexual harassment. Although we had Vishakha guidelines to deal with protection of women against sexual harassment at workplace, but we did not have a specific law. After this amendment came into force, on 24th April, President gave his assent to the Protection of Women Against Sexual Harassment Act, and then it took them another 6-7 months to draft the rules, and finally this was notified in December 2013. But then in the meantime, in IPC, this Criminal Laws Amendment Act, by virtue of this Amendment Act, this was declared to be a crime. Also, now it is not only a civil offence, sexual harassment is not only a civil offence, it is also a crime. And another significant thing about this is that this provision, it also protects boys against sexual harassment. While the Sexual Harassment Act is a gender-specific act, in the sense that only women are protected, although the perpetrators under that act can be both men as well as women. But under this provision, 354A, which was introduced has been made punishable specifically. See now, disrobing is something which maybe an ordinary person would not have the guts to do that. But people, they derive strength from numbers. So when there's a large congregation of people and they are all encouraging that other person, they are aiding him, they are abetting him, they are instigating him to do certain crimes, a person who would not have the guts ordinarily to do such a thing he might just derive strength from the crowd that is against him to do such a thing. So now, even abetment of disrobing was made a punishable offense. Then there was another offense, that is voyeurism. Now, voyeur, it's basically a French term. Okay, voyeur, which means a peeping Tom. Okay, one who derives a sexual pleasure or gratification from looking at other people's naked bodies or when they observe them in some indulgence of private acts. So, voyeurism is a psychosexual disorder. In majority of the countries, it is dealt with as psychological disorders, which is not punishable, rather which requires treatment. But in our country, our lawmakers were very enthusiastic about this entire thing. So what they did, see, there's a point also, because we live in a civilized society, and the interests of some people, they cannot be allowed to outweigh the interests of majority of the people. But then providing a punishment of 5 years, which goes on to 7 years in case of repeat offenders, I think that's slightly misplaced. I think that's more of a punishment, whereas what we require is more of a treatment in case of voyeurism. Then another case of crime, another kind of crime that was recognized was stalking. See, we already had the Information Technology Act, which was dealing with voyeurism and which was also dealing with stalking in a way. But now, since IPC is the main act, we can say like IPC is the direct act that was drafted in 1860, and rest all laws have got it in later date. So stalking was also introduced in the IPC, but then in stalking again, it is something which our lawmakers have been very enthusiastic, because what they say that if somebody is following you, if somebody is pestering you, and somebody is trying to foster contact with you despite your repeat indication of a disinterest in that person, so that amounts to stalking, and which is punishable, fair enough. But then they've gone a step further, and what they say is that even if somebody is merely monitoring your activities online, that will amount to stalking. See, it can amount to stalking the moment you go on, whether it's on WhatsApp, whether it's on Facebook. So somebody starts sending you messages, hi, hello, I want to talk to you, so that will amount to stalking. But if somebody is just checking if you are online or not, so till the time you are not aware that this thing is happening, so it's not causing any kind of mental agony or trouble to you. So mere monitoring of online activities has also been made punishable under this law, and I think that is something which can be subjected to gross misuse, because people have got open profiles on social networking sites. So if you are making mere monitoring a punishable crime, then again, because what it prescribes is a minimum punishment of 3 years, which will go up to 5 years. So I think 3 years of just monitoring someone's online activities, although stalking is a great crime, but then we have to understand that what is the enormity of the crime and whether the punishment is disproportionate to the same or not. Then, a very important thing and a very important change that was brought about was by this amendment was introduction of a special provision relating to acid attacks. Earlier, we would deal with crimes relating to acid attacks under section 326, which is relating to previous hurt. But we did not have a specific provision to deal with acid attacks. Now the legislature has introduced two provisions, section 326A and 326B, which are dealing with the crime of acid attack, plus even attempts to throw acid have been dealt with very seriously, and they have been made specifically punishable. Now they've gone a step further, and under section 100, which is dealing with those cases wherein the right of private defense of a person extends to even voluntarily causing the death of the perpetrator, what they have done, that in cases of acid attacks, if you have a reasonable apprehension that you might be subjected to an acid attack, the law allows you to even cause the death of the other person. That would be a total exemption from criminal liability. So that is another important part related necessary that now we need only a penile and a vaginal penetration. Now even if the man uses his mouth or even his fingers or a stick or an object, so even digital rape has been recognized now. Okay, so now they have broadened the definition considerably. Still, the one thing is that it's now still gender specific crime in the sense that only a man can be held guilty of committing rape, but a man can employ another man, woman or even a transgender as an agent to commit rape. Then another important thing, another important change that was brought about was in cases of gang rape. Earlier, only a man could be held guilty. So even if a woman was actively participating in the crime, because the definition was so narrow, a woman could not be held guilty of gang rape. But now they have changed the definition, and under 376D, now if there's a group of people, in that group there are some men, there are some women, if they are acting as a group or in furtherance of common intention. Earlier what was mandatory was there had to be necessarily a common intention, so the courts had ruled that a woman, she can never have the intention to rape another woman. So a woman could not be held guilty of gang rape because she could not share the common intention with other men. But now what the law says that even if you are acting in a group or in furtherance of common intention, so now they've used not and but or. So even if you are a part of the group, out of which some people have committed rape and some have not committed rape, but if you are a part of the group which has committed rape, all of you would be equally liable. Okay. Then punishments were enhanced. Earlier also we had a minimum imprisonment of 7 years that was prescribed as the punishment in cases of rape, but then further there was a discretionary clause which said that in exceptional cases the judge, if he wants, he could award a punishment that was lesser than 7 years. Now that has been removed. Now there's a minimum imprisonment of 7 years in cases of rape, and in case of rape of minor girls, that minimum imprisonment is 10 years. Then there's another thing, that is even death penalty has been prescribed in case of brutal rapes. That is, if you must all be aware of the Aruna Shambal's case, which caused this woman to suffer for a period of 42 years in the vegetative state. So that was one of the reasons why we had to enact such a provision, that if a woman had been raped with such brutality so as to lead her so as to cause her to be in a vegetative state for the rest of her life, so that was something which was deserving of the extreme penalty of death. So in case of brutal rapes and in case of repeated rapes, that is 376E, we already had this provision of death penalty which was introduced. But now there have been further changes which have been introduced by the Criminal Laws Ordinance of 2018, which was introduced on 21st April. This ordinance was promulgated by the President on 21st April, although the ordinance is a temporary measure. But what they have done, they have increased the imprisonment. Now in case of rape of minor girls, if the girl is below 16 years of age, the punishment would be minimum of 20 years or life imprisonment. And in case of rape of a girl below 12 years of age, this punishment would be a minimum of 20 years or life imprisonment or even death. Okay. So now this ordinance which has been pushed through by a government, I think this is a very political measure because it is talking about death penalty, and I think we already had provisions for death penalty in case of repeated rapes and in case of brutal rapes. So this is something that they have done just to satisfy the public outrage. They are doing something. Because what they have done, earlier also by the Criminal Laws Amendment Act of 2013, there was this provision for fast track of trials. It was mandatory for the police to complete investigation in case of crimes against women within a period of 3 months. Now what they've done, that it should be not merely a fast track of trials, it should be conducted on a day-to-day basis, and the trial has to be necessarily concluded within a period of 2 months. This is what the recent ordinance says. They also say that the police has to complete of the victim compensation scheme. Section 357A and 357B, which says that the victim compensation that is to be given under this victim compensation scheme, this has to be in addition to the fine. See, ordinarily, fine is something which is civil in nature. Fine is something which is criminal in nature, in the sense that the amount of fine would go to the state. Okay? Fine was never to be given to the victim. But this is a positive step which was taken, and now the amount of fine, okay, there's no limit on the fine also, because if you look at IPC, it talks about fine like 10 rupees, 50 rupees, 100 rupees. But now there is no upper limit on the amount of fine which can be imposed upon the criminal or the accused person. And a part of that fine, in some cases, even the entire amount of fine, the court may direct that amount to be given to the victim, so as to help her in rehabilitation and all. See, this victim compensation scheme and all these are very important in cases of victims of acid attacks and rape, because what they need is a long period of treatment, and then their rehabilitation costs, reintegration into society costs. So all this costs a lot. So this fine measure and also this victim compensation scheme, which is saying that now payment of compensation is to be done to the victim, irrespective of whether the accused would be identified or not. Because compensation is something which the state has to do. The state has to give. Why? Because the state, it did not fulfill its responsibility of providing a safe and secure environment to the victim, due to which the victim was exposed to such a thing. Then before I complete this, there are two more important things that I need to highlight here. One is relating to FIR. Okay. Now, registration of first information report. It has been made absolutely mandatory. See, what happens ordinarily in our country, when you go and complain to the police वाले वहीं पर एक थाना बना ले. What the police says, कि आपके पास कोई सबूत है, आपके पास कोई गवाह है. But now what the law says is that if the information that you are giving to the police, if that discloses the commission of a cognizable offence, they have to compulsorily register the FIR. Investigation is something which will begin once the FIR has been registered. They have not been given the latitude or the discretion to conduct preliminary inquiries also, except in cases when we are talking about cases covered under 498A or cases related to corruption. Otherwise, registration of FIR has been made mandatory, and in cases of crimes against women, such an FIR is to be registered by a female officer. If there is no female police officer available in the police station, there could be any other female officer, but the registration has to be done necessarily by the female officer, and immediately the woman is to be sent for medical examination. See, earlier, police officers, they would shrug off their responsibility and they would say that getting the medical examination done is not our responsibility, and the poor victim would herself be running from pillar to post to get herself medically examined within a period of 24 hours, because we all know that this period of 24 hours is very crucial in cases of sexual assault cases. But now this is the responsibility which has been put on the police officer. He has to tell the woman and he has to make arrangements for her medical examination at the earliest. And in case the police officer refuses to register an FIR, now what the law says that he can be punished with imprisonment of a minimum of 6 months and a maximum of 2 years if he refuses to register an FIR. Second thing is, now there's also a responsibility on the medical person. See, earlier what the doctors would say that no, it's a medical legal case, but now what the law says is that no, if there is such a case, whether it's a case of rape, whether it's a case of acid attack, you have to immediately tend to it. You have to provide medical aid to the victim immediately, free of cost, and there's another added responsibility on them, and that is to inform the police at the earliest. In case the doctors, they neglect in the performance of any of these 3 duties, they can be even held liable and punishable with an imprisonment of up to 1 year. And this is a responsibility which has been put on all hospitals, whether it's a public hospital, private hospital, government hospital, charitable hospital, hospital of any kind. Now they are all covered under this law. Okay, now before I complete, I would also like to touch upon POCSO, which is Protection of Children Against Sexual Offences Act. We got this law in the year 2012. Now So here I was saying that now there are some shortcomings about it. The first thing is, it criminalizes even consensual sexuality. See, the age of consent has been fixed at 18 years in laws. Now, for children below 18 years of age, this activity is more about exploration rather than exploitation. Okay, there are exceptions in all cases, but in majority of the cases. So what this law does is, if there are two minors who are engaged in a consensual sexual activity, so does that mean that we need to criminalize such behavior? See, it's a very funny issue that would such kids be treated as juveniles in conflict with the law? Because that is what the recent ordinance says. They also say that the police has to complete its investigation within a period of 2 months. So what happens? In the majority of the cases, the investigations, they are not conducted properly. And see what is happening in Kathua and all these places. There's we all know these are cases of forced investigations. Then further, what this ordinance says is that all cases of appeal, in such cases, they have to be necessarily wound up within a period of 6 months. So these are some of the changes that have been brought about by this ordinance. And also what they are saying is that anticipatory bail. This provision will not be applicable to cases of rape of minors. Minor below 16 years and a minor below 12 years. Then there were some changes that were introduced in the CRPC also, like introduction of the victim compensation scheme. Section 357A and 357B, which says that the victim compensation that is to be given under this victim compensation scheme, this has to be in addition to the fine. See, ordinarily, fine is something which is civil in nature. Fine is for something which is criminal in nature, in the sense that the amount of fine would go to the state. Fine was never to be given to the victim. But this is a positive step which was taken, and now the amount of fine, okay, there's no limit on the fine also, because if you look at IPC, it talks about fine like 10 rupees, 50 rupees, 100 rupees. But now there is no upper limit on the amount of fine which can be imposed upon the criminal or the accused person. And a part of that fine, in some cases, even the entire amount of fine, the court may direct that amount to be given to the victim, so as to help her in rehabilitation and all. See, this victim compensation scheme and all these are very important in cases of victims of accident acts and rape, because what they need is a long period of treatment, and then their rehabilitation costs, reintegration into society costs. So all this costs a lot. So this fine measure and also this victim compensation scheme, which is saying that now payment of compensation is to be done to the victim, irrespective of whether the accused would be identified or not. Because compensation is something which the state has to do. The state has to give. Why? Because the state, it could not fulfill its responsibility of providing a safe and secure environment to the victim, due to which the victim was exposed to such harm. Then before I complete this, there are two more important things that I need to highlight here. One is relating to FIR. Now, registration of first information report, it has been made absolutely mandatory. See what happens ordinarily in our country. When you go and complain to the police वाले वहीं पर एक थाना बुक बनाए. What the police says, कि आपके पास कोई सबूत है, आपके पास कोई गवाह है. But now what the law says is that if the information that you are giving to the police, if that discloses the commission of a cognizable offence, they have to compulsorily register the FIR. Investigation is something which will begin once the FIR has been registered. They have not been given the latitude or the discretion to conduct preliminary inquiries also, except in cases when we are talking about cases covered under 498A or cases related to corruption. Otherwise, registration of FIR has been made mandatory, and in cases of crimes against women, such an FIR is to be registered by a female officer. If there is no female police officer available in the police station, there could be any other female officer, but the registration has to be done necessarily by the female officer, and immediately the woman is to be sent for medical examination. See, earlier, police officers, they would shrug off their responsibility and they would say that getting the medical examination done is not our responsibility, and the poor victim could herself be running from pillar to post to get herself medically examined within a period of 24 hours, because we all know that this period of 24 hours, it is of sexual assault cases. But now this is the responsibility which has been put on the police officer. He has to tell the woman and he has to make arrangements for her medical examination at the earliest. And in case the police officer refuses to register an FIR, now what the law says that he can be punished with imprisonment of a minimum of 6 months and a maximum of 2 years if he refuses to register an FIR. Second thing is, now there's also a responsibility on the medical person. See, earlier what the doctors would say that no, it's a medical legal case, but now what the law says is that no, if there is such a case, whether it's a case of rape, whether it's a case of acid attack, you have to immediately tend to it. You have to provide medical aid to the victim immediately, free of cost, and there's another added responsibility on them, and that is to inform the police at the earliest. In case the doctors they neglect in the performance of any of these 3 duties, they can be even held liable and punishable with an imprisonment of up to 1 year. And this is a responsibility which has been put on all hospitals, whether it's a public hospital, private hospital, government hospital, charitable hospital, hospital of any kind. Now they are all covered under this law. Okay, now before I complete, I would also like to touch upon POCSO, which is Protection of Children Against Sexual Offences Act. We got this law in the year 2012. Now this is a gender-neutral law which is talking about protection of both boys as well as girls. Here, the main aspect about this law is this talks about sexual assault. It doesn't use the term rape, because the term rape is a gender-specific term. Rape can be committed only against a woman. Now sexual assault is a gender-neutral term which can be committed against both a man as well as a woman. So the categories of sexual assault that POCSO deals with is sexual assault, penetrative sexual assault, aggravated sexual assault, and aggravated penetrative sexual assault. So these are the 4 categories of sexual assault that POCSO is dealing with. And then it's the punishment that it gives is 1 year. So here I was saying that now there are some shortcomings about POCSO. The first thing is it criminalizes even consensual sexuality. See, the age of consent has been fixed at 18 years in POCSO. Now, for children below 18 years of age, this activity is more about exploration rather than exploitation. Okay, there are exceptions in all cases, but in majority of the cases. So what this law does is, if there are 2 minors who are engaged in a consensual sexual activity, so does that mean that we need to criminalize such behavior? See, it's a very funny issue that would such kids be treated as juveniles in conflict with the law? Because that is exactly what this law does. Now, punishment in cases of these, in POCSO also, which was a gender-neutral act, now what this Criminal Law Ordinance 2018 has done, it penalizes sexual assault on minor girls below the age of 16 years and 12 years with an enhanced punishment. But the same enhancement of punishment has not been applied in case of sexual assault of minor boys. Now we all know that male sexual abuse is a harsh reality of our society, and maybe we can no longer sweep it under the carpet, but still this is what our lawmakers seem to be in a mood to do, because there was a public outburst. So to satisfy them, they immediately came up with this, because the victims in the cases that were highlighted at that time were girls. So what they've done is they've made the laws stricter. Okay? And then to conclude with what I would like to say is that, see, we have made a provision for death penalty of minors. See, the provision for death penalty we've been having for any number of years in our laws. In 1860, the IPC was started, and we've got death penalty for murders, we've got death penalty for other crimes, but have murders stopped? So, can we say conclusively that death penalty, award of death penalty could be a deterrent to commission of crimes against women, or it would be a deterrent to rapes or brutal rapes being committed against women? I have my serious doubts. Rest I leave open to the floor. Thank you.
Thank you very much, ma'am. बहुत विस्तार में मैम ने बताया हमको इस नए अमेंडमेंट के बारे में. मैं इसको थोड़ी देर में बस हिंदी में बता रहा हूँ आपको. पहला तो ये कि जब निर्भया केस के बाद हमारे कानून में बहुत अमेंडमेंट आए हैं क्रिमिनल लॉ में। ऐसा नहीं है कि उसी वक्त आया है, बहुत कई वर्षों से महिला संगठनों द्वारा प्रयास किया जा रहा था और एक पाइपलाइन में ऑलरेडी था। और इस बिल के बाद फिर वो फाइनल एक वजह मिली सरकार को कि इस बिल को लागू किया जाए। और इसमें मुख्यतः जो चेंजेस आए हैं वो ये है कि इंडियन पीनल कोड जो भारतीय दंड संहिता है उसमें पहले 2 धाराएं थी डेरे के अलावा, एक 354 और 509 था। उसके अलावा जो अलग अलग प्रकार के अपराध होते हैं महिलाओं के खिलाफ, उसके लिए हमारे इंडियन पीनल कोड में कोई कानून नहीं था। तो इस अमेंडमेंट में जो मेन परिवर्तन हुआ वो ये है कि सेक्सुअल हैरेसमेंट जो बोलते हैं हम जिसको, वो एक ऑफेंस नहीं था, वो एक सिविल लॉ में आपके पास नहीं था। तो इस नए अमेंडमेंट में सेक्सुअल हैरेसमेंट को एक क्राइम बनाया गया और बेवास्ता करना, किसी महिला के कपड़े उतारना को भी एक स्पेसिफिक ऑफेंस बनाया गया। और इसी तरह से ये कपड़े उतारने का में किसी व्यक्ति की जो सहयोग करता है उसको भी अपराध की श्रेणी में डाला गया। और फिर एक वायरिज्म कहते हैं जो मतलब छुपी किसी महिला को देखना, ऐसी अवस्था में जब वो ना चाहती हो कि कोई उसे देखे, जो कि पिक टॉन जिसको कहते हैं। और फिर एक स्टॉकिंग या पीछा करना किसी महिला का, उसको एक अपराध की श्रेणी में भी रखा गया। तो उसमें मैम का कहना है कि एक चीज़ जो उसमें डाला गया है कि जो ऑनलाइन मॉनिटरिंग है उसको भी अपराध की श्रेणी में डाला गया है। तो मैम का कहना है कि ये शायद डिसप्रपोर्शनेट और थोड़ा प्रॉब्लमैटिक है। और इसके बाद एक जो बहुत बड़ा जो बदलाव आया वो एसिड अटैक विक्टिम्स के लिए आया कि इस अमेंडमेंट्स के पहले क्या होता था कि सेक्शन 326 में ग्रीवियस हर्ट के तहत आप FIR रजिस्टर करते थे, लेकिन अब इसका एक स्पेसिफिक अलग अपराध बनाया गया है ग्रीवियस हर्ट एसिड अटैक्स का। और उसके अलावा एक जो अमेंडमेंट किया गया कि अगर कोई आप पे एसिड अटैक करता है तो उसमें जो सेल्फ डिफेंस के जो एक्सेप्शन है IPC में, उसमें एसिड अटैक को डाला गया है। तो मतलब अगर कोई आप पे एसिड अटैक करता है तो आप सेल्फ डिफेंस में उसकी हत्या कर सकते हैं, ऐसा अमेंडमेंट में आया है। और जो बहुत महत्वपूर्ण चीज़ हुई वो जो रेप की परिभाषा है उसका स्कोप बढ़ाया गया है। सुप्रीम कोर्ट में ये मुद्दा पहले आया था एक केस में, साक्षी और जमीन दुनिया में आया हुआ था। तो सुप्रीम कोर्ट ने रेप की डेफिनेशन को बढ़ाने से मना कर दिया और ये फाइनली नए अमेंडमेंट में हुआ। और इसमें सिर्फ जो यौन द्वारा जो हिंसा होती है सिर्फ उसको न रखा गया है, उसमें कोई वस्तु या कोई चीज़ से भी जो पेनिट्रेशन होता है उसको भी रेप की श्रेणी में, या किसी शरीर के किसी अंग से होता है उसको भी क्राइम के श्रेणी में रखा गया। और एक और जो बदलाव आया है कि महिलाओं का रोल क्या हो सकता है रेप, तो उसमें रेप में अमेंडमेंट में एक स्पेसिफिक डाला गया और गैंग रेप में एक महिला भी दोषी और अपराधी ठहराई जा सकती है। ये भी एक महत्वपूर्ण बदलाव आया है। और जो सजा है उसमें जो सजा है उसमें एक प्रावधान था कि रेप में कम से कम 7 साल की सजा थी और उसमें डिस्क्रेशन है कि जज 7 साल से कम भी सजा दे सकता है। तो ये जो डिस्क्रेशन है कि जब कोई जज रेप के केस में 7 साल से कम की सजा दे सकता है, उस डिस्क्रेशन को हटा दिया गया है। और जो माइनर लड़कियों के लिए जो अमेंडमेंट था उस समय 2013 में, उसमें था कि मिनिमम सजा जो है उसको 10 साल कर दिया गया था। और उसके बाद अभी जो हम देख रहे हैं जो नया ऑर्डिनेंस आया है कठुआ इंसिडेंट के बाद जो अभी ऑर्डिनेंस है कोई भी नहीं आया है, उसमें भी कुछ उसमें बहुत मेजर चेंजेस हुए हैं। उसमें ये है कि अगर कोई माइनर 16 साल से कम लड़की से रेप होता है तो उसको कम से कम 20 साल की सजा से आजीवन कारावास तक की सजा है। और 12 साल से कम की बच्ची के साथ रेप होता है तो नए ऑर्डिनेंस में 20 साल की सजा या आजीवन कारावास या फिर डेथ पेनल्टी की सजा दी गई है। और इसमें जो नया जो ऑर्डिनेंस है उसमें डे टू डे ट्रायल की बात करी गई है और 2 महीने में ये ट्रायल खत्म करने की बात करी गई है। और पर जैसा कि आप देख रहे हैं कि कठुआ में कोई स्थिति नहीं हो पा रहा है और किस तरह से इन्वेस्टिगेशन चल रहा है नॉलेज में। और इसमें एक और अपील को लेकर भी प्रावधान किया गया है कि मान लीजिए वो कन्विक्शन के अगेंस्ट में या अपील होता है कोई, तो उसको भी 6 महीने में डिसाइड कर देता है। और एक और चीज़ जो इस नए ऑर्डिनेंस में है कि एंटीसिपेटरी बेल का जो प्रावधान है वो इन सब जो अमेंडमेंट है वो रेप की श्रेणी में वो एप्लीकेबल नहीं होगा एंटीसिपेटरी बेल। और एक और चीज़ जो कही गई है कि कॉम्पनसेशन को लेकर भी कुछ अमेंडमेंट हुआ है, उसमें भी फाइन पर कोई अपर लिमिट फिक्स नहीं किया गया है। और ये भी कहा गया है कि जो कॉम्पनसेशन में कॉम्पनसेशन मिलता है वो मतलब फाइन के अलावा भी नहीं दिया जाएगा। और एक और जो बहुत महत्वपूर्ण चीज़ ये है कि कई बार हम देखते हैं कि अक्यूज जो है अक्यूज की पहचान नहीं हो पाती है किसी रेप केस में, तो इस अमेंडमेंट में कहा गया कि अगर अभी उसकी पहचान ना भी हो तो भी उसको कॉम्पनसेशन दिया जा सकता है। और FIR को मैंडेटरी किया गया है, और जो FIR है वो एक महिला अधिकारी द्वारा किया जाएगा। और अगर FIR नहीं करता है कोई पुलिस अधिकारी तो उसको 6 महीने से 2 साल की सजा होती है। और जो दूसरी महत्वपूर्ण चीज़ है वो मेडिकल ट्रीटमेंट को लेकर है कि सारे अस्पताल, प्राइवेट, सरकारी, NGO अस्पताल, सबको कोई भी ऐसे अटैक कोई भी महिला पीड़िता को तुरंत इलाज करना है, और उनको तुरंत फ्री इलाज करना है, निःशुल्क इलाज करना है, और उनको फिर पुलिस को तुरंत खबर देनी है। और अगर ऐसा कोई अस्पताल का डॉक्टर नहीं करता है तो उसको कम 1 साल तक की सजा हो सकती है। और फिर मैंने पॉक्सो के बारे में कहा है, जैसे ज़्यादा मैं बताऊँगी पॉक्सो में अलग अलग जो सेक्सुअल एक्टिविटीज़ को क्रिमिनलाइज किया गया है। तो उसमें मैं आपको कहना है कि जो एक बहुत जो प्रश्न उठाने वाला मुद्दा है कि जो 18 साल के कम के जो बच्चे होते हैं जो सेक्सुअल एक्टिविटी में जो टच करते हैं, आप उनको अपराध बनाएंगे, आप उनको मतलब कॉन्फ्लिक्ट मतलब उन बच्चों को देखेंगे कि वो कॉन्फ्लिक्ट लॉ में है, तो फिर भी एक बहुत ही क्वेश्चनेबल पोजिशन में लेंगे। थैंक यू। अच्छा, नाउ वी मूव ऑन टू द नेक्स्ट स्पीकर।
Vageshwari has the laws of in the law, that I'll discuss some of the cases that have arisen since then. So since 2013, as we all know, the 2013 Criminal Law Amendment Act was enacted subsequent to recommendations made by the Burma Committee. Now, most of the recommendations made by the Burma Committee were taken and the law was enacted brought into force. However, there were at least 2 things which, to me, are personally which were recommended by the Burma Committee report, but which were not taken into consideration. One of them was the gender neutrality recommendation made by the Burma Committee, which obviously was touched on. So there was a recommendation to say that sexual assault against homosexuals, transgender and transsexual people should also be included. But for some reason it is left out. Now we have Socio-Legal on many platforms is talking about maybe something is not gender neutral, but we have to make it should also say also, and that's a bit confused because also already gender neutral with regard to survival. Second recommendation, or rather the recommendation that they did not take, is that the Burma Committee never introduced death penalty into never proposed for death penalty for any of these offences. However, in the 2013 amendment, we have at least 2 sections. One is 376 capital A and capital D, which are vegetative, to put a woman in a vegetative state, as well as gang rapes, which have an option for death penalty. And of course, the ordinance will come to later. So these are, I think, for me, 2 very kind of lacunae in the law. Post that, to my mind, if I look back at the kind of cases that have come up, one thing that strikes me, so I want to just break up in this presentation the different kinds of cases that have come up under P76. One of them are in the category of heinous crimes, such as what we see that immediately after 2012, like 2013 was the amendment. In 2014, for example, we had the case of the Uber driver who had raped his girl. Thereafter, we had in Bihar had the case of the Motihari gang rape. And then, of course, now we have Kathua, we have Unnao. So these are all gang rapes, right? Apart from the Uber, amongst the ones I mentioned. So we have this kind of, according to me, a situation where cases like heinous crimes, especially gang rapes, have become quite, well, I won't say it's the word common, but it is prevalent. And this is despite having laws of this nature. So then the question we ask ourselves is, what are we doing wrong, right? Because we have the laws, and according to me, actually, in Delhi, speaking specifically of Delhi, because I know in other states that it is not necessarily in terms of the things are not necessarily very efficient. But in Delhi, if you have a case of rape, and if blood is purified. So therefore we cannot even compare. And if you don't have an efficient, so anyways, there are several cases where even if it's 1 out of 3, so there will be 2 which are done quite efficiently. You get the evidence is sent to FSL on time, collected on time, then the court gets the report. But there will be that 1 out of 3 where there will be some problem, either in the report, either in the sending of the evidence, and another example of, like say, how investigative processes can be sharper is often as soon as the crime is committed and you know the scene of the crime. You see, we expect the police to be on the spot and do as much as they can and in as efficient a way. And when I say efficient, I mean in terms of the site of the crime, that you don't tamper with evidence, you don't even tamper with the scene of the site. But once again, we have a system where the approach is quite casual. You see, you don't immediately get all detailed records, as many CCTV cameras, CCTV cameras in many public spaces to see the movement of an accused from A to B, or the movement of the victim, or anything that will sort of fructify and solidify your case. That has to be done quickly. It has to be done knowing that if I don't do this, these are the consequences, where the victim or even the accused actually can do something. So this, I think, ensures towards a fair trial for all parties. So coming back to, this I would say is at the stage of investigation, and this is especially in cases of this nature where today the only way, because the other thing I also want to bring up is the whole problem of immunity. We have to ask ourselves what went wrong in either Fatwa, this is 2018, or in the case of the Unnao case. I would say the one thing is impunity, because the Allahabad High Court in the Unnao case had to pull up. This is post the woman's father dying, pregnant to live herself in front of the chief minister's house. Despite all that, after that, actually the case was transferred to CCRI. And the CCRI, after registration of the FIR, had still not arrested the main accused in that case. And it was after the Allahabad High Court pulled up everybody from the courts to the state to the advocate general, the office of the highest officer of the court in the state, and said, why have you not arrested him? Because only after that they took steps. So this is again, I guess we will discuss it. We have problems. Now, what is the solution? To me, this is, and of course, not to mention Fatwa, the most inclusive and horrendous kind of thing should not take place, right? You read an FIR like, who are these people? Why are they allowed to do this and even get away? So what we don't need is the death penalty, having, enhancing punishment and thinking that it's going to deter abuse, which of course obviously deter reactions by the establishment. But what we need is at the stage of investigation, at the stage of even trial, you need like all the forces to work much more efficiently and bring the person to book. See, because this conviction acquittal, you often find people telling you, to NCRI data, they say that, and this gives an excuse for for misuse of the law, false reportage. Because they say that, there are so many FIRs, like for example, dowry debt, right? You can find people relying upon the reading down of the dowry debt portion of 498A by saying that so many complaints are made, but the convictions and the acquittal acquit convictions, for example, will be this, will be a smaller percentage. So which come to the High Court. And many of these cases are 376 cases, but in fact they are what we commonly refer to as promise to marry cases. Now, these are interesting cases because effectively what has happened is a woman has gotten into a relationship with a man, and they get into a relationship. Sometimes it is not consensual, but it goes on to be a consensual relationship. And maybe 1 year, 2 years down the line, and throughout he's promising to marry her. Then at some stage, either it could be they have a sexual encounter once, where he says, look, I'll marry you, and we will have a relationship. And after that, he says, I'm not interested. Or it could be a full-fledged relationship for a period of 1 year or 2 years, where after that, again, he says, I'm not interested in that. Or it could be a third or fourth situation, where she is introduced to parents, they've done yoga ceremonies, and finally the boy backs up. So what happens is that the woman comes to court and says, I'm fine for it. Sometimes it could well be, and see, these are the things which I feel we never really, if I may say so, we never really know, because there are some cases where she will say that it began as a non-consensual encounter because she was interested in it. This is all in the premise of some kind of an intimacy or an interest between two parties. And of course he forces her to sex the first time, and then it becomes consensual. There may be instances where right from the beginning, the sexual relationship is entirely consensual, right? Now, whatever it is, of course, there is the important promise to marry case, because there is a legal premise there, based on which it is being raised, which is section 19 of the IPC, which says that consent is not relevant if it's under a misconception of fact. So the legal argument is that she comes to court saying that he promised to marry me, and that is the reason why I consented, and which is fair enough. Right? So in my mind, yesterday we were talking a lot about agency, and Kamala has raised this question of agency when it came to child marriage. And where I agree is with the fact that if we are going to allow for an institution to, so if the woman comes to bail, for example, and then she comes to the High Court saying, and because he often applies for bail, so she comes to oppose, and she will say that if he agrees to marry me, I won't oppose this bail petition. You understand? And so there are many cases actually the man agrees, he comes out on bail, and they do get married. Now, if you talk now, to my mind, this was actually something, a situation I had to grapple with, because I was of the notion of agency that, if she has a certain, that a woman has, you have a control and you have your body is your own, and you cannot lose that. I don't know, sorry, I don't mean to say that she cannot lose her body, but you cannot say, you have to have gotten into the encounter with complete autonomy. And therefore, you cannot come and say, okay, now the only reason I do this is to get married, and if he's not get married, then, I'm in jail, cannot become partner in hotel. It's what I get. Then, I had the opportunity in many instances to speak to the victim or complainant. And what she says is effectively what we discussed yesterday, which was that she says, I have suffered so much shame, so much humiliation, and the truth of the matter is that I never would have consented if I knew he was not going to marry me, because my entire family, it's the whole thing of shame and honor, but the honor of the whole family is dependent upon it, which is why actually even parents agree. That's often people won't say, okay, I have met this guy and I want to marry him. Parents do agree, but when the guy backs out, the whole family is humiliated. So this maybe it is a result of the patriarchal kind of the structure that we are in. And the question that we have to ask is that should the court, through judgment law, should the court intervene and continue to uphold this form of patriarchal kind of, because then we just go on and on. There is no ideal situation, right? And I think, I actually think this is a situation of fair amount of tension, I think, and we cannot sort it out. I'm not saying at all that it should be, it can be a railable offense, but apart from that, I cannot say that it should not be rape, right? Because she is coming and she's saying, I did not consent, and there is no reason why it should not fall within this provision. any other form of sexual exploitation, and therefore we make a new law towards that end. The other, now actually closely related to this, is also what is statutory rape, which is what Manish was talking about. Our boys and girls who are less than 18 years, often they elope with each other, and the families express the habeas corpus petitions to court, and when the court sits to do a mediation of the parties to ask whether the girl wants to go back to her family or stay with her husband, you will find a unique situation having to use its inherent powers to quash the matter. Whether or not the girl finally can come to a settlement, and she may say, look, I actually have not happened to this guy, I want to go back there. In those kind of cases, there have been many cases where she says, I'm very happy with him, I'm married him, and I want to live with him. So in those kind of cases, the court actually, as I said, uses its inherent powers to get the matter disposed, because you cannot, because they do recognize that here are two people who are, or even if just the girl is 17 and a half or 18, and the boy is 21, you cannot send him like the boy to jail. You see, so that again, as I said, is a situation, an ongoing kind of situation where we are kind of trying, where the courts, the lawyers are trying, or should try as much as we can to come to a more uniform kind of a conclusion, which is consistent with principles of quality and agency. And just one more thing is that yes, we're talking about agency, and for some reason, to my mind also, I think one of the things that will help would be education or employment and economic empowerment for sure. But what I found interesting actually is that there are many cases, if you have, like say, 75% percentage of people who come, like if you look at social backgrounds, it's not necessary that everybody is from a background where they're not educated or from poor families. You see, because there are many cases where either so this thing of being an empowered person, it could be I've seen young girls who actually completely have never gone to school and who are like 18 or 19, but who know their mind and who understand that concept of choice, where they say, look, I am willing to go through the repercussions, I want to be with this guy. Whereas I have also seen people who are in their, even much older, late 30s, 40s, early late 20s, who have filed cases, highly educated, could be from any kind of background, academic or academic, and who come and they say that, and who file promise to marry cases, saying that this guy promised to marry and I want to marry, and I don't pay anything, go to jail, but as long as he agrees to marry. You see, so it's very interesting. I think it's something we need to continue working on, because clearly we have different, we have like, even in terms of our release from that patriarchal mindset, we have people who are at different stages. And so apart from that, well, there is one more category which I just want to talk about. One is, this is the category of cases, I think similar to now, where the woman had approached the main accused for a job, and then he basically exploits her, promises which is really rape, in my mind. He exploits her, and then, of course, there's something about a job. And the person who, so it's a certain form of trafficking. The person who has introduced her to him continues to introduce her to other people. And that, again, now sometimes the courts can also, if it's not very clear, or, so that's one kind of situation. There is also a situation where, for example, a woman may be a sex worker, and she has faced some kind of assault in the process. You see, now in order to overrun that, because obviously you cannot go to the police station and say, I'm a sex worker, I have been assaulted. Now we may, again, as I said, we have the law on the books, but that's irrelevant, because we're going to the police station and saying that the police are going to say, the law is not going to believe you, or the other officers, whether it's lawyers, it's going to be a very difficult case. So what happens is that whole story is not put in the FIR. And what comes up is that, okay, somebody was roaming in the night, or there was a call and she went to meet her friend at 12 o'clock in the night. And thereafter she was late, because the first question the court will tell you is why does she move out at 12 o'clock in the night by herself? You understand? So what I mean is, what really happens and what is narrated in the FIR can sometimes be quite different, because the agencies feel that
बहुत जल्दी से मैम ने अलग अलग श्रेणी के केसेस के बारे में बताया। एक होते हैं बहुत गंभीर प्रकार के और जो बहुत ही वायलेंट प्रकार के जो रेप होते हैं, उसमें जैसे कि कठुआ नाव की घटनाओं के बारे में बताया। तो उसमें मैम का कहना है कि कानून तो बदल गया है, बहुत सारे कानून में बदलाव आ गए हैं, पर 2-3 चीज़ें जहाँ बदलाव हमें नहीं दिखती है, वो जिस तरह से जांच होता है रेप के केस में, जिस तरह से पुलिस के द्वारा जांच की जाती है, उसमें बदलाव की बहुत संभावना है। उसमें 2-3 प्रकार की चीज़ें हम जो हम देखते हैं कि जो पुलिस जो है वो अपना काम अच्छी तरीके से नहीं करती है, चाहे वो एविडेंस जो साक्ष्य है, साक्ष्य को किस तरह से रखना है, किस तरह से साक्ष्य को इकट्ठा करना है। और दूसरा जो होता है जो मेडिकल एविडेंस के बारे में हम बात करते हैं, जो फॉरेंसिक लेबोरेटरी में जाता है, उसमें कभी कभी बहुत बार जैसे मैं कह रहा है कि 3 में से एक केस ऐसा मिलेगा ही आपको जिसमें या तो फॉरेंसिक जांच सही से नहीं हुआ हो, या फिर उसमें कहा गया हो कि साक्ष्य इकट्ठा करने में कुछ गलती रही हो या ऐसा। और फिर हम एक जो देखते हैं कि एक जो बहुत स्पष्ट रूप से जो दिखाई देता है केसेस में, वो ये होता है कि कानून का भय नहीं है लोगों में। जैसे उन्नाव में हुआ कि सारा कानून तो था आपके पास, लेकिन फिर भी उसका अरेस्ट नहीं हुआ जब तक हाईकोर्ट ने इंटरव्यू नहीं किया। उसके बाद अभी डेथ भी होगी और हाईकोर्ट के इंटरवेंशन के बाद ही उसका अरेस्ट हुआ। और फिर जब हम कठुआ का केस देखते हैं तो हमें जो चीज़ समझ में आती है कि जो कि डेथ पेनल्टी लाने से कुछ होगा नहीं, जो वाकई में जो बदलाव की जरूरत है वो जांच के स्तर पर जरूरत है, और जिस प्रकार से हम अपना ट्राई करते हैं उसमें जरूरत है। और हम ये जो हीनेस क्राइम्स में हम एक और चीज़ जो देख रहे हैं वो ये है कि जो अक्विटेड होता है वो इस थ्योरी पे बेस्ड होता है कि महिला जो है कहीं ना कहीं झूठ बोल रही है। ऐसे जजमेंट्स भी हम कोर्ट से देखते हैं कि जिसमें कोर्ट कहती है कि महिला झूठ बोल रही है, इसलिए अक्विटेड किया जाता है। और ये चीज़ हम उन्नाव और कठुआ दोनों में भी हम ये देखते हैं कि पब्लिकली भी ये बात फैल जाती है। जैसे उन्नाव और कठुआ में दोनों जगह जो अक्यूज के लोग हैं उन्होंने लाइट डिटेक्टर टेस्ट की मांग की थी, जो पीड़िता है उसका लाइट डिटेक्टर टेस्ट किया जाए। ये तो एक हीनस प्रकार के रेप है। और दूसरा जो एक बहुत ज़्यादा संख्या में जो केसेस आते हैं कोर्ट में, वो होते हैं ये जो शादी का वादा करके शादी ना करने वाले रेप के केसेस होते हैं। और उसमें अलग अलग प्रकार के केस होते हैं। उसमें पहले सहमति से रिश्ता होता है, फिर कभी वो शादी से इनकार कर देता है, या कभी असहमति से रिश्ता होता है। और तो उसमें मैं कहना है कि इसमें शायद कानून में कुछ स्पष्टता नहीं है, और लोग जो चाहते हैं उसमें कई बार कुछ स्पष्टता नहीं रहती। तो ये हो सकता है कि इसको एक वेरिएबल अपराध या ऐसा कुछ कर सकते हैं, ऐसा होता है। फिर जो तीसरी प्रकार की श्रेणी होती है स्टैट्यूटरी रेप हम कहते हैं, मैंने कहा कि जो 18 साल के कम के जो बच्चे के साथ जो कंसेंसुअल एक्टिविटी होता है, तो उसमें क्या होता है। तो मैंने कहा कि इसमें भी जो प्रॉमिस टू मैरी वाला जो केस है उसमें हम अलग अलग प्रकार की महिलाओं को देखते हैं। कभी कभी हम लड़कियों को देखते हैं जो कम उम्र की होती हैं, 16-17 साल की, और वो बहुत स्पष्ट होते हैं कि मुझे इस लड़के के साथ रहना है, मुझे इससे शादी करनी है, या जो भी मुझे इसके साथ संबंध बनाना है। फिर कभी कभी हम ऐसी महिलाओं को देखते हैं जो 30-32 उम्र की भी हों, पढ़ी लिखी महिलाएं हों, पर वो ऐसा कहती हैं कि उसने मुझसे शादी का वादा किया था तो मैं उसको जेल भेज के ही रहूँगी। तो इस प्रकार की अलग अलग प्रकार की महिलाएं आपको देखने को मिलती हैं। और एक चीज चौथा जो नाम का जो कहा है पावर की पोजीशन में जो कोई व्यक्ति जो अपने पावर की पोजीशन में रह के अपने पावर का मिसयूज करके, जैसे नौकरी का वादा करके ऐसा रेप की पालन करता है। तो अब हम डिस्कशन के लिए खोलते हैं। तो इनके पास भी कोई सवाल हो अपना हाथ उठा के सवाल हो।
Last year there was a report by Headquarters Forum I read about it, and there's some organizations that visited these centers. So I know about Jaipur, it's called a Prajna, it's a Jaipur hospital, and it's not functioning like the way it's supposed to. And even like in Delhi, I think it's a subveteran hospital. So about 3,000 crores were given for the Vaz Spiritual Crisis Center under Hyderabad. But what are your thoughts on it? Like, is it going to be good, or should we maybe file a BIR to know where the money is going? Like, what has happened to the 3,000 crores? And because we don't know much about it. I think it was set up in 2013, the Vaz Spiritual Crisis Center.
Okay, so the thing about the sexual intercourse that's considered rape if the promise of marriage is not fulfilled. I feel that our law has a certain kind of premise that the violation, the experience of sexual violation that a woman goes through, or emotional violation, needs to be tangible. So in cases where there is violation and it is intangible, maybe in the case of, let's say, promise to marry, or a general consensual sex where you might be violated by the end of it even if you consent, is there any provision, and if there are complaints like this, how does the court react to it? Is intangible experiences of violation also taken into account, or is it completely dismissed?
लेडी को सेक्सुअल हैरेसमेंट करने के बाद अगर वो एक दिन ऐसा है कि वो लेडी घर से निकल के थाना में गई है, वो लेडी थाना में गई है, फिर थाना में उसका एफआईआर दर्ज नहीं हुआ है, उसमें हम लोग क्या कर सकते हैं?
मेरा सवाल है कि जब वर्मा कंपनी को बहुत सारे रिकमेंडेशन आए हैं, तो LGBTQI से भी रिकमेंडेशन गए थे, ऐसा गए थे कि मतलब रेप की कवर कॉन्फ्लिक्ट कवरलेस, तो हमने ये भी डिफाइन किया है कि मतलब परपेट्रेटर कौन है और विक्टिम कौन है, इर्रेस्पेक्टिव ऑफ जेंडर स्टेटस। तो न्यूट्रलिटी के लिए हम नहीं पूछ रहे, क्योंकि न्यूट्रलिटी में ऑल्सो इफेक्टिव है, तो ये चीज को मतलब क्यों खारिज किया गया है, कि क्यों नहीं कंसिडर किया गया है, फिर से मतलब रेप भी परपेट्रेटर क्यों बना गया, एक सवाल। दूसरा सवाल है पॉक्सो के तहत थोड़े जिम्मेदारियां CWC जेल लेवल कंपनीज को सौंपा गया है, उसके तहत जब मतलब इंटरसेक्स या ट्रांसजेंडर या जेंडर नॉन कन्फर्मिंग चाइल्ड के ऊपर जो भी अत्याचार होता है, कई बार उनको घर में से पेरेंट्स को ताला देते हैं कि मतलब बहुत सारा ट्रांसजेंडर, इसमें इंडिजिनियस चिल्ड्रन और स्ट्रीट चिल्ड्रन और बहुत कई तरह के चिल्ड्रन को इंक्लूड किया गया है। इसलिए ये रिकमेंडेशन नहीं गया है कि ये जो जेंडर नॉन कन्फर्मिंग या ट्रांसजेंडर, इनका जिम्मेदारियां तीसरा सवाल है निर्भया फंड का, मतलब हमने कुछ सुना है कि मतलब इंफ्रास्ट्रक्चर के ऊपर भी मतलब कई सारे रिकमेंडेशन आए थे कि कहीं जगह स्ट्रीट रहते हैं जहाँ पे उन्होंने सेफ्टी सिक्योरिटी के इस्तेमाल कर सकते हैं, ऐसी स्थिति तो निर्भया फंड का स्टेटस।
My question is related to our moving further. Sexual assaults के लिए क्या-क्या government schemes available है और उसकी implementation की situation क्या है, which includes also budget fund.
मेरा एक्सप्रेशन जजमेंट ने कर दिया कि जो डिमांड्स है सेक्सुअल असॉल्ट के फ्रॉम द क्वेयर कम्युनिटी इज फॉर जेंडर न्यूट्रलिटी ऑफ द विक्टिम, नॉट द परपेट्रेटर। और एक जो है पूछना था कि करेक्टिव रेप ऑन लेस्बियन, बाइसेक्सुअल वुमेन, ट्रांसमास्कुलाइन कम्युनिटी के जो करेक्टिव, उनको करेक्ट करने के लिए जो किया जाता है, उनके फैमिली के लोग करते हैं, यूजुअली जो हम लोगों के पास एविडेंस है, उसको लेके उसको एग्रेवेट, वो फर्स्टली इनविजिबलाइज्ड है, वो रिकग्नाइज्ड ही नहीं है। दूसरी बात है उसको बाहर लाना और वो अग्रेवेटेड सेक्सुअल असॉल्ट के अंदर कैसे लाया जा सकता है इन लीगल टर्म्स, इसको लेके अगर कुछ बात हो सकता है।
My question is based on perspective. When we say that the laws are in place and there is the police machinery is also working fine, then why do we look at the number of reported cases as increase in incidents? Why don't we look at the awareness and that people think that the law is more approachable and that is why we have a number of cases which is increased, the reported cases. So why do we look that the incidents have increased but not the awareness? just want a perspective on that.
I just want to reflect on one thing and also ask that, when we go to police stations to complain about sexual assault cases or sexual harassment cases, this is in, I'm coming from Delhi, police just tells us that I'm an educated woman who has access to law and have network in that sense. They just tell us, madam, how to negotiate करेंगे, madam नहीं खर्चा रिपोर्ट लिखवा दीजिए, 2-3 बार देखें. So in those cases, for everything we are not doing day-to-day basis, we are ourselves dealing with so many things. Like we know how to deal with cases in our homes, but sometimes we need to fight complaints, and especially when the cases are of hierarchy, say when we are complaining against our teachers, or somebody who is powerful in that sense. So they will come and counter fire, which is obviously a lie, but then they say, madam, आप नहीं कर रहे हो, हमारे पास तो ये है, हमारे पास वो है, आप negotiate कीजिए, and how to deal with those situations.
Does the head of course constitute against basically or sex worker against people among students, or can the activity be punished for the community?
Regarding Professor, you see that it is consented sex between children and minor children, and it is more of exploration than exploitation. How does it fall under the Act of Socio-Legal? I just need to have understanding if I'm missing out on something.
I'm talking about consensual activity amongst minors. Okay? Now, what this law, it's the age of consent at 18. That is, below 18, you don't have the right to consent at all. You don't have any autonomy over your body. Like when we talk about law relating to kidnapping, if I can relate it, you see, it is an offense against the guardian. A child, he doesn't even have the right to give a consent. So I was talking about consensual activity amongst minors. Like, see, we've got section 377. But 377, it criminalizes even consensual activity amongst adults. Okay? So similarly, this also is another instance of draconian policing by the state. What they are saying is that even if it is consensual, it is something which the law has forbidden, so you would be punished for that. That was my point. We've got so many questions, some of them are related.
So can we, that is so, can we do a PIL challenging the provision which criminalizes and imposes a punishment on two minors who had sex consensually, between themselves consensually? Is there scope for doing a PIL to challenge the law so that youngsters who have consensual sex are never put in jail afterwards?
See, what I feel is that there has to be an age, but then again, it's not that it is only the state which can decide what is right and what is wrong. To each his own. See, what I feel is there is every possibility of having a PIL of this. This is a great area in law. Another point here is that when we talk about the Child Marriage Prohibition Act, we've been having this law for long. Now, since a child marriage is not a void marriage, the law says it's a perfectly valid marriage, unless and until one of the parties, especially the girl, she decides to annul the marriage. Okay, so when the child marriage is legal, what happens with two minors they are married? If they are saying that even consensual activity would be criminal, then what about conservation rights of such minors who have been married and the marriage is perfectly valid? So I feel there are too many grey areas in the law which need to be addressed and explored, and there will be no harm to PIL on this.
Now, there's a Supreme Court judgment, independent thought versus so that just reinforces. Yeah, the Supreme Court judgment of independent thought versus criminal area. In some ways, of course, it's a success because it does. The assumption is that it would decrease marriage under couples who are less than 18. But what it basically reinforces also, and it says that even basically saying that consent, let's say consensual or non-consensual, but sex under 18 years would amount to no crime. So eventually a PI will have to be filed actually. Because if you look in practice, it's quite, it's really unnecessary and it really puts a lot of burden on the courts as well.
for the police. So even a prostitute has a right to say no, and she has said no, even if you paid her, that would amount to. I hope I answered your question. Then there was this question relating to intangible cases of violation. Can that be real? See, we have a provision 376D, which is talking about intangible cases also. That is where some of them have actually violated, some others have not actually violated. Some were like just maybe waiting for their turn, or maybe they were just a participant in the entire activity being done. Liability would be on all. So that is the only way that we can say that it would be an intangible aspect. Otherwise, what Ray says, there has to be some sort of a contact. There has to be some sort of a penetrative violation. Only then that would amount to. Does that answer your question?
I actually,
It wasn't about contact, even if there is contact, and there are times when there is consent and still you feel violated. So I'm talking about very intrinsic experience of violation that a woman might be, not necessarily recognized by law, not necessarily something that can be medically proven. Even if I have no injuries and I still feel violated. So,
very much possible. See, young lady, what I feel here is that maybe you need to understand the concept of consent very clearly first. Okay? Consent means an informed choice that you make, whether you want to say yes or no to the act, and you had a knowledge of what the act was that you were consenting to. See, what you are talking about is this happens in many cases of daydream. Okay? The girl, she goes out with the boy, she's interested in the boy. She also wants to get intimate with the boy, but not to the extent that the boy feels that maybe the woman has consented. Okay? So we don't have any clarity over this issue. This is again a very grey area in the law. Okay? But then again, the consent has to be an active yes. Okay, some days back there was a judgment, I'm just not remembering the name, but in which the court said that there is no such thing as a feeble consent. A consent has to be an active consent and equivocally, verbally expressed yes.
That's the reason that
Someone asked a question about the schemes. Scheme, as regarding schemes, so 357E, the Delhi Victims Compensation Scheme of 2015, and even under POXO, you can actually seek compensation up to a maximum of 3 lakhs. You even have a provision for intent compensation up to 50,000. So nowadays, in fact, if a woman is raped, FIR is registered, and even if you move an application immediately before the judge, seeking for compensation, whether it's for any kind of medical treatment or travel from one place to the other, and if you just show the grounds, the court will pass an order for compensation. And for some of the other questions, I think I kind of really understand. So we can either meet subsequently or maybe just repeat the question.
So this has been a very good session, and we have a lot of unanswered questions. So we will continue this if you meet both our speakers. And thank you very much. It has been a very good session. Thank you.
That we were talking about action yesterday. So to me, I think this ordinance, new ordinance that's come, even in terms of finding a PIL, I find it quite, a very unreasonable provision. Because the way they have asked for enhancement of sentences without really addressing other issues, for everything that is going on in the death especially keeping in mind now also with kind of relationships. I think if we can look a little closer at this new ordinance and we see the impact. One more impact of the ordinance, what it says, is that in a case of bail, and this provision of exclusivity, as well as in a 239, when notice is issued to the other party, in the ordinance they make it obligatory for informant to be present as well. Now, in many cases, the complainant /informant/notice is present. In many cases, she may not want to be present. You see, so I think even that's like a setback. So, to the victim. So, if we can just discuss it, that's something. And number two is if we can at some point start discussing victim protection like a law. There are some schemes, I know Delhi has some schemes that you apply for protection to the police. when I go back to now, like what happened with her now, I think she had to be given protection by the law. This is the case of the victim center. So again, we can work towards some law towards victim protection in cases of this kind. So the victims are under. So these are two areas I want to do.
तो हमें कहीं ना कहीं आइडिया देता है कि शादी का ढूंढना लगने में जो कंसेंट का आइडिया है वो कितना ब्लर हो जाता है, ऑलमोस्ट डिसअपियरिंग ऑलमोस्ट। एंड कहीं ना कहीं इस सवाल से हम सभी जूझ रहे हैं, अपने आप से पूछते हैं। एंड कई ऐसे केसेस आए हैं जहाँ पे हमने देखा है कि जो ऐसी महिलाएं हैं वो कोर्ट के चक्कर काट रही हैं, वो इस इशू को लेके कहीं ना कहीं इस पूरे सिस्टम में स्ट्रगल कर रही है। एंड बिकॉज इस क्राइम का कोई रेकग्निशन नहीं है, जिसके वजह से कहीं ना कहीं वो एक लॉ में तो दूसरे लॉ में फंस के उस पूरे लीगल प्रोसेस में इस तरीके से फंस चुकी है कि उससे निकलना नामुमकिन होता जा रहा है। लास्ट ईयर हमने दिल्ली हाईकोर्ट में एक PIL डाला था ऑन मैरिटल रेप। एंड हमारे साथ आज 2 यंग लॉयर्स हैं HRLN से, ओलिविया पाम जो कि पिछले 10 साल से प्रैक्टिस कर रही हैं, पिछले 2 साल से HRLN से जुड़ी हैं एंड बहुत तरीके के ह्यूमन राइट्स इश्यूज पे काम कर रही हैं। एंड हमारे साथ है अली सक्सेना जो कि जर्नलिस्ट हैं एंड एडवोकेट हैं और HRLN से जुड़ी हुई हैं, और वो भी ह्यूमन राइट्स के काफ़ी मुद्दों पे काम कर रही हैं। और दोनों इस केस से बहुत ही डिटेल में जुड़ी हुई हैं एंड रेगुलर इस केस को फॉलो अप कर रही हैं, इस केस में जा रही हैं। मैं चाहूँगी कि ओलिविया इस केस के बारे में हमसे डिटेल में बात करें।
Thank you. Good morning, everybody. Yes. Before we start, I would like to have a little introduction to the students here. Please, can I have your hands up, please? For the students here. I'll put the first question to you so that you have a better understanding of marital rape. This is an interactive session. Others can also take part. It'll be short. Yes. My first question to you is, how do you know that sex with a partner is rape? What is the fine line that is sex with your partner okay or has turned to be rape?
It's only possible.
This is just to get a better understanding so that you know where we're going with this.
Whenever the other partner shows,
Can you please stand up?
whenever the other partner shows some discomfort, that should be the fine line. You don't have to say no or take attitude about it. Whenever you see the other person is discomforted or not very okay with it, it shows that it's the border line.
Anybody wants to add to that, please?
There has to be consent. It is not about just being discomfort. There has to be a yes and no. And you know, if I'm saying no, the other, if anybody is saying no, the other person has to accept it.
Yes. So, I would just ask, consent is always an informed choice. You have to understand what the options are and what the repercussions are. So, hence, in this, you say that you don't have to say no, right? Your question is you don't have to say no. You say that consent is very important. So, my question to you is consent made to the state, because it's the age factor, or is consent between two individuals? Somebody can answer that, please. So, understand what consent is. Anybody? Anybody? Consent between who? Between individuals. Right. So should the state be allowed to make a age thing about majority and minority for consent of sex between two people?
Yes, they should. Definitely help family. Yes, they should.
Great. So see, there's no wrong answer here. Everybody should give in their views that we understand marital rape. Marital rape
Before we actually move on to talk about marital rape, इससे पहले कि हम आगे बढ़े और marital rape के बारे में बात करें, मैं आपसे एक सवाल और पूछना चाहती हूँ। आपके लिए स्पिरिट ऑफ मैरिज का क्या मतलब है, या इंस्टीट्यूशन ऑफ मैरिज का क्या मतलब है?
It is when two individuals decide to live together for the rest of their lives. It's an informed choice, freely, without any coercion, of course. So it is a mutual decision.
My question is marriage a license to have sex?
No, because they freely choose to live with each other, so there is an understanding that there is, and I think everything is mutual. So mutual agreement is the main factor in marriage.
Which comes back to consent. Yes. Which consent is important.
Yes.
Everyone agrees?
Everyone.
I would say so. तो स्पिरिट ऑफ मैरिज या एक मैरिज आपको लाइसेंस नहीं देता है किसी औरत की या किसी वुमन की बॉडी के ऊपर पूरी तरह से हक जमाने का। ये बात अब हो चुकी है। जिस समय इंडियन पीनल कोड लिखा जा रहा था, जब कॉन्स्टिट्यूएंट असेंबली डिबेट कर रही थी, तब ये बोला गया कि अगर हम रेप में मैरिटल रेप को डालते हैं या उसको एक समान मानते हैं, तो उससे स्पिरिट ऑफ मैरिज खराब होती है। जब दो इंसान शादी करते हैं आपस में, तो उस शादी का कंसेंट से, फ्री कंसेंट से और फोर्स सेक्स से कोई मतलब नहीं है। और तब हमारे इंडियन पीनल कोड में इंट्रोड्यूस हुआ एक्सेप्शन टू सेक्शुअल इंटरकोर्स और सेक्शुअल एक्ट्स बाय अ मैन विद हिज ओन वाइफ, the wife not being under the age of 15 is not rape. Under the age of 15 hopefully change होगा independent thought के judgment के बाद, जो under the age of 18 करेगा. But the exception says that any forceful sex or any forceful act of sexual intercourse by husband on the wife is not rape.
I'll have the first slide. If everybody could just take a look at that, there's the difference between marital rape and rape. It's the same crime, same offense, it's just the status that has changed. Either you're married or you're not married. It's the same offense. Okay. Here with the definition of rape, we will divide it into two parts. The first part is by a man with his own wife. Okay, that's the first part. And the second part is wife not being under 15 years of age is not rape. We will deal with the second part first, which will fall back on the first part to understand what marital rape is. Okay? And the second part, that is wife not being under 15 years of age is not rape, is dealt with extensively with the independent court judgment recently passed by Justice Lugur. Yes. Yes. So the Act read as previously the Act read as see, we only deal with exception 2 of 375 IPC. So, the first part of the Act says that, sorry, the second part says that, I just wanted to say that these are extracts taken from the judgment in which we will try to give a clear notion to what marital rape is. The first part is that we should not have this kind of outdated notion that the wife is no more than a servant chattel of her husband that has since since being given by the even after the United Kingdom, to which we in India still have thought that a wife is more of in charge of the family, part of, yeah, I think you will explain it from here.
Independent Thought's judgment says कि अगर आप 18 years and less है and you're married to a man whichever age, it is not marital. But that is not the case for any regular woman. In Delhi, when we get cases of divorce, of domestic violence, there is one complaint that stands common in all of those cases, which is कि मेरा पति मेरे साथ जबरदस्ती सेक्स करता था. This is a very, very common line, but it is not defined in any of our fields. It is not in the penal code. Marital rape is still not part of our penal code.
What we're trying to say here is that Indian societies, it is something which is very new to Indian society. While this marital rape has been defined since 1934 or 1834 by Poland, and then India is only exposed to it right now. There are about 51 countries that have criminalized marital rape, while India is still way behind. This is why I'll read something which has been referenced by the European Commission on Human Rights, which endorsed the conclusion that a rapist remains a rapist regardless of his relationship with the victim. Next slide. Yes. This is just to understand rape. It is quite clear that a rapist remains a rapist, and a marriage with a victim does not give courtesy to a non-rapist. Similarly, a rape is a rape whether it is described as such or is described as penetrative sexual assault or aggravated penetrative sexual assault. Now, do you understand that? You understand that why a woman, married woman, is being treated as somebody as weak because of previously women were not financially independent. I think this is the main cause of why marital rape has not come out to the surface, because women were not financially independent. But now I feel that with this, where women have become, have done amazingly well. This is why I say that. What the judgment records is also that it says that it must be remembered that those days are long gone when a married woman or a married child could be treated as subordinate to her husband, or at his beck and call, or as his property. That means women were treated as property. We deal with exception 2 to the section 375 of the IPC, which deals with marital rape and defines marital rape, saying that it creates an artificial distinction between a married girl and an unmarried girl, where thereby, with no real rationale, and thereby goes away with the consent of sexual intercourse by a husband, which is by a husband who is a girl between 15 and 18 years of age. Now, this independent thought deals with the age of 15 years, which is not the age of majority, which we have changed to 18 years. Now, this notion of tradition and customs, I need to ask the house here that because marriage is a tradition and also a custom, hence is it against the concept of marital rape? And if it is, how can we address it? Anybody? If a tradition and custom is against or incontrovertly to your rights, how can we address this? Should we do away with the custom and rights, or should we do away with our constitutional rights? Because it's against
all the customary constitutional rights have to override customary. There is no defined written customary law that a woman must surrender to the needs of the husband if he wants to have sex.
Yeah, not if
there cannot be any customary rights also to all this.
Right.
And of course, under all circumstances, the constitutional rights, which especially to these topics must override customary rights if people feel that our custom is such and such. Sorry.
There seems to be a custom in India, like Akshay Tritiya and so on, huge practices of custom, right? Where you have child brides and children being married. So child marriage is very customary and is taken as part of religion. So the question that Olivia asked you about, is custom to be honored? Should custom in India be honored? And if you make a law like marital rape, is it not against our custom? Is it not anti-custom?
A lot of people still practice child marriages, irrespective of this judgment. What should we do? Because this is our custom, but it's against the rights of the individual. So hence, what this judgment says that times is changing, that what was accepted in a few decades ago may not be necessarily accepted today. Such as early marriage or child marriage. We have not discussed the child marriage. I'm only explaining to you why the second part of the exception 2 of 375. We are addressing that so that we understand what marital rape of a marital is. Who is a major? Yeah, let me read this. In effect, therefore, the practice of early marriage or child marriage, even if sanctioned by tradition or customs, may yet be an undesirable practice today with increasing awareness and knowledge. Its detrimental effects and the detrimental effects of early pregnancy. Should this tradition practice still continue? This is what has been addressed in the judgment regarding customs and tradition. Should a custom or tradition continue despite the fact that it is detrimental to society? We do not think so, and soon it is given up, it would be the best interest of the girl child and for society as a whole. Constitution, this is when we talk about constitution and moral and tradition. This is the differences here. What should we do if morals and, not morals, but what should we do if tradition and customs is contradictory to your constitutional right? It says that constitutional morality forbids us from giving interpretation to section 2 of section 375 of the IPC that sanctifies a tradition or custom that is no longer sustainable. It says that in view of marital rape of a girl child has the potential to destroy the institution of marriage cannot be accepted. In view from any perspective, there seems to be no reason to arbitrarily discriminate against a girl child who is married between 15 and 18 years of age. This is regarding, the next slide is regarding the practice of Akshay Tritiya, where mass child marriages are performed. Such young girls are subject to sexual intercourse regardless of their health, their ability to bear children, and other adverse social, economic, and psychological consequences. Civil society can do just so much to prevent such child marriages, but eventually it is the government of India, the state, government to take proactive steps to prevent child marriage so that young girls in our country can aspire to a better and healthier life. Next slide, please. Therefore, we are left with absolutely no other option but to harmonize the system of law relating to children and require exception 2 to section 375 of the IPC to now be read as sexual intercourse or sexual acts by the man with the whole wife. The wife not being under 18 years of age is not rape. Hence, this is the second part of the exception 2 of section 375. Now, in the first slide. Yes. So now we have dealt with wife not being under 15 years of age should be read as wife not being under 18 years of age. That part is dealt with, which falls back to the first part of the exception, which is sexual acts by a man with his own wife. This is marital rape. This is how you understand marital rape. This is how you can maybe file an FIR unmarital rape. Right? But they have not yet criminalized marital rape. Why? Because the petition is depending on the High Court and their High Court. There are various parts to this which I need to, the first question I need to ask is on how prosecution can be conducted in marital rape. What should be done? Can anybody please answer? Anybody want to answer on that? Is the statement of a woman necessary in marital rape? Is there a cry for
wife not being part of 15 years affairs is not there. What do you mean?
No, this has been changed. This is changed now.
15 years. लेकिन child marriage तो 18 years after 18 age के बाद में होगी ना?
तो जो मैं आपको थोड़ा बताना चाहूँगा, ओलिवर ने ये बताया कि रेप क्या है, मैरिटल रेप और रेप में ये फर्क है कि रेप का कंप्लेंट कोई भी अनमैरिड या अगर कोई भी औरत या लड़की जाकर के कंप्लेंट कर सकती है रेप के अंदर, लेकिन ये रेप उनके पति के अलावा कोई और करेगा। मैरिटल रेप होगा अगर आप कंप्लेंट करेंगे अपने पति के अगेंस्ट कि मेरे पति ने मुझ पर रेप किया। ये बेसिक जो डिफरेंस है रेप और मैरिटल रेप में। हमारी प्रोविजन में जैसा मैंने बोला ये एक्सेप्शन है। इसका मतलब ये है कि हमने रेप बताते हैं क्या है, लेकिन हमने ये बोला है कि अगर एक आदमी अपनी बीवी के साथ सेक्सुअल इंटरकोर्स करेगा वो रेप नहीं माना जाएगा। वो सिर्फ एक कंडीशन में रेप माना जाएगा अगर वो 15 साल से छोटी है लड़की, जो ये चेंज हो चुका है डिपेंडेंट थॉट का जो जजमेंट आया था वो 18 साल की उम्र में। उसके बाद ओलिवर ने ये बोला कि हमारा जो कस्टम्स है या जो हमारी धाराएं चलती आ रही है इतने समय से, हम उसको ऊपर रखें या हमें जो कॉन्स्टिट्यूशन ने हमारे राइट्स दिए हैं उसको ऊपर रखें। तो ये डिबेट को डिसाइड करने के लिए इन्होंने बोला कि हमने दिल्ली हाईकोर्ट में पिटीशन फाइल किया है कि मैरिटल रेप का एक्सेप्शन है वो हटना चाहिए और मैरिटल रेप यानी हस्बैंड अपनी वाइफ के ऊपर रेप करे ये ऑफेंस में आना चाहिए। जैसे बाकी के रेप ऑफेंसेस डिफाइन है वैसे ये भी रेप में आना चाहिए।
Any other question? Yes, you want to ask something?
What happens to marriage after a complaint of rape is filed and in a scenario where we have criminalized this offense? What happens to marriage itself? How does the Hindu Marriage Act or those legislations come into play? Do we assume that once a complaint is filed, the marriage is annulled? Or how is all of that taken into?
See, I'll take you a little bit one step back. We still do not have any provision which criminalizes marital rape, and this is what we are trying to do through the PIL that has been finally developed. Now, I'll give you background to this. If India actually, if our courts stand up and say marital rape is an offense, it will be a breakthrough for us, but we will be the 52nd country in the world to do so. Countries as small and neighboring to us as Nepal have already criminalized marital rape. So, to answer your question, if someone is to go to the police station tomorrow and say my husband has committed rape on me, please file an FIR, there is no provision to file an FIR. But the Domestic Violence Act talks about sexual assault.
So the question is that
what happens to the marriage?
What happens to marriage? Do you think the marriage will last after a person has, if a person has committed marital rape over and over again? Would that marriage last?
No, but he's asking that is the plan of action that as soon as you file a complaint, is it also automatically a plea for divorce?
No.
Or is it not? That's what he's asking.
Yeah, so even in domestic violence, see, we do not have a provision to file marital rape right now. So what will be the effect of the marriage once we have that provision where we can file marriage is called yet to be decided. Now, the only provision that we have in the domestic violence also does not automatically lead to the end of the marriage. Domestic Violence Act is different and divorce is different.
I want to say something.
something to everyone. It's a food for thought here.
I just want to address a few issues regarding law. Okay? Since we already opened the topic of law, I just want to address certain issues. The issues regarding marital rape, there are many provisions of law which does not actually define or punitive action against the marital rape, because there is no mechanism where you can go and say that this is actually happening. I will tell you a few which actually talks about marital rape, but does not talk about any punitive action. I can tell you about 198B of CRPC. I don't know if people are aware of this. 198 of CRPC says that if a wife does complain against her husband, and yet, that proposal should be as such that there will be an interrogation whether such a crime really took place or not, then at the request of the wife, only a complaint can be made, otherwise no. But there is a contribution to Section 12 of the Domestic Violence Act, the POSCO Act, the Prevention of Child Marriage Act, and restitution of conjugal rights. Who understands the restitution of conjugal rights here? Where a man or a woman can also seek application free from the possessor's court to reconstruct his relationship with his wife or husband. So these are the kind of things which are maybe for marital rape, or there's some sense which can backfire and be against that. But there's no such thing that defines what marital rape is apart from this first line that says, it says sexual intercourse or sexual acts by a man with his own wife. Simple. Simple as that. The last one is marital rape was talked about in the Justice Verma Committee report, in which he says that the legal provision on marital rape should be accompanied by changes in the attitude of the prosecutor, police officers, and those in society. That is, when you have a victim who goes to the police station saying that this is what has happened to me, the police says it is a husband and wife situation which we cannot enter. Or we cannot, there was a Twitter by somebody famous saying that, why should the police enter our bedroom? This is a comment made by somebody. Yes, marital relationship between the predator and the victim is not a valid defense against the crime of rape. Recommendation for the removal of the exception of rape. These are the 3 points that Justice Verma Committee talks about marital rape. Which there are many international case laws that has defined marital rape. The first is, of course, the Supreme Court of Nepal. This is in 2011, No, 2008. 2008. Yeah. The Supreme Court of Nepal has already criminalized marital rape, saying that the classification of law that an act committed against an unmarried girl to become an offense and the same act committed against a married woman to not become an offense is not a reasonable classification, because it's the same act committed to a married person, and then the same act is committed to an unmarried person. Then the Supreme Court of Human Rights, CCRI versus UK, says that a rapist remains a rapist regardless of his relationship with the victim. The third, held by the Canadian Supreme Court in R versus J, it says that the relationship between the accused person and the complainant does not change the nature of the inquiry into whether the complainant consented to sexual activity. I need to understand that. I need to ask a question. The question is that how do we prosecute marital rape? I'm still on that point right now. Maybe you could answer this, please. amendment here to the Act to actually define marital rape and also for punitive action as for rape laws.
Sir, this is what you say is exactly what we need to think. Is marital rape different from any other form of rape? So then a divorce and compensation is not the only punishment for
The
rape.
criminal element also should be there, but it's a very tricky area.
No, sir, it's not that actually. So what this gentleman is saying is exactly what the only debate is. Should marital rape be different from all the other forms of rape? If not, then what Olivia is asking is that if a wife comes with a complaint that my husband has raped me, should there be any difference in the investigation, in the prosecution, than what it is in any other form of rape case? This is the only debate. If we settle this debate, the courts will actually go over with the exception. So what Olivia brings to us here is how should it be prosecuted? What should be the process of investigation when it is a complaint of marital rape?
And why is it tricky? You use the word tricky here. So why is the prosecution of your husband for rape tricky?
Because there's case of blatant use of blatant possible misuse like dowry, and that's my view. I think.
Yeah. So Aditi to answer this, he said,
like for example, in dowry death, what happened? We saw a lot of false cases also.
I'll take that. False cases, right? You want me to answer false cases?
Yes, the false cases.
A lot of people have filed a lot of false cases in different laws too. It depends. How do you prove your case? Proving your case, there's a lot of evidence that is to be taken under trial. So my next question to the thought train here, the thought processes here is that, would a woman cry out rape in marriage?
Since there is no law on this, can it come under Domestic Violence Act 2005?
There is a provision under Domestic Violence Act, but the punishment defined is only 3 years. Whereas the rapist has a more stringent punishment.
I wanted to add, this was my input, and also to Collins, maybe at some stage, at some conference, you can have this as a subject of debate and further discussion. ये एक provision है और हर मर्द जो डिवोर्स पिटीशन फाइल करता है 90 आउट ऑफ 100 केसेस में उसका एक ग्राउंड ये होता है कि मेरी बीवी मुझे अपने नजदीक नहीं आने देती, शी डजंट अलाउ सेक्स, सो इट इज अ ग्राउंड ऑफ क्रूअल्टी. बहुत सारे ये मेरे सामने देखा हुआ प्रैक्टिकल केस है किसी और का जो चल रहा था कोर्ट में. तो एक ग्राउंड लड़की ने ये लिया हुआ था मैरिटल रेप का कि जब चाहता है मेरे को इस्तेमाल करता है. तो क्रॉस क्वेश्चनिंग में पूछा गया अक्सर इस्तेमाल करता है, उसने कहा अक्सर इस्तेमाल करता है. तो आर्ग्यूमेंट हस्बैंड की थी, इसका मतलब अगर आपकी एलिगेशन ये कि अक्सर मेरा नाजायज इस्तेमाल करता है, मुझे मैरिटल रेप करता है, तो माने ये मेरे को ये अपने पास आने ही नहीं देती और ये अपने आप में क्रूअल्टी है. और कोर्ट ने ये जजमेंट में लिखा कि ये देखने वाली बात है कि क्रूअल्टी हस्बैंड को है कि उसको जबरदस्ती जाना पड़ता था, अपने आप को जबरदस्ती उससे लादना पड़ता था, या ये लड़की जो मैरिटल रेप कह रही है ये विक्टिम है या हस्बैंड विक्टिम है. तो आज ये सिचुएशन अगर है तो मे बी आप किसी टाइम पे मैंने ये पॉइंट इसलिए उठाया बिकॉज आई वांटेड टू लीव द फूड ऑफ थॉट फॉर एवरीवन, दी पैनलिस्ट ऑल्सो एंड द फ्लोर ऑल्सो, कि आप सोचें कि ये कैसी डायकॉटमी है.
एक तो I need to say something to you about Domestic Violence Act. Domestic Violence Act is a criminal, it's not a criminal provision. It's not a criminal procedure. It does not have criminal procedure. It is a civil procedure.
No, it's right.
But no, what? I'm telling you about the section. Which, again, if it is quasi-civil, quasi-criminal, then punitive action here is not considered as rape. It's not considered as rape. Hence, it's not defined even in domestic violence. Even if you file a petition on a domestic for this act. For marital rape, it is not recognized.
There is no marital rape, there is no sexual assault.
Okay, let's just give me a second. Now, a woman may deny sex to her husband. She may say, I'm married, but I don't want to have sex. And the courts have held that amounts to cruelty, and therefore it's a ground for divorce. Okay? These are conceptually very separate issues. So that may be all right as well. That if a woman or a man denies her husband or wife sex in marriage, then your marriage basically breaks down. So you can go to court and say, this amounts to cruelty. A woman can say this amounts to cruelty, a man. But that is separate from the argument on marital rape. Now on marital rape, we had the gentleman over there saying that marital rape is tricky. And it is tricky because it can be misused. Right? To which the argument came that there are many laws which are misused. And the answer to trickiness is that you cut out the misuse. The courts cut out the misuse. You find misuse everywhere. Take freedom of speech and expression. You find, along with the right, comes the abuse of the right. So freedom of speech and expression comes with defamation. So what do? You cut off the misuse. You don't cut off the act itself. So, question that is posed now is, what's the problem in having marital rape as a crime in India? Is there a problem? Is anybody opposed to it? And is there a problem with having marital rape? Are there problems?
Actually, एक केसेस है शक्ति एरिया में, तो केसेस था कि वो जो पति है शराब पीता है, पति शराब पीते हैं, तो वो भी वही मैटर में केसेस किया था कि मेरे पति मेरे को बार-बार मेरे पास आता है तो मेरे को अच्छा नहीं लगता कहते हैं, लेकिन उसका जो केसेस था वो पति साबित किया कि मैं शराब का नशा नहीं किया करता है, तो इसलिए जब शराब नहीं पीती हूँ तो उसके पास नहीं जाती हूँ, लेकिन वो शराब पीती है।
लेकिन ये बताओ, शराब पिया, बलात्कार किया, तो बलात्कार नहीं होता है?
वही है, लेकिन जो वकील था ना, वो साबित करा दिया कि शराब का नशा नहीं किया तो केस हो गया है, वही होता है।
वो भाई मैंने एक मिनट, थोड़ा धीरे से जाना, धीरे से। मैं उस वकील का मैं नहीं पूछ रहा हूँ। आपने अच्छा उदाहरण दिया कि किसी ने कहा कि मैंने शराब पिया, उसके बाद मैंने जबरदस्ती सेक्स किया, तो वो रेप नहीं है। तो आप मानते हो या नहीं मानते?
नहीं, हम मानते हैं, हम तो मानते हैं वो रेप है, इसलिए
हो गया।
लेकिन उसी केस को किस तरह से हम लोग डीलिंग करेंगे? मेरा कहना वही है, वो केसेस
वो केस छोड़ दो मैडम। सिंपल बात है कि शराब पिया हुआ आदमी जो रेप करता है, वो भी रेपिस्ट है। तो सब कौन मानेगा? इसको केस का छोड़ दो। कोई फालतू जज है, कोई फालतू जज दिया, छोड़ दो। सिंपल बात है।
नहीं सर, हम लोग हर चीज कोर्ट जाना है, हम लोग बोलते हैं कि कानूनी जो दायरा में हम लोग करना है, तो केसेस ऐसे आता है, हम लेके जाते हैं और वो केसेस ऐसे फाइनल होता है जब जजमेंट ऐसे आता है कि नहीं वो तो शराब का नशा में किया था, तो फिर दोबारा किसको बोलेंगे कि आप केसेस करो तो करेंगे नहीं ना? मेरा कहने का मतलब वही है।
Most of marital rape complaints have been filed under cruelty. I just said cruelty, not under rape. So, because there is no definition, we hope and we are hoping that after this judgment of independent court, there will be some sort of judgment for marital rape in which marital rape can be criminalized.
I have a point here. I feel rape and marital rape are two very different aspects. Just to elaborate on it. Rape is, it is a certain stranger who is affected your dignity, he's got his hands on you. But marital rape is with a person you had a consensual sex for a long time, maybe most likely, it so happened. It could be one of the incident or the repeated incident, but there is still a bond that you have. So how do you criminalize that?
would you like to continue with somebody who actually cannot respect your rights?
See, it is very subjective. Marriage is rape is a very subjective thing. It's a very private thing. हो सकता है that it could be a misunderstanding or that there is a possibility of discussing it. There is a possibility of not having that. But that is not any marriage.
No, correct. What you're saying, that is for all the other grounds of divorce also. Now the rape is defined as an act. It is an act, a singular act. If your previous encounter was consensual, does not matter. My previous encounter with somebody was consensual, but this is not. It is a singular act.
That is what I am saying. Why is singular act has to be realized?
Now this is what it is like. That is actually institution of marriage different from this one act that holds all the potential to be criminalized.
I feel the degree of this is much lesser than what it is for the rape.
See, she's asking a very simple thing. I'm a married woman. My husband had sex with me against my will. Correct. Okay, he's done something wrong. But we have a long relationship, long history and so on. So, does it mean actually that she has to find a case against the husband? I mean, I may say as a woman, okay, he's done this, but in view of my long history, I let it go. It's another thing if he does it again and again and again and again. So, she's putting that practical issue.
But the law doesn't mandate reporting at every. I mean, it's not telling every woman or man or anyone else in a marriage to sort of go to court with every incident, even if you don't feel like.
So this is actually a point.
Create your own experience.
Absolutely. So my point is
this is, I go back to the point that you yourself raised, which is that if there are more reporting of cases, is it because of awareness or is it because of
absolutely. My point here is that instead of thinking or debating that we should criminalize this, don't you think that having a counseling before marriage for couples who are going to enter into marriage and making them aware of these would be a step that will probably help reduce this?
Rape is not something that somebody does not.
Ma'am, what we will do here is, we will give you a brief story of the cases that we have done on marital rape, and there's a brief story without actually
saying who these people are, but just giving you a gist of how these people went through and how it advocated. Now, the thing is, we're not encouraging and saying that please come up with a complaint. We're only letting you know that these are the kind of people that we have dealt with. Yes, counseling is one of the many things. But we have been sending these people for counseling. We'll give you 2 examples, or maybe 3 examples, in which how this came to be, how they were
and when I counseled them, it did work out. So it was like 2 years back.
Exactly.
Now it's fine. So that is the point.
See, the simple thing here is that, you have to understand the relationship between a man and a woman in a married relationship. Okay, when you begin to understand what marriage is about and why it should not be forceful and what can be accepted and what cannot be accepted.
Absolutely. It is a very wide definition. How will you define that this constitutes marital rape? And the way you define what is consent, how do you define what is marital?
Ma'am, I just wanted to say, because when you started your question, you said that, when you just talk about rape, it is an unknown person who got that. It's not true. If you see the statistics just of Delhi, more than 85% cases are cases where a person close to you, most likely a family member or a friend, is the perpetrator. So saying that it is an unknown person who got your hands, it's not true. It is easiest when you are a person who has a certain amount, where the victim has a certain amount of trust on you. So it's easiest for you. It's not necessarily testing, it can be a friend, it can be a neighbor.
Even if it is a known person, it is forced, it is unconsented.
No, so I'm not talking about consent here. I'm just clarifying the fact that if you're trying to sort of say that rape and marital rape are different in the sense that in cases of marital rape, you have a long history with the person, without the consent. So we had this case where the girl walked out of her marriage in 1.5 months because of how brutally she was raped by her husband during that period. She was in need of medical attention because of that, and her husband did not take her to the doctor, did not get the tests. So that is one example. And it's been 2 years, and she's still in the process of counseling because the case was filed under Domestic Violence Act. And after the judgment of, I think, 2016, where the court said that before filing an FIR, you need a compulsory counseling of 3 months. Those 3 months were the time that the people who were counseling her were trying to convince her to settle. So that's problematic because you have to identify cases where a person has been raped.
So absolutely. So how do you define what is the definition, what is the gravity, what is the degree? I'm understanding.
And the second example is of a woman who stayed in the marriage in that condition for about 12 years. You know why? Because she and her kids were financially dependent on her husband until one day she couldn't take it anymore and she walked out and came into our offices crying that I can't take this anymore, but he would take away my kids if I speak up about it. So what do you do in cases like that?
So that is again the degree, the gravity of the
Exactly.
that is happening.
Exactly.
That's why I asked how do you define it? What is the degree to which we take it as a matter?
Yes. So now I'll give you a very brief perspective of the ongoing case, and I will tell you that what are all the angles of debates that are going on. Now तो अब मैं आपको केस के बारे में संक्षिप्त में बताती हूँ और मैं आपको ये बताती हूँ कि बहुत से अलग अलग सेगमेंट्स इस केस के बारे में क्या बोल रहे हैं। हम ये बोल रहे हैं कि मैरिटल रेप किसी और रेप से अलग नहीं है। एक एक्ट एक हस्बैंड का अपनी वाइफ के ऊपर फोर्सफुल सेक्सुअल इंटरकोर्स किसी और रेप से अलग नहीं है। इसको वैसे ही इन्वेस्टिगेट किया जाए, इसको वैसे ही प्रोसिक्यूट किया जाए और इसका पनिशमेंट वैसा ही हो जैसा रेप का। हमारे केस में बहुत से मेंस ग्रुप हैं जिन्होंने आकर के यही बोला है कि इसकी ग्रेविटी को समझा जाए। हम ये नहीं कह रहे कि ये ऑफेंस नहीं होना चाहिए, पर ये समझा जाए कि इसका पनिशमेंट जो बाकी के रेप केसेस हैं उससे कम होना चाहिए। हमारी दिल्ली सरकार ये कह रही है कि हमारे कोर्ट के पास पावर ही नहीं है। दिल्ली सरकार ये कह रही है कि कोर्ट के पास पावर नहीं है कोई नया ऑफेंस बनाने की, और हमारी भारत सरकार ये कह रही है कि अगर आप इस एक्सेप्शन को हटाते हैं तो आपको ये केस कैसे प्रोसिक्यूट किया जाएगा ये आपके बस में नहीं है। कितने फॉल्स केसेस होंगे इसको भी आप कंट्रोल नहीं कर पाएंगे। ये 4 एरिया हैं जो अभी ये कोर्ट के सामने पेश कर रहे हैं ये केस, और हमारा जवाब इन सबको ये है कि हम पहली कंट्री नहीं है जो ये बोल रहे हैं कि ये एक ऑफेंस अपने आप में होना चाहिए। हमसे पहले 50 और कंट्रीज, डेवलपिंग कंट्रीज, डेवलप्ड कंट्रीज, यूएसए से लेकर नेपाल तक सब ये बात बोल चुके हैं कि एक हस्बैंड का अपनी वाइफ के ऊपर फोर्सफुल सेक्सुअल इंटरकोर्स उतना ही मेजर ऑफेंस है जितना एक अंकल का अपनी बीवी से, जितना एक स्ट्रेंजर का किसी स्ट्रेंजर के साथ। तो इसमें हम उसको कैसे इन्वेस्टिगेट करेंगे, कैसे प्रोसिक्यूट करेंगे, ये हमको बनाना नहीं है, ये हमको पता है कि कैसे इन्वेस्टिगेट करना है, कैसे प्रोसिक्यूट करना है, और हम ये केसेस कर चुके हैं। तो अब हमको ये सब यहाँ पे जितने भी लोग हैं सबको समझ में आ गया है कि मैरिटल रेप क्या है, पर यहाँ किसी को भी ये समझ में नहीं आया कि मैरिटल रेप का ऑफेंस अब तक क्यों नहीं किया। तो मैं ये सेशन इसी के साथ यही बोल के खत्म करूंगी कि ये हमारा वार्तालाप यहाँ खत्म नहीं हुआ है, हमें और सोचने की जरूरत है। अगर आपको लगता है कि हमारे जो केस चल रहा है उसमें हम कोई पॉइंट ले सकते हैं जो बहुत उस केस को मजबूत बनाए, तो प्लीज हमें बताइए और हम मिलकर के इस मैरिटल रेप के एक्सेप्शन को हटाएं। थैंक यू।
I need to put a question to the floor. Should there be degrees of rape? Should rape be defined in these stage violations? This is rape, this is not rape, it's almost rape, this is going to be rape. If we are going to actually understand, it's simple. Consent, not consented. Should there be degrees of rape? with husband, with boyfriend, with friend, not rape, could be rape, has to be rape, almost rape.
No, that, I mean, the distinctions that you mentioned, probably not that, but there has to be degrees of everything. That's why you have the idea of this crime,
So you say that we should wait till it very previous.
No, I'm not. See, I'm coming to this point from the point of the idea of reformation. If we were to treat all sexual offenders as somebody who cannot be informed and reintegrated into society, then there is really no. That is not the philosophy of prison rights or criminal rights that I sort of align with. So yes, there is, and consent is not as simple as yes or no. We need to stop simplifying it too much. And there is incredible amount of work that is going on consent. That is going on consent amongst people who work on the issue. And for the purpose of law, we can. The reason is that people don't understand consent in the first place, so we can start with a yes or no. But at the same time, if we're really going further on the conversation, we need to understand that there are degrees of consent. There are degrees to what you consent to, what you don't consent to. At what time do you consent to something and immediately at the next moment you don't consent to something else? So it is not as simple as that. So in a similar way that we also need to look at sexual offences not as something that is a damnable yes or a no.
So he says, basically what he's saying is consent. There are degrees of consent. Maybe she said yes, maybe she said no, maybe she did not consent, then she said yes. So give us a quick answer, then she'll summarize.
Evidence.
He's saying there are degrees of consent. What did she say? Ambiguous consent. Usne spasht tarike se dhyan, she did not say no clearly. That's it.
See, the thing is, a relationship between a husband and wife is also very private. What goes on in the bedroom, how do you know? How can you give evidence in that case? You understand?
But
it's up to the woman, it's up to the victim. But Sneha's trying to tell me is about brutality. How brutal the act is.
So let's summarize, okay? And then we'll do a little anything. Delhi High Court judgment, which is we must circulate Delhi High Court judgment which went to Supreme Court. And that Supreme Court judgment we must circulate. Man and woman knew each other. बहुत ही नजदीक का रिलेशन. And they were even kissing. The judges noted that. They were even kissing. Then they got into a physical relationship. And there she said no. No. But it was a feeble no. What do you do feeble in Hindi? It was a feeble. Kamzor jaisa naam. Not kahi, lekin kamzor, but weakly, softly. Not kamzor, kamzor softly. Feeble no. तो हाईकोर्ट जज बहुत अच्छा हाईकोर्ट जज जो पटना से है, बहुत अच्छा हाईकोर्ट जज, उसने कहा डिसाइड किया कि I cannot make out. She said no, but I cannot make out because they were seen kissing earlier. So maybe she consented. So he said, a feeble no is not no. I said no. Because softly मैंने कहा, so that is not no, that is consent. Because earlier they were kissing. And Supreme Court upheld that. That is a very wrong thing. So you study this. You study that judgment carefully. A feeble no is not a no. Even?
You're talking about the conclave.
Yes.
He's talking about the same judgment. So I think in that case, they had kissed, but she had not consented for anything more than that, and he forced himself. Yeah. When the friend walked in and or the wife walked in and they did that. So that is why the court said that no, the no did not mean no, it meant a yes. Yes. It was
not an emphatic no. मतलब clearly स्पष्ट तरीके से इसे कहा गया. See, this is all actually a new development of law. Not only in marital rape, but in rape, how is consent given, not given. And there are laws now being made in France. I believe there are laws now being made that there must be very clear, unequivocal agreement to have sex. It need not be by yes, but it can be clearly by conduct. That there must be a very clear, unequivocal. And if there's any level of ambiguity as to whether the woman really wants to have sex with you or not, then you are in a danger zone. So you can't just go ahead and have sex. If there's any element of ambiguity. So let's stop here. We run out of time very much.
I just want to say, there are no degrees to consent. If it's a yes, consent is yes. Like if the girl is saying yes, then we to go. And no, it's no.
No, that's not what I said. What I meant by degrees of consent is you consent to several things while having sex. And you don't consent to several things while having sex in the same time.
No, yes,
No, I'm just saying that there is yes, there is no. If the girl like, if the signal is not clear to the guy, then it's a no. Because a yes is always a yes. Yeah.
To what you say.
No more, madam. Now, all discussion a little later. We have run very much half an hour. We have 1 hour. We have not played. Madam.
अच्छा, तो अभी बहुत गंभीर चर्चा हुई शादी में रेप के ऊपर, और एक तरह से सवाल बहुत सरल भी लगता है, कभी बहुत सिंपल लगता है, कभी बहुत कॉम्प्लिकेटेड लगता है, पर बहुत गंभीर चर्चा हुई. मुख्यतः जो मेन चर्चा हुई वो ये कि हमारे कानून में रेप को जहाँ परिभाषित किया गया है ना, उसके नीचे एक अपवाद दिया गया है कि यदि कोई पुरुष अपनी पत्नी के साथ यौनिक रिश्ता लगाता है तो वो रेप नहीं होता है. पहले था कि अगर वो 15 साल से कम की है तब वो रेप होगा, और उसके बाद सुप्रीम कोर्ट का जजमेंट आया जिस पर हमने कल भी चर्चा की है. तो आज के वक्ताओं का मेन जो मेन बात उन्होंने रखा वो ये है कि रेप होता है, और सिर्फ इसलिए कि जो रेप करता है, जिसका रेप होता है वो उसकी पत्नी होती है, इसलिए रेप कुछ और हो जाता है, ऐसा हो नहीं सकता है, ये उन्होंने कहा. और जो सुप्रीम कोर्ट का जो फैसला है आई थॉट, इसमें 2-3 बहुत मुख्य बिंदुओं पे चर्चा हुई है. एक तो ये कि इसमें कहा गया कि 15 से 18 साल की जो बच्चियां हैं, चाहे वो शादीशुदा हो, उनके साथ रेप ही होता है. और एक बहुत महत्वपूर्ण चीज़ जो कहा गया कि ये जो हम शादी में रेप की बात करते हैं बहुत आम चीज़ है. हम सब जो घरेलू हिंसा की केस करते हैं उन सब में हम पाते हैं ये आरोप लगाया जाता है, पति लोग लगाते हैं अपने पति नहीं कहना चाह रही हूँ, अपने पार्टनर के ऊपर कि वो रेप करते हैं. और एक और महत्वपूर्ण चीज़ जो सुप्रीम कोर्ट ने इस केस में कहा कि ये कहना कि हम रेप को मान्यता दे रहे हैं शादी में, ये बहस देना कि रेप को शादी में रेप को मान्यता दे के हम शादी की संस्था को कमजोर कर रहे हैं, ये तर्क को अस्वीकार किया कोर्ट ने. और कोर्ट ने कहा कि आप ये नहीं कह सकते कि अब 15 से 18 साल की जो लड़कियां हैं वो उसकी पत्नी के साथ हम रेप को लीगल डिक्लेयर करें इसका मतलब ये नहीं कि हम शारीरिक संस्था को किसी भी तरह से कमजोर कर रहे हैं कहा कोर्ट में। और जो जस्टिस वर्मा कमीशन ये जो क्रिमिनल अमेंडमेंट आया उसमें एक प्रपोजल साफ साफ आया था कि जस्टिस वर्मा कमीशन ने स्पष्ट रूप से कहा था कि जो एक्सेप्शन है मैरिटल रेप का हमारे भारतीय दंड संहिता में उसको हटाया जाए और उसको अब तक स्वीकार नहीं किया गया। और विश्व भर में हम देखते हैं तो करीब 51 देश हैं जहाँ पे इसको हटाया जा चुका है। और फिर ओलंपिया के काफ़ी सारे जजमेंट्स का इंटरनेशनली अलग अलग देशों के सुप्रीम कोर्ट ने शादी में रेप को इलीगल घोषित किया है और उसको अपराध माना है। अलग अलग देशों में उसको अपराध माना गया है। पर इस सब पूरी चर्चा में जो एक बहुत जो सवाल उठता है और जिसका जवाब आसान नहीं है वो ये है कि आप शादी में रेप को प्रूव कैसे करेंगे, उसमें साक्ष्य कैसा होगा, कैसा साक्ष्य इकट्ठा होगा और उसमें फिर अदालत जो है वो फैसला कैसे करेगी। क्योंकि मुख्यतः जो है जो साक्ष्य होगा वो जो वाइफ का अकाउंट भी होगा, तो इस पर जो डाउट्स है। बट टेक्निकली एविडेंस एक्ट में जो उसका साक्ष्य है वो भी मान्य नहीं होगा। और फिर जो थोड़ी चर्चा हो गई वो ये बहुत कॉम्प्लिकेटेड था क्योंकि जो हमारे अपराध के अलग अलग श्रेणी होते हैं, कोई ज़्यादा गंभीर अपराध होता है, कोई कम गंभीर अपराध होता है, तो इसको इसमें कहाँ डालेंगे। क्या कुछ लोगों के मन में सवाल था कि क्या ये रेप भी उसी स्तर का रेप है। और फिर और इसके जो आखिरी में जो अभी चर्चा चल रही थी वो सहमति के ऊपर थी कि सहमति के अलग अलग स्तर होते हैं। और कॉलेज सर ने बताया कि सहमति को स्पष्ट रूप से परिभाषित नहीं है। आप उसको कोर्ट के कई सारे जजमेंट है जिसमें कहा गया कि लड़की ने स्पष्ट रूप से मना नहीं किया था। तो ये आज बहुत ही अच्छा डिस्कशन था और अभी में हमारा
hysterectomy is a major surgery performed on one or more of the female reproductive organs, usually involving the removal of the cervix, uterus, brood, fallopian tubes, or ovaries. It's invasive in nature and has major implications on a woman's fertility, and this generally makes it a last resort surgery, reserved for people who are no longer of reproductive age. Yet in states such as Andhra Pradesh, amongst rural women, it's the second most common surgery, and the average age is 29. So first I'd like to invite Narendra Gupta to speak. I'll just give a brief introduction on you. That's okay. So physician by training, Dr. Narendra Gupta has worked extensively at the grassroots level with tribal and other marginalized communities in Western India. He has been active in planning and implementing community-based healthcare models, training healthcare providers and community representatives in socio-epidemiologically informed healthcare delivery systems. For approximately 3 years, he directed and scaled up a very large volunteer-based program of the government in the state of Rajasthan to promote birth spacing. And 3 years earlier, he was a full-time advisor to CAPRT of the Ministry of Rural Development to incorporate disability and health concerns in the Rural Development Programme. He has advised and trained government health managers, administrators and the judiciary on gender and health, inequities in health and related issues. He was one of the most active members of the campaign for the universal free availability of essential and life-saving medicines, which led to a scheme for free medicines and diagnostics for all in the state of Rajasthan. And Dr. Narendra Gupta works with Prayas, which is a voluntary organisation at Chittagong and Centre for Health Equity in Jaipur. So, would you like to start, Narendra?
Thank you very much, Tyra. I was advised that I should speak more in Hindi than in English. So, I'll try to do. And सबसे पहले वो इतना इंटेंस जो ये सेशन हुआ मैरिटल रेप में सो मच ऑफ इंटेंस पार्टिसिपेशन, मुझको लगता है कि मैं इशू जिस पे बात करने वाला हूँ थोड़ा बोरिंग तो होने वाला है, बिकॉज आई कुड सी दैट सेशन एक्सटेंडेड टू additional 1 hour than the allotted time, so it shows lots of interest and lots of passion around the issue. जो मैं बात कहने वाला हूँ essentially वो है ये महिलाओं का गर्भाशय निकालने की बात. The term for it is called hysterectomy. तो ये महिलाओं का जो ये गर्भाशय निकालने का जो ये मामला है, I am sure a lot of you might have read somewhere in newspapers, कभी-कभी stories आती है मीडिया में कि बहुत जगह पे महिलाओं के गर्भाशय uteruses have been removed, and these have been removed if there is an indication for it, कोई medical indication है, they are removed, then of course fine. But a lot of it has come under notice that they were done for provider profit motivation. Provider profit motivation का मतलब है कि डॉक्टर को जरूरत नहीं थी उनको निकाल देने की, पर स्टिल उन्होंने निकाल दिए क्योंकि उनको कुछ कमा सकते थे, कुछ लाभ बना सकते, ऐसा वो कर रहे हैं. और उसके कारण से महिलाओं ने मतलब बहुत कम उम्र में अगर आपको यूट्रस निकल जाएगा और यूट्रस के साथ ओवरी भी अगर निकल जाएगी, ये जो निकालने की जो स्थिति होती है वो 2 तरह की होती है. एक तो ऐसा है कि केवल गर्भाशय निकालने और दूसरा गर्भाशय के साथ अंडाशय निकालने. तो ये निकालने के बाद फिर जो महिला का जो नेचुरल रिप्रोडक्टिव साइकिल है वो सारा का सारा डिस्टर्ब हो जाता है. क्या चीज़ वही भी डिस्टर्ब हो जाती है, एक तो ये है कि जो मेंस्ट्रुअल जो हमारा रिप्रोडक्टिव साइकिल है, मेंस्ट्रुअल साइकिल है, दैट इज फिनिश्ड ऑफ. उसके बाद वी वांट टू मेंस्ट्रुएट, तो मेनोपॉज हो जाएगा. अब अगर ये चीज़ एक नॉर्मल कोर्स में होती रहे तो नो इशू, नो प्रॉब्लम, नो वायलेशन ऑफ एनी राइट. पर इफ इट इज हैपनिंग फॉर प्रॉफिट मोटिवेशन and it is happening for no reason, there are no indications for us and still are happening, तो फिर इसका मतलब है कि ये मामला खतरनाक है और this needs to be taken note of, especially by the health system and also by the legal system. Both systems have to come in play in order to ensure that things begin to happen. This is exactly like सिजेरियन सेक्शन. जैसे सिजेरियन सेक्शन जानते ना आपके ना ऑपरेशन से बच्चा होना है, तो ऑपरेशन से जो बच्चा होना है वो आजकल ट्रेंड उसका बढ़ता जा रहा है. और वो ट्रेंड में भी आप 2 चीज़ें बहुत क्लियरली देखते हैं कि जो प्राइवेट हॉस्पिटल्स होते हैं उनमें अगर 100 महिलाएं डिलीवरी के गई तो 100 में से 50 की जो होगा वो ऑपरेशन से बच्चा होगा, और 100 महिलाएं जो गवर्नमेंट हॉस्पिटल में गई 100 में से 4 के लिए हो रहा है. मतलब व्हाट काइंड ऑफ डिफरेंस इज दिस हैपनिंग नेचुरली और देयर इज सम पैटर्न एंड दैट पैटर्न इज ड्रिवन बाय certain motivations, and whether these motivations are valid motivations or they are motivations for making something out of it. So hysterectomy is essentially something to say in the same line. What how has it all come? And then we also have filed a public interest litigation in the Supreme Court against most of the states of India. और उसमें यही सब किया कि आपको एक पावर पॉइंट है, आप दिखा सकते हैं. हेलो एक पावर पॉइंट वो कहाँ, वो आपके इसमें नहीं लगेगा. अच्छा पेन ड्राइव में तो मेरा क्या आपको लग जाएगा. मैं एक बात कहना शुरू में भूल गया, वो ये बात थी कि ग्रीक फिलोसफी बताती है जिसमें आपको सबसे ज़्यादा चिंताजनक बात है वो ये है कि दो चीज़ें हो रही है यहाँ इस देश के अंदर, दो चीज़ें हो रही हैं और ये महिलाओं के जो उनका सेक्सुअल एंड रिप्रोडक्टिव है राइट्स हैं उनका बिल्कुल बहुत ही ज़्यादा कहना चाहिए खतरनाक तरीके से उसका ये उल्लंघन हो रहा है, उसका वायलेशन हो रहा है। वायलेशन को आप इस तरह से समझिए कि जैसा सब लोग आप मान ही रहे हैं कि भाई हेल्थ इज अ पार्ट ऑफ योर फंडामेंटल राइट टू लाइफ और उसके अंदर हेल्थ केयर इज आल्सो योर फंडामेंटल राइट। विदिन हेल्थ केयर योर वीमेंस हेल्थ एंड मेंस हेल्थ इज आल्सो fundamental right. Within women's health, her sexual and reproductive health also is a fundamental right. And within sexual and reproductive health, right के अंदर you should have access to quality and ethical health care. But this is a violation of quality and ethical health care essentially. What is happening is in this hysterectomy in India, the number of hysterectomies performed so far in India are far less in comparison to, one could say, if we compare data with the countries of the West, where from the data is available, are far less. जितनी होनी चाहिए उतनी नहीं हो रही। पर जो हो रही है वो अपने आप में बहुत चिंताजनक है। चिंताजनक बात यह है कि if you see in the West, then you find that the average age at which these hysterectomies are performed is post-menopause 56 years. And here in India, the average age at which these hysterectomies are performed are 32 to 34 years. Means almost 14 years before the natural menopause. Almost 14 years before the natural menopause. And it's a cause of alarm. When we investigated this matter, by doing lots of fact finding, we discovered very alarming kind of situation. What happens is that in villages, there is a problem of menstrual hygiene and reproductive hygiene. There is this issue of early marriage, early pregnancy, with too many pregnancy at shorter intervals. मतलब बहुत सारे जल्दी शादी हो जाती है, जल्दी शादी के साथ साथ जल्दी बच्चे हो जाते हैं, कम अंतराल में शॉर्टर इंटरवल बहुत सारे बच्चे होते हैं और खूब सारे बच्चे होते हैं। मतलब 3 हो गया, अर्ली मैरिज, अर्ली प्रेगनेंसी, शॉर्टर इंटरवल प्रेगनेंसी एंड टू मेनी प्रेगनेंसी। फिर क्या होता है, देयर इज नो सिस्टम to maintain reproductive hygiene. So reproductive tract infections, I should have given you the background. Reproductive tract infections in India is one of the highest in the world. And one of the reasons for very high reproductive tract morbidity is essentially poor nutrition, mental stress and poor reproductive hygiene. These three things together contribute to this high reproductive tract morbidity. और उसके कारण से कंप्लेन तो आएगी, कुछ ना कुछ आएगा, लो बैठ की स्थिति आएगी या आपके लो बैठ की स्थिति आएगी या आपके मेंस्ट्रुअल कैओस होगा, मतलब इरेगुलर मेंस्ट्रुएशन होगा, कभी जल्दी होगा, कभी देर से होगा, बहुत ज़्यादा होगा, बहुत स्कैंटी होगा, समथिंग का सो वन कंप्लेन। अब जब हमने ये फैक्ट फाइंडिंग की, इन्वेस्टिगेशन की, तो हमने उन महिलाओं का इंटरव्यू किया जिनकी हिस्टेरेक्टोमी हुई, तो पता लगा कि वो गई, डॉक्टर ने देखा और उन्होंने कहा भाई आपकी तो सोनोग्राफी करनी पड़ेगी, एब्डोमिनल यूट्रस एरिया की, और देखना पड़ेगा कि क्या कारण है। उन्होंने सोनोग्राफी की, थोड़ी देर बाद उन्होंने सोनोग्राफी की रिपोर्ट आ गई। सोनोग्राफी की रिपोर्ट में कहा ये तो लगता है आपका यूट्रस गड़बड़ाने वाला है और लगता आगे कैंसर का खतरा है, इसको तो निकालना पड़ेगा। और निकाल दिया और 20,000 रुपया चार्ज कर दिया, 15,000 चार्ज कर दिया, 25,000 चार्ज कर दिया। एक तो ये कारण है, ये राजस्थान में है। दूसरा कारण जो वहाँ गुजरात में निकल के आया, वहाँ एक डॉक्टर सपना देसाई ने इन्होंने बहुत इंटरेस्टिंग इन्वेस्टिगेशन किया और पटेल कम्युनिटी है बहुत बड़ी, खेड़ा महसाना, ये लोग काफ़ी मिडिल क्लास पेजेंट लोग हैं। तो वहाँ की महिलाएं वैसे ही नहीं कि हाँ हमारे रिप्रोडक्टिव प्रॉब्लम है, तो उनसे पूछा अच्छा भाई आपके कितने बच्चे हो गए, कि 3 बच्चे हो गए, 4 बच्चे हो गए, और बच्चे चाहिए कि नहीं चाहिए, अच्छा अब और बच्चे नहीं चाहिए तो ये निकाल देना चाहिए क्योंकि पता नहीं कब आपके कैंसर में बदल जाए, खतरनाक चीज को अपने पेट में क्यों रखने को और आपको जो ये हर महीने जो और ये परेशानी झेलनी पड़ती है सबसे पीछे छूट जाएगा और आप इसको तो वहां उन्होंने इस चीज में कहते हैं उनको कन्विंस कर दिया कि देखो ये खतरनाक चीज को रखो, मतलब एज ए यूट्रस इज अ dispensable commodity or why should you unnecessarily keep it when its function is over? Its function was to, have a baby. All those things are over now. Why do you need it? तो वो उसको उन्होंने वहाँ से आया और वहाँ पे बहुत बड़े पैमाने पर छत्तीसगढ़ में एक अलग तरह का हुआ, वहाँ पे एक राष्ट्रीय स्वास्थ्य बीमा योजना भारत सरकार ने चलाई थी। तो राष्ट्रीय स्वास्थ्य बीमा योजना में कोई भी महिला किसी भी अपनी ट्रीटमेंट के लिए गई और उसको उन्होंने सीधा लिंक कर दिया कि भाई आपने तो ये यूट्रस का मामला गड़बड़ा गया है और उसके कारण से ऑल दीस थिंग्स आर हैपनिंग, सो योर यूट्रस इज हैपनिंग और उनकी यूट्रस उन्होंने वहाँ निकाला। अब इसमें क्या है कि बहुत ज्यादा शोर इसलिए नहीं मच रहा है कि दिस इश्यू इज सो फार मोर इनटू विलेजेस, मोर इनटू द फैमिलीज व्हिच आर नॉट सो वेरी वेल ऑफ। Of course, in Gujarat it is having negatively in the sense कि महिलाएं finally consent कि हाँ ये चलो अपना चलेगा, but then there are side effects of it. The side effects of it are these कि एक तो आपकी bone density है वो कमजोर हो जाती है क्योंकि आपका हार्मोनल लेवल से वो कम हो जाते हैं पोस्ट हिस्टेरेक्टमी, और उसके अलावा फिर आपका इमोशनल डिस्टर्बेंस भी हो सकते हैं, सारी चीजें सारी तो हमने जो केस लगाया क्योंकि these women in Rajasthan initially said कि साहब we had not gone there for getting our uteruses removed, हम नहीं चाहते थे कि हमारी यूट्रस रिमूव करें, पर उन्होंने एक तरह से हमारे ऊपर दबाव डाला, हमको डराया, हमको घबरा दिया, हमको घबरा दिया और घबराने के बाद तो ये हाँ थोड़ा सा और नीचे करते थे और थोड़ा नीचे कर दीजिए। ये देखिए ये फोटो ऊपर चला ये टेकन द कंसेंट्स और तो ये महिला है, बच्चे उसके 3 हैं और वो केवल उसका एक 15 साल का बेटा है, एज उसकी पता नहीं है पर लगभग अराउंड 35 और 40 के बीच में उसकी है और वो गई थी हॉस्पिटल में ट्रीटमेंट लेने और फिर अल्टीमेटली उसका कुछ हुआ नहीं वहाँ से और फिर वो प्राइवेट में गई और प्राइवेट वालों ने कहा भाई आपका कोई करना पड़ेगा। ऐसे ही महिला है उसका भी दिखा रही है Yeah, just go down. Yeah, this is another. So there are several such accounts. So what I am essentially saying is that there is no system, no pattern, कोई तरीका नहीं है कि किस तरह से करें और ये अनएथिकल तरीके से ये सारे केसेस चल रहे हैं और इसके ऊपर बहुत स्ट्रिक्ट कंडीशंस लगाने की जरूरत है। तो हमने 2013 में एक कॉन्सल्टेशन किया था दिल्ली में, HRL, प्रयास, हेल्थ वॉच ट्रस्ट एंड यूएनएफपी, उन चारों ने भी ये किया था और उस चारों में हमने और थोड़ा नीचे जाइए डॉक्टर सपना देसाई का प्रेजेंटेशन है जिसमें आप और जाते हैं काफी नीचे जाना है, काफी नीचे जाना नहीं और नीचे ये वो ऑक्सी जो है फेडरेशन ऑफ ऑब्स्टेट्रिक्स एंड गायनेकोलॉजी उनकी जो प्रेसिडेंट थी उनका है वो तो रविंद्र टंडन के साथ कह रहे हैं हम लोग सेव यूट्रस कैंपेन चलाने के लिए गया हूँ आगे और नीचे चलिए और नीचे चलिए और नीचे चलिए और नीचे और हाँ ये थोड़ा और तो हाँ थोड़ा ये देखिए स्टडी पॉपुलेशन और नहीं मैं और बताऊँ और हाँ ये तो आप ये देखिए स्ट्रैटेजी मीनिंग रीजन फॉर ये एक उनका स्टडी था फिर नीचे जाइए और नीचे और नीचे और नीचे और नीचे तो उन्होंने देखा कि स्ट्रैटेजी जो इंश्योर्ड मिले हैं उसमें ज़्यादा हो रही है और दूसरों में कम हो रही है और एक जो बहुत इम्पोर्टेंट बात है जिसको हमको समझना चाहिए वो ये है कि आपने कल स्टेरिलाइजेशन फोर्सफुल स्टेरिलाइजेशन बहुत हो गया है women have been subjected to tuberculosis and most of these tuberculosis were conducted in camps और camps में भी एक साथ 50, 60, 70 and the instruments are not properly sterilized and that has led to lots of infections and these infections ultimately have been ये infection मुख्य रूप से इस चीज के रीजन रहे हैं कि उनके रिप्रोडक्टिव ट्रैक्ट मॉर्बिडिटी बढ़ी रिप्रोडक्टिव ट्रैक्ट मॉर्बिडिटी बढ़ने के कारण से they went and वो जाके डॉक्टरों को मिली और डॉक्टरों ने हिस्टेरेक्टमी कर दी और थोड़ा नीचे जाइए और थोड़ा ये तो ये है कि विमेन्स बॉडी ज्यादातर आप लोगों ने सबने देखा होगा तो ये सब ये यूट्रस का हिस्सा है वो फेलोपियन ट्यूब में ये यूट्रस को सारे के सारे वो निकाल देते हैं और ओवरीज है दोनों इनको भी वो दोनों के सारे निकाल देते हैं और एक नीचे जाइए तो जो सब स्टडीज बताती है कि 1/3 hysterectomies are unnecessary in the world, not only in India, इंडिया में नहीं बल्कि पूरे दुनिया में 1/3 और इंडिया में तो ऑलमोस्ट 2/3 hysterectomy मतलब 100 हो रही है तो 70 hysterectomy आप ये मानिए कि जो unnecessary है जिनकी कोई आवश्यकता नहीं है कंजर्वेटिव ट्रीटमेंट से हो सकती है पर केवल पैसा कमाने के लिए प्रैक्टिस करते हैं प्रैक्टिस और कि हम प्रैक्टिस करें हिस्टेरेक्टोमी करें और रिकॉर्ड बनाएं हमारा देखिए हमने इतनी हिस्टेरेक्टोमी कर दी सबके लिए वो है सारे हिस्टेरेक्टोमी करें तो ये हमने जो फाइल किया केसेस उसमें बहुत इंटरेस्टिंग सी बात है छत्तीसगढ़ की गवर्नमेंट ने हमको रिप्लाई में बताया कि हमने एग्जामिन किया कि इंडियन हॉस्पिटल्स में बहुत हिस्टेरेक्टोमी होती है और फिर उन हिस्टेरेक्टोमीज को लेकर के हमने वो डॉक्टर्स हैं उनके लाइसेंस कैंसिल कर दिए तो हमने लाइसेंस कैंसिल कर दिए तो उन्होंने हमारे को वापस पिटीशन किया और जब पिटीशन किया तो हमने एक और कमेटी बनाई और उस कमेटी ने कहा कि नहीं तो मुख्य बात यह है कि जो जबरदस्ती हिस्टेरेक्टोमी करने की जा रही है ये विमेन हेल्थ का क्लियर वायलेशन है इसके लिए बहुत स्ट्रिक्ट गाइडलाइंस की जरूरत है इसके लिए बहुत ज़्यादा ये चीज़ की जरूरत है कि हम किस प्रकार से इसके ऊपर एक रेगुलेटरी फ्रेमवर्क बनाएं एक सिस्टम बनाएं और अगर इस तरह के कोई वायलेशन होते हैं इट इज एग्जैक्टली लाइक अ रेप जैसे रेप इज असॉल्ट ऑन वुमेन एग्जैक्टली हिस्टेरेक्टोमी इज आल्सो असॉल्ट ऑन अ वुमन व्हिच इज ऑफ अ डिफरेंट काइंड ये अननेसेसरी हिस्टेरेक्टोमी is like doing unnecessary rape. It's like a rape. तो इसको उसी स्पिरिट से उसी पैटर्न से हमको इसको लेना चाहिए था तो मुख्य रूप से मैं हिस्टेरेक्टोमी के बारे में यही बात कहना चाहता था कि सारी की सारी जो है वो ज़ाहिर है कि जब आप लोगों को जो फोल्डर भेजे हैं उसमें पूरी रिपोर्ट है और आप उस फोल्डर में भी आप इसको पूरा कर सकते हैं पूरा डिटेल में देख सकते हैं कॉलेज में उन्होंने आई एम नाउ कॉलेज में मुझे ये कहा था कि मैं आपसे कुछ और बात करूँगी पब्लिक प्राइवेट पार्टनरशिप इन हेल्थ केयर हेल्थ सिस्टम ऑफ एक पैटर्न बनता जा रहा है इस देश के अंदर और उस संदर्भ में अभी गवर्नमेंट ऑफ इंडिया है वेरी रिसेंटली अनाउंस इन द बजट इट अनाउंस अ स्कीम कॉल्ड एट आयुष्मान भारत नेशनल हेल्थ प्रोटेक्शन स्कीम नाउ इट इज कॉल्ड नेशनल हेल्थ प्रोटेक्शन मिशन तो वो उन्होंने वहाँ पर चालू किया है और उसके अंदर पब्लिक प्राइवेट पार्टनरशिप के नाम पर वो लोग इंश्योरेंस मॉडल बढ़ा है तो जो ये इंश्योरेंस मॉडल है ये ऑलरेडी इस देश के अंदर फेल हो चुका है पर फिर भी उसको बढ़ाया जा रहा है और the tendency is to privatize the healthcare system, commercialize the healthcare system and make the health system as कैटेगरी ऑफ पीपल और वो भी कोई बहुत क्लियर होने वाला नहीं है कि किस प्रकार से वो होगा। तो स्थिति हमारे यहाँ पर एक्सेस टू क्वालिटी हेल्थ केयर विच इज अ basic fundamental right of every human being in this country is completely getting eroded. What it was is further getting eroded and decaying. तो ये उसी कॉन्टेक्स्ट में हमको देखना चाहिए कि कैसे हम इसको चैलेंज करें थ्रू लॉ, थ्रू कम्युनिटी एक्शन, थ्रू मीडिया, पब्लिक मोबिलाइजेशन, ये सारी की सारी चीज़ें हैं। वी हैव टू हाईलाइट दिस। शायद कमरा जी ने कल कहा था कि लॉ इज वन थिंग, कि लॉ विल टेक इट्स ओन कोर्स एंड फाइल, but then we also have to support our law, whatever we petitions we file through our force of public mobilization. Unless that public mobilization is not available, the court will also take a very lenient view or a very different view of the whole thing. But if there is a public pressure, media pressure, then court also basically coordinates it. तो ये स्थितियाँ काफ़ी हमारी गंभीर है in terms of access to health care, various access to health care becoming far more difficult and complex. और not only from the perspective of the non-availability of adequate financial support, but also because of the nexus which service providers have with pharmaceutical companies and medical devices companies and whatnot. तो ये एक अपने आप में बहुत चिंताजनक स्थिति है और हमको ये सब चीज़ें उसी चीज़ पे देखना चाहिए। और तो ये इश्यू ऑफ अननेसेसरी डिस्ट्रैक्टिविटी है, उसके ऊपर हमको कंट्रोल और रेगुलेशन बनाने की पूरी कोशिश चाहिए थ्रू द प्रोसेस ऑफ लॉ एंड थ्रू पब्लिक मोबिलाइजेशन। थैंक यू। ये स्पीकर जो है मिस्टर आदित्य श्रीवास्तव, तो मैं आदित्य श्रीवास्तव has been working on the right to food for over 6 years in different roles and capacities. His work as the district advisor of the Supreme Court Commissioners on Right to Food in India. Aditya has also been working on several cases related to right to food and also assisting the senior counsel in the right to food case in the Supreme Court. And when I understand the senior counsel is Mr. Colin Gupta. He is a member of Right to Food campaign in India, which is a nationwide network of organizations and actors. His key area of interest are legal and policy interventions and issues of poverty, food security, urban homelessness. Aditya also coordinates this CSO support cell, that is this civil society organization support cell, which is an initiative to address the shrinking spaces of spaces for civil society and other non-governmental organizations. He is also a manager of Civic Participation Initiative, which provides strategic and technical support to community leaders and grassroots human rights activists. Aditya is here. And then we have another speaker. Her name is Albertina Almeida, if I said it correctly. And she is from Goa. And she will also be talking about access to food, food security, and food sovereignty or something of this type. Okay. So we have two very distinguished speakers, and then I will not say anything further at this moment. And I invite Aditya to speak first.
Good afternoon, everyone. Sorry, this is a personal session. I know all of you might be slightly done and want to close off, but I'll try to make it as interesting as possible. The title, since we are also focusing on maternity benefits in this session itself, I will go into a little detail about the maternity benefits. But before doing that, I just wanted to give a broad overview of what the concept of right to food is. And especially, मैं थोड़ा ये में भी बात करता रहूँगा बीच में जैसा आपको सबसे पहली बात तो ये कि I'm really glad that this issue has been covered in this conference because जो जेंडर एस्पेक्ट है फूड सिक्योरिटी का उसको हम लोग नजरअंदाज कर देते हैं. Just when we work on the field, we realize that it's actually women who take charge of, again, gender role, but you can't help it. They're in charge of the kitchen and rations, public distribution system, rations, feeding children, all these aspects are actually handled by women in the household. तो ये भी देखते हैं कि इस वजह से महिलाएं जो हैं वो काफ़ी ज़्यादा इकट्ठा होकर के जहाँ में हमने जो part of right food campaign, and you would actually see that out of 3,500 members in the campaign, you would see that close to 2,500 members are women, and they're also very active in demanding their rights. So just giving a very short overview, the right to food case which I had worked on earlier with Colin and Cruz covered several schemes, and over the course of 17 years, since 2001 to 2017, काफ़ी सारे schemes थी जिनको कोर्ट ने मॉनिटर किया, and because of this monitoring, there has been significant development, significant improvement in functioning of these schemes and implementation of those, which were public distribution system, ICDS, which is meant for children and pregnant and lactating women, midday meal scheme, and there was earlier some maternity benefit scheme, which were national maternity benefit scheme and MBS, introduced in 1995, reduced the parcel by 500 rupees cash in entitlement used to be given. And later on, all of this it codified in the National Food Security Act. So, just look at the preamble. The Food Security Act came out 2013, was enforced in 2013. So, if you just look at the preamble of the Act, it says that the Act envisages what a life cycle approach, which means right from the womb to your tomb, you would be, the state would ensure that at least your food security needs are being provided for. And which will essentially mean that right from the stage when a woman is pregnant and is bearing a child, there would be some sort of entitlement to provide food and nutrition security. From there to then once the child is born, it goes to Anganwadi center, is being fed there, other services available at Anganwadi centers as well. And then further, if they go to a government school or a government sponsored school, then they would be provided free meals. Covering this now, I'd like to, I'm going to speak a little bit more about all other entitlements, but I just want to cover maternity benefits issue in a little bit of detail because we are short on time as well. I would want to stick to the topic of the discussion. So, apart from all the schemes which were there, which were being monitored by the Supreme Court in the right to food case, one new entitlement, which was a significant increase from earlier entitlement, was a maternity benefit cash entitlement of 6,000 rupees, which used to be earlier 500 rupees or 1,400 rupees under different schemes. But the Act said that every pregnant and lactating mother should get a minimum entitlement of 6,000 rupees. Now, there was earlier a scheme which was IGMSY, Indira Gandhi Marital Suraksha Yojana, which was being implemented on a pilot basis in 53 districts since 2010, which attempted to cover similar entitlement, but the amount was slightly lower. After the Act came into force, and the date was, next month it's going to be 5 years since the Act came into force. On 5th of July 2013, the cash entitlement rose up to 6,000 rupees and was supposed to cover as a wage as a wage compensation. And also to provide nutrition, because when a mother is pregnant, it would be better that there is also some cash available to purchase food as per her desire. So the cash entitlement was 6,000 rupees. However, even as of now, and I'll come to that a little later, even as of now, that entitlement is not being provided. Not to the extent that the Act had envisaged to be. So since the scheme was being implemented only in 53 districts, and there's been a central act which should have been covering all states, all districts, and all women as the act says. But since it was not being done, we had challenged non-implementation of this particular scheme or this particular entitlement. ये जो 6,000 रुपए का मातृत्व भत्ता है, क्योंकि ये दिया नहीं जा रहा था महिलाओं को, और 2 साल हो चुके थे जब एक्ट के आने के बाद 2015 में हमने जा करके PUCL के बिहाफ पे पिटीशन डाल करके इस चीज़ को कोर्ट में लेकर के गए कि मातृत्व भत्ता नहीं मिलता है. चैलेंज दिस एंड वी वेंट टू सुप्रीम कोर्ट, filed a petition on behalf of PUCL and said that this amount should be paid to every woman. The petition is still pending, but there have been some developments since then, and these developments are again regressive. ये जो कुछ बदलाव हुए हैं कुछ सालों में, वो और भी ज़्यादा इस एक्ट को और इसके प्रोविजन को डाइल्यूट करने के लिए हुए हैं. तो उन बातों पे भी मैं आऊँगा कि जब 2013 से लेकर के 2016 के दिसंबर महीने तक या 2017 के जनवरी तक, जनवरी 2017 तक ये एक्ट जो है 53 ये जो एंटाइटलमेंट है 53 डिस्ट्रिक्ट तक ही लिमिटेड रहा. एंड फाइनली इन 31 December 2016 Narendra Modi, the Prime Minister, made an announcement that it's going to be expanded to all through pan-India expansion of this entitlement. पूरे देश में महिलाओं को ये मतलब भत्ता देना शुरू किया जाएगा. और उन्होंने साथ साथ ये भी कहा कि विल मेक बजट एलोकेशन, उसके लिए बजट भी दिया जाएगा. तब हमने बजट की गणना करी, उसकी बजट कैलकुलेशंस किए, एंड वी रियलाइज दैट द बजट वाज नॉट एडिक्वेट. As against the requirement of say 14,000 crore, not say actually, if you just multiply total number of pregnancies, which is around 2.4 crores per year, with 6,000 rupees, and I'm just talking about the cash entitlement aspect, we're not looking at the operational issues here. There was a requirement of 14,000 crores, against which there was an allocation made of only about 2,700 crore. And in subsequent budgets as well, even including the current budget, actually in the current budget they have reduced the budget allocation further to 2,400 crores from 2,700 crores. The government says that this reduction is because we are aiming to cover 50 lakh women per year. While it is evident and it is clear, if you look at just the population estimates or population figures, you will realize हर साल 2.5 करोड़ महिलाएं जो है वो गर्भवती होती हैं. तो 2.5 करोड़ महिलाएं अगर गर्भवती होती हैं, 2.5 crore women who get pregnant every year, how do we intend to cover and cash entitlement is supposed to cover all women? How do you set a target of just 50 lakh women? So all those modalities are also then provided in the new scheme which was announced by the Prime Minister. The new scheme is called, and it has replaced all other schemes, is called Pradhan Mantri Matritva Vandana Yojana, which in different installments would pay 5,000 rupees cash entitlement to all women. The remaining 1,000 rupees is supposed to come and it is quite absurd that a scheme like this would say that on an average, there would be an additional 1,000 rupees would come from another scheme. And on an average, for a scheme this big and this important, you cannot have such arbitrary terms saying that on an average you may be able to get this. So the other remaining 1,000 rupees on an average is supposed to come from an existing scheme, which is the Janani Suraksha Yojana, which was actually the objective of that scheme is to promote institutional deliveries and it is not focusing on meeting nutritional needs of pregnant women. So then we tried to calculate how do we reach at this figure of 50 lakh which the government wants to cover, and what are the modalities, comparing it with the modalities within the scheme. So the first thing which I said that if you were to cover, if you were to pay 1,000 rupee on an average, the cash entitlement under the Janani Suraksha Yojana is actually 1,400 rupees for low performing states and 700 rupees for high performing states. But even if you look at that, women, I have the figures here, if I can just run through it. If you look at that, there are only 36.4% women who are actually receiving this Janani Suraksha Yojana entitlement, despite the fact that 78, close to 79% women are going in for institutional delivery. So there's a huge shortfall in implementation of Janani Suraksha Yojana as well, which has been running since 2005. Then you come to the main scheme, which is the Pradhan Mantri Vandana Yojana. It says that women would receive their first installment when they register themselves at the Anganwadi center. So the government data itself, official data itself says that 11% of women actually do not register themselves at Anganwadi center. Then you come to the next installment, which is of 2,000 rupees. Next installment is supposed to be paid at when the woman receives her first antenatal checkup. Government data again says that 46% rural women and 31% urban women never have that antenatal checkup, which would actually mean that 1.15 crore, or a little more than 1 crore women would be excluded from this cash entitlement of 2,000 rupees of second installment. Come to the third installment, there are two requirements there. The first one is that the birth, and this is post-birth, post-delivery. The childbirth should be registered, and the second one is that the child should have received all the vaccinations especially mentioned. So 78 lakh women would be excluded because their childbirth was not registered. If we go by the current official data, 1.6 crore women would be excluded, are being excluded actually in effect, because their child did not receive the vaccinations which are prescribed for within the scheme. And most damaging of all these conditions is are actually two more conditions. One is the one child norm. Earlier there used to be a earlier scheme used to have a two-child norm, which said that women would receive these cash entitlements only for first two live births and the third delivery or third pregnancy. At the time of third pregnancy, they would not receive such one. But government has further reduced it to just one child now. So only the first child or at the time of first delivery, women would receive this entitlement. Again, if you look at the official data, 46% children, only 46% children are the first order of birth. You would be excluding 54% children who are actually at a higher risk of being malnourished because it's a second pregnancy and the woman is already legal. You would have excluded another 54%. The effect of the last condition I would come to is that a girl, if she is below 19 years of age, she would not she would not be eligible for this entitlement at all. Which essentially means that this is again data. If you just look at during an NFHS survey, when the officials went and surveyed, they realized that 15 girls within the age group of 15 to 19 years, 5% of those girls are already pregnant. I know we have several sessions. We're going to be talking about child marriage act as well, prohibition of child marriage act as well. We've already talked about population control measures of government. See, both these conditions are actually again putting more vulnerable sections at risk. Are actually putting more vulnerable sections at risk, जिनको बहुत ज़्यादा ज़रूरत होनी चाहिए या जिनको बहुत ज़्यादा ज़रूरत है, उन लोगों को आप इस एंटाइटलमेंट से वंचित कर रहे हैं। आप इनको अलग अलग कारण दे करके, तो जो 3-4 मैंने कारण बताए थे, वो मैं फिर से एक बार डेटा जो दिया था तो फिर डेटा पॉइंट हो जाएगा। फिर से मैं आपको वो 3-4 कारण हिंदी में भी बता देता हूँ कि जब आप प्रेगनेंसी का पंजीकरण कराते हैं, गर्भावस्था का पंजीकरण कराते हैं, तब आपको पहले 1,000 रुपये मिलना चाहिए। फिर उसके बाद जब आप एंटीनेटल चेकअप कराते हैं तब आपको 2,000 रुपये मिलना चाहिए। और तीसरा इंस्टॉलमेंट बच्चा पैदा होने के बाद तब मिलेगा जब आप बच्चे के बर्थ का पंजीकरण कराएंगे और उसको सारे वैक्सीनेशन, सारा टीकाकरण उसका करवाएंगे, तब जाकर के आपको आपकी इंस्टॉलमेंट 2,000 रुपये का मिलेगा। और आखिरी कंडीशन जो है वो तो हरी जगह सबसे कही हो गई है कि आधार जो है वो मैंडेटरी है स्कीम के अंदर में। ये सारी चीज़ें जो है हम लोगों ने अपने पिटीशन में जो सुप्रीम कोर्ट में डाला है उसमें बड़े टैक्टफुली चैलेंज करने की कोशिश करी है और उसकी हियरिंग्स भी अभी चल रही हैं, डिसीजन नहीं आया है। पर क्योंकि ये यहाँ पे हम लोगों को इस बारे में भी थोड़ा सा सोच विचार करना पड़ेगा कि हम लोग हाईकोर्ट के स्तर पे या बाकी लीगली इसको कैसे मुहैया कराया जा सकता है, क्योंकि सरकार ने तो अपना इंटेंशन जो है वो क्लियर कर दिया है कि हम इतना ही पैसा दे पाएंगे, पर किसी न किसी तरीके से महिलाओं के लिए कम से कम ये पैसा निकलवाना पड़ेगा। तो कुछ बल्कि मैं चाहूँगा देवस्मिता निकल के लेना शायद उन्होंने गुवाहाटी हाईकोर्ट में कुछ इंडिविजुअल पिटीशंस डाले थे गर्भवती महिलाओं को लेकर के। They filed a couple of cases in Guwahati High Court and they got favorable orders. But these were again individual cases and these were cases where those women fulfilled all the conditions which are laid down within the scheme. A good way to go would be if we could conduct some sort of survey or maybe even an individual for each of these conditions. So, for example, if there is a government says or the scheme says that there is a one-child norm, we could always go to approach the court saying that this is my second pregnancy, or as a child you could file as a child born second order or third order, you could file a petition on their behalf saying that why am I not being given this right? Conduct a survey or find 10 such people who have not been given this entitlement because of any of these conditions which I enumerated, and just approach the court, maybe in a PIL, maybe in an individual petition, but anywhere, in any state. All of this would help us really build the jurisprudence which maybe we could even take to the Supreme Court, saying that we have so many orders from different high courts saying that this person was deprived because of this conditionality. I think I'll cover the rest of it during the question answer session. I will also give some time.
Thank you, Aditya. So now I introduce to say
basically, I'm not going to speak about the Food Security Act and maternity benefits because that's covered by it. But just to kind of add anything before I move on, is to say that the Anganwadi workers are tasked with with the task of putting the individually functionally kind of accesses these women. And there is where when we interact with Anganwadi workers, they often tell us that their major hassle now is the Aadhaar card, because you need to have an Aadhaar card. They need to make an Aadhaar card because for benefits, it's compulsory to have Aadhaar. Although the Supreme Court has kind of held back on the Aadhaar card generally, but when it comes to beneficial schemes, it's compulsory to have Aadhaar. So everything collapses there, because if a person doesn't have an address, for example, in the sense that they are afraid or something, and the landlord doesn't have a clearly to give them, for example, a document to say that they live in that house, etc. They have nothing. They can't make an Aadhaar card. And if they can't have an Aadhaar card, they cannot access these schemes. So although it may not seem very directly connected, but I think it's a key issue when it comes to accessing any schemes for women, which have been, even if they are progressive schemes, you cannot access those schemes without an Aadhaar card. So I think that's a very key area that we really seriously need to pay attention. Having said that, I would also like to look at, the Food Security Act, first of all, defines food security as supply of food grades. I don't think that supply of food grades by itself is anything about food security by itself, because you can't live on food grades alone. So you can't really even, it doesn't even talk of the quality of the food grades or anything like that. So there is a problem there as far as the Food Security Act is concerned. Now, but let's take what it talks about itself. The Food Security Act is talking about food security in terms of supply of food grades. Like Aditya said, that's not happening. So therefore, now the Food Security Act has got mechanisms inbuilt in the Food Security Act which are meant to monitor this. Why is it not happening? Ensure that it happens, etc. So you have these, for example, you have the district grievance redressal officer. So somebody has to be appointed as the district grievance redressal officer. Then you have to have, there have to be district vigilance committees, district and taluka vigilance committees, which can complain to this district grievance redressal officer. Now, if you also have the State Food Commission. So the thing is that for this act to be implemented, to ensure that this act is enforced, to ensure that this act is implemented, all these mechanisms need to be in place. We need to remember that every woman cannot rush to the High Court with a writ petition or a public interest litigation or anything, whatever you call it. That's not access to justice. So for a woman to be able to access justice, you need something closer home if she has a grievance. So that earlier that was not there. Now the Food Security Act takes care of that. There is a mechanism. So if that mechanism is there, but if it's not set up, or if it's absolutely inadequate, I do not know about the other states, but in Goa, for example, the State Food Commission Goa State Commission for Women is entrusted with the task, but the Goa State Commission for Women is itself not properly functional, and they are entrusting this, so they are like supplying, other responsibilities on existing bodies and in that sense. So the whole thing fails because if you can have a good, great law. First of all, it's not all that great, but to the extent there is something that itself cannot be delivered because the mechanisms are not operational and something needs to be done. Of course, the Supreme Court has issued directives, and because of that, they have now, for namesake, Namki Vasta, they have set up these, like you have the State Food Commission here, for example, the Women's Commission is asked to do it. You have the Vigilance Committees, the Consumer Protection Council operates as the Vigilance Committees. So they just pass one line kind of order, which say, okay, this body will now operate also as this. So this is a very extensive thing which requires attention, and it's not as if these other bodies are functional. If they were functional and
they are not functional and they're kind of casting this responsibility on these bodies. So that's a serious problem, I think, because then if you can't monitor, this thing will not function. If you can't enjoy enforcement, if you can't monitor. So this is one aspect. So for women especially, this access to justice is critical. They cannot access it because the systems are not in place, it collapses there itself. Now the other aspect is that what the Food Security Act does not cover. What about, each place, again, I'm arguing for specific concerns in each area, and different people have different foods as their staple diet. For example, in Goa, we do have fish as a staple diet. So, food security would be availability of fish, for example. So it's not about food security only in terms of food grades. You cannot live, just like you can't live on love and fresh air, you can't live on food grades alone. So the argument for a right to life, we will still have to approach the issue under the Constitution to ensure the remaining aspects of food security are guaranteed, because this is limited in terms of what kind of food security is provided through the Food Security Act. Now, if you are talking of this larger sense of food security, then you get into a whole lot of other issues as well. That there is a depletion of resources. Now, there are certain, let me just also go back to the constitutional framework. There are certain rights already guaranteed. I suppose you are mostly lawyers and you all know about fundamental rights and directive principles, and I don't need to talk about that. But, so as you would know, the critical difference is that as far as fundamental rights, they are guaranteed, and directive principle is something that the state can gradually enforce. So now, the state has said that it is guaranteeing the provision of food grains, right? So it cannot regress on it, because there are judgments which say that you cannot regress on rights that have been guaranteed which were initially fundamental principles, but have been gradually guaranteed. So if you cannot regress on it, the state cannot carry out acts which result in depletion of resources, depletion of the stock of food grains. You cannot have that. So now, if you look around at the various, so I think we need to be questioning this, because it's not, they are actually regressing. In the name of saying you provide this is being given like some charity, and then as Aditya said, you may take 1,000 from some other scheme, etc. But what about the whole, retreat by the state in terms of its obligations to ensure protection of the resources? So when, for example, you have a development model or development projects which result, whether it's because of mining, whether it's because of transportation, for example, in coal transportation, which is going to, the scale at which it is being proposed now, it's going to completely destroy the food sources. So what kind of food are you going to get? You're going to get food which is unsafe. So that kind of regressing of the food security, the going back on the food security, because just having grains which are completely polluted is not food security at all, even in terms of grains. And I'm also talking about depletion of other resources like fish, etc. So I think we need to grapple with this and the whole burden that is cast on women there too, because women, I do not believe that it's the function of women to take care of health or to provide get pensions, etc. But I think that historically that's what women have been doing. We need to recognize that work, and so since women have been doing that work, the burden is, there's an extra burden cast when people are having to consume polluted food, etc. So therefore, I think we need to recognize all this various invisible work that women do, and we need to make out a case for a wider concept of food security, and on the one hand, and on the other hand, we need to make out security and how this impacts various sections, especially marginalized sections such as women. I think I'll stop there.
Thank you very much. Before I open up the house for questions, let me answer a bit into it. Somebody, just a couple of days back, newspaper reported that somebody found out Albert Einstein died. What he knows about people of India, China and India, China and Sri Lanka, कि ऐसा लगता है कि वो पता नहीं में अपनी बातें भूल जाते हैं. This is what Einstein had said. Einstein was, he said that this racial thing is a disease of white people. So he was not a person that believed in these kind of stereotypes. पर उसने ये कहा तो मैं भी सोचने लगा कि यार ये उन्होंने ऐसा कहा क्यों, क्या कारण क्या है. The fact of the matter is this कि समस्या हमारी ये right to food और food security और nutrition की इतनी ज़्यादा है कि आप और हम उसको जो इतनी बड़ी साइलेंट इमरजेंसी चल रही है उसका हम कुछ अंदाजा ही नहीं लगा सकते. सबसे बड़ी बात तो यह है कि अभी जो हमारा राइट टू फूड के अंदर जो नेशनल फूड सिक्योरिटी स्कीम या एक्ट है उसके अंतर्गत बहुत सारी स्कीम है. जैसा आदित्य ने बताया PDS की स्कीम है, PM-YY का है, प्रधानमंत्री पर जो कि वंदना वो है, फिर MDM है, फिर ICDS है, सब कुछ है. पर जो सबसे जो महत्वपूर्ण बात है वो ये है कि इन सारी चीज़ों के होने के बावजूद भी आप देखिए कि more than half the women are enemy, more than half the children are enemy, almost 1/3 number of children are underweight and stunted and grossly undernourished, almost 10% children are severely acute malnutrition. और जो सबसे खतरनाक, सबसे जो ज़्यादा डेंजरस चीज़ हो गई है वो ये, and that is the government data I am quoting, that children from 6 months to 23 months, only 9% children in this country are getting adequate diet. एक तो आप ये बात जान लीजिए कि किसी भी व्यक्ति का क्या फिजिकल ग्रोथ होगा, क्या मेंटल ग्रोथ होगा, that all gets determined in the first 1,000 days of life. And these first 1,000 days begin from the conception. A child is conceived in mother's womb. So 270 days there and 730 days after the birth. These are the most important time period. And during this time period, nothing significant is being done as far as the nutrition is concerned. महिला को ICDS से take home ration मिलता है, hardly anybody, I don't know how many women eat, how many women even access. Then बच्चा जो है up to 3 years, there is no provision except the take home ration from 6 months to 3 years. And after 3 years, जब सब कुछ खत्म हो चुका है, almost everything is over about his future growth or her future growth, then you begin to start hardcore meal for the child. तो ये सारी की सारा जो सिस्टम अभी चल रहा है ये बहुत गड़बड़ चल रहा है सिस्टम एंड इट नीड्स मोर. और वैसे तो मैं जन स्वास्थ्य अभियान में उसमें काम करता हूँ तो डेडिकेशन ऑफ आवर स्पेक्टेड मेंटल की सेक्रेटरी डिपार्टमेंट में होम अफेयर्स सेक्रेटरी वो नीति आयोग वाले तो सुनने में तैयार ही नहीं. तो हमने सोचा जो पैसा देता है उनको जाके पकड़ लें. तो उनको मिलने गए तो उन्होंने भी कहा बात तो सही है पर साथ समस्या है कि WCD मिनिस्ट्री से एजुकेशन और WCD मिनिस्ट्री का आंगनबाड़ी का सारा काम बदलना, these are all quite challenging things and may take time. तो कहने का तात्पर्य ये है कि हम बच्चे को जिस दिन से वो पैदा हो रहा है, जिस दिन से उसका बीज बन रहा है मदर्स होम, तब से लेकर 3 years तक unless we do not ensure nutrition security, we are losing on everything else we do later on. That is not going to happen. तो ये एक बहुत बड़ा इश्यू है जिसके ऊपर हमको how law can be applied, how legal measures could be taken up in order to ensure this. And this is something a big emergency. Quite a lot of these food security programs have been going on, but they are not making much of it. अभी 8 March 2018 को प्राइम मिनिस्टर इनॉग्रेटेड व्हाट इज कॉल्ड एज पोषण मिशन, 8 मार्च 2018 का पोषण मिशन। तो पोषण मिशन की जो मीटिंग हुई उसका जो चेयर है वो नीति आयोग का डिप्टी चेयर है। उन्होंने जो टारगेट रखा है वो ये टारगेट रखा है हर साल 2% स्पेंडिंग करेंगे कम, हर साल 2% हम एनीमिया, 3% एनीमिया कम करेंगे, 2% अंडरवेट कम करेंगे। आई वाज जस्ट वंडरिंग कि उसके लिए एक मिशन बनाने की जरूरत है। यू कुड डू 2% इज अ horrible figure, and even that cannot be accomplished. I am 101% sure. So this has to be taken up on a huge priority basis. मतलब ये तो फर्स्ट एंड फोरमोस्ट थिंग है इंडिया की, क्योंकि इंडिया इज थिंकिंग कि इतनी बड़ी हमारी ऑलमोस्ट हाफ ऑफ द पॉपुलेशन ऑफ इंडिया इज लेस देन 25 years old, हाँ, और 35% में तो हमारे 2/3 पॉपुलेशन है। मतलब वी हैव सच अ ह्यूज यंग पॉपुलेशन। वी आर थिंकिंग, गवर्नमेंट थिंकिंग कि वी कैन हैव अ डेमोग्राफिक डिविडेंड की यंग पॉपुलेशन है, इस कारण से हम बड़ा इनका फायदा उठाएंगे और वी क्वांटम जंप इन इकोनॉमिक ग्रोथ। पर अगर वो आपका जो कैपिटल है इट इज अनस्किल्ड, स्टैंडर्ड, मेंटली नॉट फिट, all this is wrong. It is going to be a demographic liability, and that is to be also taken into note into, and the court has to come forward somewhere in order to सरकार को हिलाने के लिए कि भाई आप कुछ करेंगे। तो I just thought let me also add to these two panelists here what they have said, and now the floor is open for questions.
Water shortages. What do you see as the kind of current situation looking forward, 10, 20 years, and what we should be doing now to kind of make sure that the future is terrible?
This is not a question, it's just a issue I want to flag off. अभी मैं झारखंड से हूँ और अभी कुछ दिन पहले, एक सप्ताह पहले वहाँ पे हंगर डे था, और हंगर डे की बात की राइट टू फूड कैंपेन वहाँ पर एक्टिव है और लोगों ने बहुत वहाँ पे कैंपेन किया और उसके बाद इंक्वायरी कमेटी बनी और इन्वेस्टिगेशन हुआ और अंत में डिक्लेयर हुआ कि वो हंगर डे नहीं, वो हंगर डे नहीं था। और मेरी हाँ हंगर डे नहीं था, भूख से नहीं मिलती उसकी। और नेक्स्ट पेपर में भी ये भी आया कि शायद हंगर डेथ को हम लोग इस तरीके से देखते हैं या डिफाइन किया हुआ है कि कोई भी डेथ हंगर से डेथ लगेगी नहीं। तो ये मुझे समझना है कि किस एंगल से लोग देखते हैं हंगर डेथ को, क्योंकि भूख से मौत होने के बाद भी वो उसको उस कैटेगरी में रखा ही नहीं जाता और मान लिया जाता है कि वो किसी दूसरे बीमारी से उसकी मौत हुई।
beneficiaries get excluded, like several migrant women get excluded from marital act. And if you analyze the marital deaths that are taking place, just looking into 1 year marital deaths, we had actually one third of our women had been from the migrant population. So denied of all these things, or marital liability act, or JSY, or any of these. And many of the migrant population get excluded. One kids madam had been talking about this Aadhaar card miscellaneous, and also ration cards are not there, and these are all interlinked also. even the food security act, the women who are migrating to the cities won't even get enough food to eat because they have to purchase everything outside. Because ration card will not be there for them to buy in the cities, food for them. So these are certain issues, especially vulnerable communities being excluded from many of these.
I quickly wanted to ask, when you talk about healthy food, does that also include, or in some way cover, say, like a lot of Rohingyas that are coming from India, the Rohingya refugees in India? So are they also included, or is there a demand? Because initially the right food campaign did say that it should be regulated in India, but is it still limited to the Indian citizens, or does it also apply for the refugees as well?
So under the food security bill, why is there a cash entitlement that is given out? And why have they not looked at other ways of security for the refugees? How do you ensure that it is being taken care of?
I don't know, under JSY or PMFPY, मतलब दोनों में से एक स्कीम में it is just for women who are 19 years or above. तो जो 19 years से कम है, they are pregnant, don't they get any maternity benefits? So shouldn't we, when you apply for that petition, आपको एक वो डालना चाहिए कि it should be for all your pregnant, even if they are.
You are not supposed to become pregnant.
No, we shouldn't be. But अगर आप child marriage recognize कर रहे हो और ऐसा होता है कि आधार कार्ड पर एज कम होती है, तो वो नहीं अवेलेबल करते।
Not take any further question. Let them answer these questions first.
Thank you. Actually, when ma'am was talking and was talking about that emergency, it came to my mind that I might have covered at least the legal aspect of what the petition is about that. But these are discussions. The question of agriculture. The emergency that I was talking about, I mean, we can actually see it looming over it, and we can keep on talking about entitlements which are provided under the Act and all, but there are other ways which the entire ecosystem is being diluted. One is the corporatization of agriculture. The second one would be corporatization of meats itself, I mean, or the food that's being provided. So I'll just give you 2 or 3 instances of how the second bit is being done, because that is, in fact, food production doesn't seem to be going down, so that's not so much of an emergency, but maybe as in the future the land use gets changed and land is taken away from agriculture purposes and food production purposes, then there might be a scarcity situation. But yeah, we still do have scarcity in terms of pulses and all, not so much for cereals, which is, like she said, is the staple diet which is being provided for under the Act. Corporatization of food, if I could just talk a little bit about it, that the government's priority is not actually in providing, I'm not talking about just this government, it could be any government, in providing food, healthy or nutritious food. It's been finding different ways. So one way was that, for example, Rajasthan, there are some people from Rajasthan here, they would talk with this, that a private company was being given operation in public-private partnership to run ration shops, wherein the private company could also sell other items apart from food grains, which would essentially mean that a government mechanism and the most far-reaching last mile distribution mechanism would in fact be, government distribution mechanism would in fact be used to promote commercial products, commercial food products. Now, what these products are going to be, government insistence, government cannot provide money for pregnant women, like I just said, but they would instead provide free land or subsidized land to Patanjali Food Park. And what are you going to produce in that food park? Again, it's going to be those substandard, sub-quality. Instead of maybe Patanjali noodles, so whatever you are, I mean, there may be some advertisements, whichever way. But what you actually need to feed your children, or what you actually need to feed your families is home cooked food. Instead of that, what you're doing is that you're setting up plans for food production.
You will not get rations in the PTA shop unless you buy Patanjali salt or some other Patanjali product. There are 3 Patanjali products which are there in the ration shop, and unless you purchase them, you will not be getting a ration. So that's the extent to which it's gone. You have to purchase Patanjali salt, and then you get your ration.
So yes, that, and again I'll say from Uttar Pradesh itself, under the ICDS scheme, and this is again another case that one is doing together, not just in Uttar Pradesh, it's happening in several states, but I'll just cite Uttar Pradesh example, that Conti Chatta, who was a liquor baron, his company was providing meals which were actually not being consumed by children, meals which were supposed to be distributed at Anganwadi Center, take-home rations. For children within the age group of 6 to 3 years, you are first of all giving them packaged food instead of hot cooked meals. Then these food items or these food packets are being prepared by industrialists who, in his whatever greed, would even steal from children and provide such poor quality food that even cattle, and this is an NHRC report that I'm quoting. The food packets, when they tried to feed it to cattle, even cattle refused it. What was that? I think that's another emergency that's looming, and of course, I think you would agree with that, because with Jan Swasthya Abhiyan as well, we've been fighting this battle too. The question on hunger deaths, so starvation or hunger deaths is actually not being defined how to assess it, but we have tried to work around several definitions and finally realized that starvation is actually not a sudden state, but it develops from chronic hunger. साल दर साल जो है वो साल दर साल या महीना दर महीना जो है वो भूख से शरीर जो है वो कमजोर होता जाता है. Body starts weakening, and so does your immune system, and then you start catching diseases. So, for example, I've even seen this in one of the starvation death cases, that the government disputed that it was not a starvation death because the person died of cardiac arrest. Cardiac arrest just means your heart stopped working. Heart stopped working because you were hungry, because you haven't had food. And so, a biological reason would be different from circumstantial reason. The second, so body starts weakening, your immune system becomes weak. So, if, for example, a person who's been suffering from chronic hunger over years would actually be more prone to catching tuberculosis than I would be. Because, I can't say that. I am very well nourished, but yeah, other people over here. That's the actual cause, and you have to go into those structural reasons as well. You have to actually assess that. There is also another system which is, if you were to talk about it technically, that when you do autopsy, you actually check how much food was there in the stomach at the time of death. And there's another system which is called verbal autopsy, where you go around, speak to the neighbors, speak to the family, ask them how much has the person been eating and in the last few days. And but again, all of this is not part of Jharkhand has just now actually created some committee or something which is trying to formulate some guidelines or some protocol to assess whether a person died of starvation or not. But until then, Jharkhand especially, the spate of starvation continues, and that's another third case that we filed in the Supreme Court with Colin, with HRN actually, which was the first hunger death of a 11-year-old girl. So we filed a petition, we met with her mother and filed a petition on behalf of her. A question of migration exclusion. Should I leave that? Okay. Just two or things. Yeah. Maternity Benefit Act is different from maternity benefit under the National Food Security Act. Maternity Benefit Act says that women should be given paid maternity leave, should be given so many days of holidays, maternity leave, and now there's some provision. I just today, a couple of days back, I think there was some discussion about maternity leave as well. But that is another issue, that because Maternity Benefit Act, even when it was amended just last year, 2017, the 1961 Act amended 2017, and even now we are not talking about unorganized sector under the Maternity Benefit Act, and that is something again that we are planning to do legal interventions about, that even in unorganized sector, especially for construction workers, which can easily be registered, and how many days they have been employed, all of those things can be done. Especially for construction workers and domestic workers, we're planning some legal interventions so that the Maternity Benefit Act, this provision of maternity leave and paid maternity leave, can be implemented for unorganized sector as well. The question of Rohingya and non-Rohingyas, unfortunately, again, speaking like someone who knows about the National Food Security Act, the problem is that there was in 2015, central government came out with a PDS control order. It amended its earlier PDS control order. Ration cards are issued, and earlier all public distribution system used to function as an executive order and not as a legislation, not as a law. So they amended the PDS control order, and then they said in that PDS control order, they said that only citizens are entitled to get a ration card. That's something that we wanted to challenge, but in the main right-to-food case, but the case was shut, and again, this other UCL case that we have, its scope is very limited. But yes, that is something that we should keep in mind, and we should get a PDS control order amended to say that all residents should be covered by public distribution system. But specifically on the question of Rohingya and non-Rohingyas, we are actually, we were discussing it just yesterday, that we are trying to file an application in the ongoing cases saying that ration should be provided, some kind of ration should be provided to Rohingya refugees. Cash entitlement, apart from cash entitlement, there is also a meal entitlement for pregnant women. So, which they can get from an Anganwadi center, which is similar to, so Anganwadi center basically covers a child from the time of conception to the age of 3 years, to the age of 6 years. So from for the first, during the time of pregnancy, the woman is also entitled to a meal for every day. It could be take-home rations or it could be hot cooked meal, depending on where she is located. And in addition to that, and this was an entitlement which existed for a long time, since 2001. But in addition to that, the National Food Security Act also says that there would be a cash entitlement, which I understand you saying that it could be used for other things as well, but it's primarily to cover other aspects of maybe her travel, just to run the right center. It is primarily for all those reasons, because otherwise she wouldn't even be allowed to reach out. And sometimes she would even be forced to work during pregnancy. That happens a lot. That's it, I think. 19 years of age, I had actually covered it.
I just want to add to your question about his answer to your question about what we see in 20 years from now. I think that I'd like to flag one other important issue, that what is happening is that you keep hearing of the Prime Minister going to this country, that forever traveling. But he's not just traveling, he's signing investment agreements. And when he's signing investment agreements, the priorities in those investment agreements are priorities for profits of industries over rights of people, of local people. So what is invariably happening is that, for instance, a company, and then there are these investor dispute settlement mechanisms, which are today an order of the day, and these dispute settlement mechanisms, it's not like you and I can go and appear there, or a citizen can go there. First of all, if the state cannot sue the companies which invest, and then those companies, there are lawyer firms, big time law firms. The costs of that for the state are phenomenal, which will in turn mean reduction in budgets for all these for various welfare measures, and for as we said, the budgets are reduced. So the thing is that we need to kind of somewhere build a momentum to say, because then the government is forced, if it takes a policy, for example, it takes a stand which ensures say cheaper food. Then let's say a company which is trying to sell some particular processed food may say that our prospects of profit are reduced because you are providing free food or cheaper food. So then the state is obligated to abide by the investment agreement. But that investment agreement is something that none of us have had a say in, either in Parliament or in the Legislative Assembly. There will be no discussion on that. So I think we need to posit the obligations that the state has under the so-called investment treaties, which the people of the country are not a party to, and against the constitutional rights, the rights under various international treaties, and ensure that our food security does not slide down further, and there is a regression. I think maybe we can use this principle of that there shouldn't be a retreat. There can only be an advancement of rights.
Yeah, Colin,
you were speaking to the session.
मेरा सवाल ये है कि ICDS के अंदर लैक्टिंग मदर और प्रेग्नेंट मदर के लिए है, और 3 to 6 ईयर ऐसे लिए है, लेकिन जो 6 महीने से 3 इयर्स उसके लिए तो कोई नहीं है।
नहीं, 6 माइनस मतलब 6 महीने तक के बच्चे हैं ना, 0 से 6 महीने तक के बच्चे।
4 महीने बच्चे से 3 साल के बच्चे,
6 से 3 साल के बच्चों के लिए एक इंप्रेशंस या हकूक़ का प्रावधान है।
लेकिन नाम के नोट से नहीं हो रहा है जी, इंप्लीमेंट से नहीं हो रहा है। नाम
कौन से स्टेट में?
ओडिशा।
सो वहाँ पर नहीं हो रहा है। अच्छा,
तो उसके लिए आपको करना चाहिए।
हाँ, क्योंकि वो सेंट्रलाइज तरीके से वो पैकेट बनते हैं, और इसलिए कभी कभी ये होता है कि जो कॉन्ट्रैक्टर होता है उसको पैसा नहीं पहुँचता है, वो पैकेट की सप्लाई बंद कर देता है।
नहीं, वो बात नहीं है।
वो पैकेट में जो आता है ना, जो मैंने विधि का उदाहरण दिया था, उसी तरीके से अगर उसको पैसा नहीं पहुँचा होगा या कुछ हुआ होगा या कहीं पे
नहीं, कहाँ पे
कहीं और जाके बेच दिया होगा, ये नहीं पता है।
नहीं, कहाँ पे
पता, मैं आपसे बाद में बात करता हूँ।
Patanjali salt. Patanjali salt. So Sandhya said you can't get your rations unless you buy Patanjali salt. And until you just bypass it out of your speech. What do you want to do then? Does anybody know? You can't get rations unless you buy Patanjali salt. क्या करना है? See, ultimately Who will give an answer?
ये तो वैसे ही हो गया ना पहले when you wanted to get the LPG cylinder connection, you also have to buy a chula from the shop.
Who will get it? One lawyer can say, one activist will say, what should you do? Somebody comes to you and says, I'm forced to buy Patanjali salt and I get my ration. So the evidence is here, they have to buy it. You're forced to buy Patanjali. What is the answer? It was a very important intervention she made, and then she remained silent with us, not asking. First of all, can you challenge?
Yes.
Yes. Okay, you tell us. No, not competition, not competition. You are going to get rations and you are forced to buy Patanjali salt. Can you go to the High Court and say, please squash this nonsense business of forcing us to buy Patanjali? Yes. Why? What is the magic word for a writ petition? On the first day he said it. What is the magic word?
But calling for that, there should be some kind of a written order. Is there a written order for it? That you have to buy a Patanjali product. So you either have to have some video documentation or some kind of a thing. Unless you don't have some evidence, you can't go to the court. And I am reasonably sure that there can't be any government order. Compulsorily buying Patanjali product.
Maybe one can try to do that under the Food Security Act first as a measure to go to the grievance redressal officer who is there under the Food Security Act. Of course, they are all state mechanisms at the end of the day, but still. So, because then otherwise when you go to the High Court is going to say it's not exhaustive your remedies about grievances. Because there are provisions in the law. And then we go there.
It doesn't require any naming, it doesn't require any proof. I want to take up this issue of proof also. First of all, go straight to the High Court, right, say that this is nothing. 3 or 4 people who are forced to buy Patanjali salt can go. And it's a very important case because Patanjali is trying to get into the food distribution system. Very important to stop it in his tracks. And it's totally unreasonable to force him to do that. If we get an order saying no ration shop will force people to buy Patanjali. Point number very simple. What is proof? What is proof? Suppose a person says, like in the section that marital rape case, a woman is raped by her husband in the room, or I go to buy his postie to Patanjali. What is proof? Proof is a videotape, proof is a document, proof is a government order. A person saying on affidavit is not proof. Please understand this. A person saying on affidavit, I was in the room with my husband and I said no and he raped me, that is proof. A person going to the High Court and filing affidavit 3 or 4, 5, 6 people. The village panchayat that they are forcing to buy Patanjali salt, 5, 6 people. It's proof. What will the court do? The court will turn to you and say, are you doing it? No, I'm not doing it. Or I'm doing it, yes sir. Or I'm not doing it. And then the court will say, alright. They are making a statement that they are not forcing it. It will come in the court order. So never make proof dominate your thinking in a litigation. And remember the magic word unreasonable. Sandhya, got it? No? Straight go. Patanjali will become one of the biggest inheritors of the public distribution system. They will take it over, take government funds, and they will do the public distribution. This is the start. They start with salt.
सर मेरा कुछ कहना है इसी को लेके मैडम ने वो जो उनका जो एक्सपीरियंस है जो उत्तर प्रदेश में हो रहा है उसके बारे में मैडम ने नहीं देते तो उसी को लेके हम लोग क्या करेंगे वो सोल्यूशन के लिए कॉलेज सर ने बात करेंगे बीच में से
आप लोगों में से कुछ जवाब आएगा कि ये रिटर्न में है क्या, कुछ एविडेंस है, प्रूफ है अपने हाथ में, इसको ले जाके हम उसको एक पेटिशन या कुछ आधा तो फिर उसको कर सकते। तो मेरे कहने का मतलब यही है कि जो रेशन में ये कंपल्सरी हो रहा है, तो ये कोई प्राइवेट संस्था तो उसको नहीं चला रहा है, गवर्नमेंट वाला ने इसको इम्प्लीमेंट करा रहा है ना। वहाँ पर जो काम कर रहा है वो प्राइवेट वाला नहीं करता है, जो डिस्ट्रीब्यूट करता है, जो लेता है वो जो विलेज है वहाँ पर होता है। तो मेरे कहने का मतलब है कि इसको कौन है जो सुपरविजन करता है। अगर ये रेशन बात आती है तो ये गवर्नमेंट की बात आती है, अगर गवर्नमेंट की बात आती है ये चीज़ें जो है मेन सिटी में या कोई शहर में नहीं होने वाली चीज़ें, ये हो रहा है गाँव में या विलेज में हो रहा है। ये उत्तर प्रदेश में कंपल्सरी है, मतलब उत्तर प्रदेश छोटे गाँव भी नहीं है, ये बहुत बड़ा एक स्टेट है जिसमें पॉपुलेशन भी बहुत ज़्यादा है, वहाँ पर कंपल्सरी हो रहा है कि हो सकता है 50% लोगों को ये इसमें सहमत नहीं है कि समझने लेके वो जिए, तो उनको नहीं पसंद, लेकिन वो कह नहीं पा रहे बाहर। आज वो दीदी मुद्दा यहाँ पर लाए कि इसको किस प्रकार हम लोग इम्प्लीमेंट किया जाएगा। अगर मेरी प्रश्न का जवाब पहले दिए भी गए हैं, तो मैं चाहती कि इसके सुपरवाइजर किसके हाथ में है, ये कौन करता है इसको।
देखिए, अब ऑर्गेनाइजर्स ने हमें बताया कि अब बहुत ज़्यादा समय बचा नहीं है, इस कारण से अब एक क्वेश्चन और हम एडिशनल अगर कोई बोलना कहना चाहते हैं यानी फिर उसके बाद हम इसको रैपअप करना शुरू करेंगे।
मेरा सवाल ये है कि जब हम फूड सिक्योरिटी पे बात कर रहे हैं, जहाँ असली फूड सिक्योरिटी है, जहाँ खेती है हमारा, जहाँ हमारे किसान है वो अभी मार रहे हैं, अब हमारा खेती मार रहा है। अब जब हम किसान का भूखे नहीं मार रहा है, तब हम जब वहाँ बात करें उसको कैसे हम जोड़ेंगे ये फूड सिक्योरिटी। सरकार बोल रहा है कि ये अखाद्य नहीं मर और दूसरा खाद्य खा के मर गए, तो उसको कैसे जोड़ेंगे। तो असली जो हमारा फूड सिक्योरिटी है उसको हम खत्म करके सरकार की जो स्कीम से, मैं मानती हूँ कि स्कीम से थोड़ा बहुत हमको राहत मिलती है, लेकिन पूरा तो नहीं मिलता। ये असली जो फूड सिक्योरिटी व्यवस्था को कैसे हम लोग फूड सिक्योरिटी में जोड़ सकते हैं।
ओके, तो देखिए, जो बात आपने कही कि ये जो किसान जिस तरह से खत्म हो रहे हैं, इनकम कम हो रही है, सब कुछ है, देखिए स्थिति तो बहुत करीबी कमजोर है और ये जो इनिक्विटी है, जो अंतर है, वो बहुत ज़्यादा बढ़ता जा रहा है, इसमें कोई शक नहीं। पर इसमें भी कोई शक नहीं है कि स्थिति आज से 20 साल पहले, आज से 50 साल पहले या 100 साल पहले कहीं ज़्यादा बेहतर आ गई, पर इस स्थिति को और बेहतर बनाया जा सकता है। और जब हम फूड सिक्योरिटी की बात करते हैं तो फूड सिक्योरिटी में केवल हम यही नहीं सोचते हैं कि ना खाना नहीं मिल रहा है, साथ साथ हमको ये भी सोचना चाहिए, जैसा कि उन्होंने बताया कि खाने का जो होलसम फूड है, बैलेंस फूड है, वो सारा का सारा भी खाना उसमें मिलना चाहिए। अब देखा जाए तो हम फूड के मामले में किसी हद तक सेल्फ सफिशिएंट है, ऐसा नहीं है कि हम सेल्फ सफिशिएंट नहीं है, पर लोगों की परचेजिंग पावर नहीं है, एक्सेस नहीं है, ये सारे भी इसकी एक महत्वपूर्ण कारण है। एक जो दूसरा पक्ष और उभर के आ रहा है और वो भी मेरे को लग रहा है कि हमको उसको अब ध्यान में रखना चाहिए, और वो क्लाइमेट चेंज के जो बात आल्सो इक्वली इम्पॉर्टेंट कि एक तो देखिए कि नॉट ओनली देयर इज अ सेक्शन व्हिच इज अंडर nourished and underweight and stunted, all those kind of things. But then there is a rising trend of obesity. That is also happening and has begun to happen quite a lot. So we are experiencing what we conventionally or classically called as double burden of malnutrition, because obesity, overweight, more than required your body mass index is also a rising problem here. And because of that, lots of non-communicable diseases are also happening. Now, taking into account the issue of this climate change, then as you increase your industrialization, as you increase your high yielding variety of food crop production, all these things add to adverse climatic conditions, and not enough measures are taken. Though the total climate pollution and all those things in India are far less in comparison to per capita pollution or adverse climatic conditions from India are far less in comparison to Western countries. But that apart, we have to begin to take into account all these kind of things, and we have to be far more innovative than what we are. तो इसमें कोई शक नहीं है कि ये जो जितनी भी अभी स्कीम्स चल रही है, they are far less than what is required in this country to be done on all fronts. और ये जो obesity और ये जो high BMI का जो problem बढ़ रहा है, that is not because कि people perhaps are consuming quite a lot, but the kind of food they are eating is also contaminated, has such kind of things. जैसे सस्ती नमकीन खाएंगे तो सस्ती नमकीन यूज करेंगे कि that the oil has been used several times because they cannot afford to buy good quality nutrient food. So these kind of challenges are there before us, and we have to rise up to take on these challenges head on, using all measures of public awareness, public action, and also legal measures. And there are certain legal frameworks and certain legal protections available to us, and we should make full use of those protections and legal measures in order to, not let these things move on the way as they are. So this is what I just like to say at the end. And thank you very much for hearing. And soon after having food, we had a session on right to food. Was really a good thing. Thank you very much.
Like Hijras, Tirunangais, and there are religious identities, regional like Shiva Shaktis, Jogappa, Jogti, Arvanis, and also gender sexual identities like Koti, Mangalmuki, and there are secular trans identities, Dupi Manvi, trans women, trans men, and gender fluid and gender fluid intersex people. So we find mostly these gender identities as a trans identities in India, and there are also very colloquial trans identities. For example, in Tamil Nadu itself, we got the trans women have given their own name like Aravani, and also Tirunangai. Aravani is the one who trans women married to the god Aravan, and Tirunangai is women with respect. Next slide. This is Hijra. Next. This is Nupi Manvi. Not these women have given their own name, look like women. Nupi Manvi is the term used for trans women, and mostly they are into the beauty parlor thing and beauty thing, and a lot of them have their own independent livelihood, unlike the Hijra system, where the Hijra system lives in a matrimonial structure sharing their common resources following the matrimonial relation under one roof. Next. These identities are called Shiva Shakti, Jogappa, Jogti. Mostly we can find in Telangana, Maharashtra and Karnataka region, these three states, where these people are considered as God people married to God. Mostly trans women. Next. Koti and Mangaluki is another term which are feminine trans identities, which is also you can find like almost all in South India and North Indian part also. It is a specific term or name used to represent the feminine identity of trans people. Mostly trans women. Next. And these are trans women and trans men, which is a universal definition we have. Trans women you can find who identify themselves as trans women like me, and trans men who are biologically born as a woman and identify themselves as a man. Next slide. Gender fluid, they are the people irrespective of their stereotype genders, whatever they look like, the men or women. So they are also identified under the umbrella of trans identities. Next. These are the intersex people. Intersex people have three variations. They are born with the both organs, reproductive organs of male, female. That is one combination, and one combination has neither the both, and the third combination can be one organ developed and other is undeveloped.
So those are called intersex variations, and they also consider themselves as one of the trans identities. Next. And now coming to the last judgment, it has been delivered on April 15, 2014 by Justice K. Mantra, Justice Arjun Kumar Sikri, and the petitioners were National Legal Service Authority of India was the primary petitioner, and the co-petitioners were Puja Mata Nasir Kaurji, Women Welfare Society, and Lakshmi Narayan Tripathi, who is a Hijra women activist there, but now she played to the Kinder activist. Next. These are the special features of this judgment. The transgender people declared as a third gender. I don't know who are first and second, but hope we don't become the content of both. So basically, that these people, transgender people of this country, should be considered as a third gender. And the constitutional rights are equally applicable. So the court felt that after reading all the case studies, they have gone through all the holy scriptures, they have read Ramayana, Mahabharata, means people have given them all the stories, they have listened to all of them, and they consider that after listening so much religious stuff and economic, social stuff, they felt that they are constitutionally, their rights have been, damaged from all these ages, so we need to acknowledge them. And right to self-identity. And this is the particular feature of this judgment, right to self-identity. So the Nasa judgment gives the right to the transgender people to identify their bodies as self-identify as a transgender. What does it mean? It means, it says, the transgender people can either acknowledge them as a male or a female or the third gender. And the third gender goes on like trans women, hijra, mukti, all this list goes on. But the definition ends over like that. Whoever feels himself or herself as a trans person and feels affected to that definition can identify as affected, self-declared as a trans person. What an open definition is. Irrespective of your body, your anatomy, your stereotype gender in the society, you are given the freedom to express your gender, equality and liberty. So this judgment itself is placed on the pedestal of equality and liberty. That's amazing. And socially and economically backward classes provide reservations in education and jobs. So the judgment also is talking about the backwardness of the transgender community of this nation. So they have been vulnerable and marginalized all these years. They should be provided. They should be declared as a backward class. It's not backward caste, but it is a class. It is a group. And they should be provided with the reservations. They haven't given any limit for the reservation, but they are speaking about they should be provided reservation. Coming to the next, Institute of Transgender Welfare goes in the state. So the bench has been provided with the case study of Tamil Nadu, the Aravani Welfare Board, which has been started in 2009, where they have been shown that the state started providing schemes, welfare schemes to the community. That becomes a very good thing for the community, where in 2009 Aravani Welfare Board has been instituted, and I think 12 to 14 government departments has been synchronized to work for the transgender welfare in that state. And that has been a successful case study. So the court has taken in this judgment and also asked various central and state governments to institute in the various states such welfare boards also. Coming to next, provide healthcare in government hospital include free SRS. So as we talked about Aravani Welfare Board in 2009, the government hospital also provided a free surgery in government hospitals in Chennai. So in this judgment also the court and the bench is saying that they have to also provide a free SRS after constituting the report. Now the non-recognition of civil rights, marriage, adoption, etc. discriminatory. So court also acknowledged that there has been a lot of discrimination in the other social rights called like adoption rights, having family, marriage, all those things. So they should also acknowledge that. And anyone who is insisting SRS, any trans person or any person, if says that you are not identified unless until you have gone undergone surgery, that they say this is illegal. So the court is saying that you should not pathologize the identity, gender identity. So any surgeon, irrespective of surgery, he or she can be considered as transgender if she or he declares herself as a trans person. State should address stigma to public awareness. So state, like central government and state government, has to address the stigma and discrimination which the community has been undergone all the ages. Judgment should be in the light of an MOSAE report of the expert committee on the issues related to transgender 21st July 2014. So, Ministry of Social Justice and Empowerment is one of the Indian government department which has done a number of consultations before this judgment, and where they have invited all the expertise from the trans and non-trans communities. From there they have consolidated and submitted the report to the court also regarding this judgment. So this report has such details that what details have been submitted to the court. So if you want to go to the judgment, you are supposed to also see the expert committee which has been given to the Ministry of Social Justice. Next. And legal progress based on answer versus. So once the judgment is out, it's not so much easy to us. It's not that all the things are in right place and everything is so fluid. It's very tough to us that we have waited from days to months and years until today that to implement even a single line of this judgment. For example, in Tamil Nadu, Pritika Ashni, who has applied for police officer post, has been rejected for being trans person. That she is not capable of doing this job. But she challenged this on the basis of answer, where she got that post, and now she is a SI in the Tamil Nadu. And based on her judgment, now 6-7 more trans women have been employed in the police department as constables. Next. And this is my own state, Sonia Sheikh. She is an acid attack survivor, where with the help of HR and NB, Sonia Sheikh has to wait for 2.5 years for the compensation being an acid attack survivor. She has been discriminated only because of a trans person. So with the help of HR, we are able to get the first installment of our compensation of 3 lakhs based on Nalsa versus human. Next. And she is a leader from Bihar, transgender activist Reshma Prasad, who Nabila I think shared her case, who is leading her case in Supreme Court, and she approached the Supreme Court for the direction to send her to, because there is no third column in the PAN, permanent echo number, and she knocked the doors of Supreme Court for including for linking up the Aadhaar with that of PAN card. So next slide. And she is Grace Banu, our Dalit trans activist, and the one in blue saree. The one in black dress is her daughter Tarika. So both are Dalit trans activists from Tamil Nadu, and both have been approached the Tamil Nadu High Court for reservation in the education system. And Grace Banu has been admitted as an engineering student, and her daughter as a medicine. And both have been proved these cases successful based on answer. Next. And she is also one of the greatest transgenderists from Assam. She herself is an advocate in Guwahati High Court, Swati Vinay, who moved the Guwahati High Court, saying that even after the Nalsa judgment, the state has no welfare for her. So in the last month, we got a judgment in a very positive term, and the court has directed the government to start initial discussions on transgender welfare for Assam. Next. So policy level progress. So these are legal level interventions which have been done on the based on Nalsa judgment, and these are the policy level interventions which few states have done. States like Kerala is the first state which came out with a transgender policy based on Nalsa judgment. It is the first state in the India which came out with a policy. Maharashtra, next, Karnataka, Chhattisgarh, Andhra Pradesh, and Jammu and Kashmir. They all came out with either of the GOs or the policies as their state policies for the transgender people based on Nalsa. Next. States who are working still on the policies based on Nalsa are like Delhi. The AAP government recently, 2 months back, has initiated a dialogue with the community to make a welfare code there. In Telangana, we have a continuous dialogue with the government. Assam has been now initiated a committee after the judgment. Bihar, Odisha, and West Bengal are also in the pipeline to initiate a welfare codes in their respective states. Next. Policy level progress based on Nalsa. Other state actors. These are the state actors, the institutions or the organizations which are based on the Nasa judgment, which got the instructions from the Minister of Social Justice and Employment to work on the issues inclusion of transgender people. For example, the UGC issued a circular on 29 October 2014 to all the universities of the country to enroll transgender students. NIRDPR, National Institute for Rural Development and Panchayati Raj, has included the transgender facility schemes like DD2, JKY, Manrega and RCD, where they will provide loans and trainings for the unemployed along with the transgender people also. Next. These are the few challenges with respect of NALSA, like Indian Penal Code, you all know 377, we are struggling with that which is a British law 19th century anti-sodomy law, which declares unlike other than penal and vaginal sex, every other sex is an unnatural sex. And this is how like lot of trans people are all can also criminalize, being lot of them involved in the sex work, being their livelihood profession, like livelihood, traditional livelihood. And police used to threaten this for that, and also in LGBT communities. So this has been been a challenge for us, even after being Nazi judgment also for us. And there is an act called Hyderabad Women's Act 1990, which criminalizes the underage castration, denies Hijras right to adopt and raise children, and force registration of Hijras within this region. This is the pre-independence act, which is also existing now, and which has been recently challenged in the Hyderabad High Court to repeal this after the division of Andhra Pradesh into state of Andhra Pradesh and Telangana, because the region of Telangana even still prevails with this act and criminalizes the transgender community. Apart from these two laws, the rape laws. So, if a transgender person has been prone to rape, we won't listen any case has been registered or an affair has been registered on basis of like case of a transgender person till now, till today. And very contrarily, there is a case study in Pune which comes out like a transgender has been gang raped and has been the perpetrator has used the 377 section to come out of this case. Very easily. So the rape of the transgender people has been institutionalized but not being addressed under the rape laws. Next, a reservation and education employment system. We all know that all the systems have been in our country caste-based, class-based, and something based. We all know there is a lot of bureaucracy and corruption institutionalized. So, in the light of those institutionalizations, how transgender people will be able to negotiate if at all they have been given education, opportunities, or the job employment opportunities? Will they able to sustain in those organizations? Will they able to sustain in those environments because of a lot of transphobia and discrimination? So that's how few people like Rezwan and few other progressives have thought about that. A reservation should also exist in the education system and on the employment system, which of course the answer says that, but very few other progressive laws also talk about. Even the central government also questioned that when government has the Supreme Court has told that you have to include them in the backward class. Central government has questioned on which basis you are going to make them as a backward class. There is already a backward class commission in this country. Are you going to list them under this section after so and so like research and roundup things? How you want to, or you want to navigate in the judgment itself. So there is a lot of silence and lot of delay in talking about the education and employment, because if those things are not grabbed, then how can you expect the transgender people to be flourished, leaving the traditional livelihood options like dating and sex work? Next comes name and gender change. Well, this has been a very long-term challenge after even of narcissism, because even we approach after birth, we are in our biological names and brought up in our other names by our parents. But now after our gender change, we want to change our name and gender also. But there are no policies existing either in the state level or the central level, saying that so and so procedure has been prescribed to change your name or gender. So that becomes very tough, that if we finish our education in one gender, and after that we transition to other gender along with the name, and there is a lot of variation. That's how we have been always rejected for the education further and also in the job opportunities. And people also discriminate us saying that you are not the same gender what you look like now. Next. Rights of Transgender Persons Bill 2014. I think the next two speakers will cover most of this because this is a bill. I'll give you an introduction about this bill. Rights of Transgender Persons Bill 2014 is introduced by the private members, has been introduced as a private members bill by Tirupati Shiva, the DMK MP in Rajya Sabha, and been successfully accepted by all the political parties in the Rajya Sabha, but it has never come to the discussion to the Lok Sabha. Because the BJP wanted to come out with their own bill, so they easily may pass this bill in the Rajya Sabha, but never make this enter into the Lok Sabha. A few specific features of this bill can be like 2% quota, reservation in private as public educational, and transgender commission. The bill also proposed a commission, and no transgender child will be removed from the family, and penalty of 1 year imprisonment of 1 lakh for the hate speech against trans people. And all these things are regulated. My next speaker will throw more light on these issues. Next slide. Transgender persons protection of rights bill 2016, and this is the way which the BJP government, the present government has come out, and which has been also approved by the cabinet, has been sent to the committee also, parliamentary standing committee. All the political parties have done a lot of dialogue on this and have also given a report on this. And we all have represented our arguments in front of the committee regarding this bill, and we have very specific reservations about this bill. Because this bill contrarily goes on the face of the Nasa judgment and also the bill which has been passed by the Rajya Sabha in 2014, the Tirupati Shiva bill. It has so much of provisions which criminalizes the community. For example, define transgender as self-identified intersex. The definition in this bill is confined to only intersex persons, which again confines only to the bodies of the trans people. Whereas the Supreme Court is saying that self-identity is the principle which transgender has to be identified as. And next, provides for screening committee. It again instigates a medical screening committee should be gone, all those things, where again it attacks the trans bodies. Provides no reservation. It is extremely silent about the education, employment system, and also reservation. It only says that they should not be discriminated, and without defining what is discrimination. And makes it easier for families to transfer their children to the gender non-convention to the state universities, criminalizes begging and enticing people. And this is the peculiar feature of this bill. It mainly focuses targeting the Hijra community, because the larger the trans community of India is the Hijra population. It attacks on the Hijra's livelihood, saying that anyone who begs or entices the begging will be penalized by 2 years of imprisonment or also death. So it's not only talking about the community, but also the structure which has been from ages and ages set up by the trans community for their livelihood options. So one way you are not providing any scope for other livelihood options, neither reservations in education or employment, but in one way you are taking the livelihood options which is present with us now. Next. So we have done in Hyderabad a big rally with 3,000 Hijras, which is called Hijra Tehzeeb Bachao rally. Next. And we have done roundtable discussions on this bill. Next. And this is about goodbye HRL itself in Delhi. Next. And we have advocated with parliamentarians regarding this bill. Next. We have done press events. Next. And we have done social media campaign on this. Next. And next. And this is a national protest we have done in Delhi last year, December, where we asked the government to stop the bill and kill it. Next. And this is a recent protest in Tamil Nadu, Kerala, West Bengal, Assam, Karnataka. And after this lot of pressure, the government has come out with a press note saying that few changes will be considered. Like other than the protest, like now we define transgender person whose gender does not match the gender assigned to that person at birth, includes trans men, trans women. Now they now started using our terms like trans men, trans women, and all those things. But this is not official. This is only a news press statement they have given. But we haven't got the dealing with the actual corrections of this. And medical state will be dropped, they said, and include definition of discrimination. And living politics, my next speakers will go like next. And unresolved issue with the change bill, that also next speakers will next. The ongoing transactivism is we are doing our pressure, putting pressure on the government and the system for the implementation of the NALSA government and for the withdrawing or the change of the transgender bill of 2016 according to the articles. So we are working with this collective agreement against sexual violence and repression, NAPM, and Sampurna, it's like wrong, the spelling is wrong. Telangana National Justice Transit Committee is a collective from my own state. Trans rights now, that is a collective started by Grace Banu and a campaign. Unafraid Trust NGO and Human Rights Law Network. Next. 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 Thank you.
मुझे लगता है सिर्फ 4 साल की, क्योंकि अभी तो जन्म हुआ है 4 साल पहले नालसा है, तो खाना भी खाने नहीं आता है, जिसको मांगने जाओ बोलते तो कौन है, कैसे पीक दूंगी, कहीं काम देखने जाओ तो बोलते तुमको क्या काम मिलेगा, तुम क्या काम करोगे, किसी के घर में भी काम करने जाएगा तो बोलते तो हमारे बच्चे खराब हो जाएंगे आपसे, हमारा ऑफिस का स्टाफ खराब हो जाएगा। मैं नालसा के बाद फर्स्ट पर्सन हूँ बॉम्बे में जिसने HRL ज्वाइन किया एज ए एम्प्लॉय, और आज में 3 साल के बाद मुझे एक्टिविस्ट करके ऐसा धकेल दिया, मैं बहुत डर गई थी ये चीज में, मुझे कभी नहीं मालूम था और कभी मैंने ये दुनिया ही नहीं देखी, लेकिन जब क्रांति सर ने, कॉलिन सर ने, सेवा मैम, सरिता मैडम ने बहुत फोर्स किया मुझे कि विकी में कुछ है, सोचो करो, तब जाके मैंने कई बार मारना चालू किया। अब और मैं 4 साल की नालसा की। मैं नालसा की अब की स्थिति महाराष्ट्र की बताना चाहूंगी। अब की स्थिति ऐसी है कि काफी ट्रांसजेंडर मतलब बच्चे जो कि घर में से भाग जाते हैं, जिनको के दिल के जैसे रहने नहीं मिलता, पहले लड़का बोल के जन्म हुआ है, दिल औरत का है कैसे पता नहीं, शर्म आती है लोगों में जाने को, वो लोग माँ बाप के डर से या लोगों के डर से घर से निकल जाते हैं और वो कई ऐसी जगह पे जाके सेटल हो जाते हैं जहाँ पे उनको कोई पहचानता नहीं। स्टेशन से उतरने के बाद दूसरा कोई नहीं मिलता, पहले ट्रांसजेंडर ही मिलते थे और ट्रांसजेंडर किसी बच्चे को देख के पूछता ये क्या हुआ रे तू रो क्यों रहा है, तो क्या फिर बच्चा कुछ बोलेगा, फिर वो ट्रांसजेंडर के साथ जाता है बच्चा, फिर ट्रांसजेंडर जाके अपने जो तैयार या जो घर हवेली रहती है वहां पे उनके साथ रहते हैं, ट्रांसजेंडर उनकी अच्छी परवरिश भी करते हैं, अच्छे ख्याल भी रखते हैं, लेकिन वही करना पड़ता है जो कल्चर से चलता है, या तो बैकिंग करो या सेक्स वर्क करो या किसी की शादी में जाके नाचो गाओ। मैं खुद बैकिंग करती थी, मैं कुछ डांसर हूँ, लेकिन अभी मैं ट्रेन से जब ट्रैवल करती हूँ रोज ऑफिस के लिए तो मैं कभी अभी मांगती तो नहीं हूँ, लेकिन मुझे खुद अभी कोई पैसा देता है मैं लेती हूँ, मेरा हक है, वो मेरा हक है, भीख नहीं मांगती लेकिन हक है। मेरी आइडेंटिटी के लिए मैंने बात करी, जो लोग बाहर से चले आते हैं उनको अपनी आइडेंटिटी नहीं मिलती, सब पैन कार्ड आधार कार्ड अपने माँ बाप के यहाँ छोड़ दिए होते, तो यहाँ आने के बाद उनको क्या कैसे वो खुद की आइडेंटिटी बनाए, वो अपने गुरु का नाम लगाते हैं, मतलब बहुत कुछ उनको करना पड़ता है, एफिडेविट करो, ये करो, इससे मिलो उससे मिलो। हमने क्रांति सर से काफी बात की इसके ऊपर और हम हाईकोर्ट में केस फाइल करना चाहते हैं कि खुद मेरे डॉक्यूमेंट्स मैंने ट्रांसजेंडर बना दिए, मेरा पासपोर्ट ट्रांसजेंडर आया है और उसी बेस पे HRL ने भी हेल्प किया था, ये PGI करके पासपोर्ट, मेरे पूरे डॉक्यूमेंट्स मिले हैं, सिर्फ मेरा फर्स्ट पासपोर्ट ट्रांसजेंडर आया है और इसी बेस पे मैं हाईकोर्ट में अपील करने वाली हूँ कि मेरे जैसे और भी काफी ट्रांसजेंडर्स हैं जिनकी ID प्रूफ चेंज होनी चाहिए। दूसरा मैं कहना चाहूंगी, दवाखाना में हम कभी जाते हैं तो लेडीज डॉक्टर देखेगी तो बोलते जेंट्स डॉक्टर को बुलाओ, जेंट्स डॉक्टर बोलते लेडीज डॉक्टर को बुलाओ, वार्ड में बोलते नर्स को बुलाओ, ट्रांसजेंडर उधर ही मर। प्राइवेट हॉस्पिटल में पैसा देगा तो इलाज होता है, गवर्नमेंट हॉस्पिटल में कुछ नहीं होता। SRX का ऑपरेशन फ्री में है बॉम्बे में साइन हॉस्पिटल में, वो हॉस्पिटल की स्थिति जाके देखेंगे तो मैं खुद नहीं जाती वो हॉस्पिटल में, आज तक पैर नहीं करती। पेशेंट को देखने गई हूँ, मेरे दोस्त लोग ने SRA किया है, मैं उनको देखी, लेकिन मुझे खुद को ऑपरेशन करना तो मैं डरती हूँ आ जाने, मुझे अपने हाल नहीं करवाना, पैसा नहीं मेरे पास, तो सरकार की भी तो कुछ स्कीम है सरकार हमारी तरफ वो नजर से नहीं देखती जो नजर से देखना चाहिए। सरकार चलो चल रहे जाने दो, चलो चल रहे जाने दो, ऐसा नहीं होता और हमको ऐसा नहीं रहना। तीसरा पुलिस स्टेशन, अभी हाल ही 6 महीने पहले की बात है, ये मैं खुद का एक्सपीरियंस बता रही हूँ। मेरी दादी ऑफ हो गई और मैं पुलिस स्टेशन गई थी एनओसी लेने, और शायद मैं ऑफिस में गई थी और मेरे को ऑफिस में फोन आया तुम्हारी दादी ऑफ। मैं वैसे ही घर पे आई थी, साड़ी पे थी और मैं पुलिस स्टेशन गई एनओसी लेने। पुलिस वाला दूर से देख के मुझे, मैंने बताया मेरे ऐसा ऐसा हो गया है और मुझे एनओसी चाहिए। उसने मुझे डायरेक्टली पूछा आपके घर में कोई पुरुष व्यक्ति है या नहीं। मतलब क्यों, मैं आपको इंसान नहीं लग रहा? नहीं हमको पुरुष व्यक्ति चाहिए। मतलब मैं हिजड़ा हूँ इसलिए आप ऐसे बोल रहे हो? मैं पुलिस स्टेशन में आवाज बढ़ा के बात किया। इवन इतना भी कहा मैं ह्यूमन राइट्स में काम करती हूँ, तो 2-4 पुलिस वाले ऐसे देखने लगे। एक पुलिस टेबल पे बैठा था मेरे साथ, उसके बाद में 4-5 पुलिस हलवादार आ गए और सुनने लगे क्या बोलते। मैंने बता दिया अगर मैं ऐसा हूँ, अभी मेरे डैडी बहुत दारू पिए थे, वो उठ भी नहीं पा रहे और उनकी साइन चाहिए, कैसे ले जाऊं? मैं बोला चलो पुलिस जी आप ही चलो घर पे और कंडीशन दे। बिल्कुल सुने नहीं वो हमारे। आखिर में मैंने टैक्सी करके मेरे पापा को गाड़ी में डाल के पुलिस स्टेशन लाया, फिर मुझे एनओसी दी। पुलिस वाला सॉरी बोला, मुझे सॉरी की जरूरत नहीं चाहिए, तुम सॉरी मत बोलो लेकिन हमारा काम करो, हमारा हुलिया देख के मत कुछ करो, लेकिन हमारा हमको एक इंसान समझ के हमारा काम करो। जो कोई भी देखेगा ट्रांसजेंडर, ये क्या है ये नहीं समझते हम। अगर कोई समझा सकता है तो नॉर्मल पब्लिक भी, मैं रोज भी कभी ट्रेन से बस से या ट्रैवल करते तो लोग अरे मक्खी चली जाएगी, कितना बोलना पड़ता है। चाय वाले चाय लेके जा रहे हैं, अरे इधर उधर टकरा गए, ये क्या है, कभी देखे नहीं क्या ट्रांसजेंडर। तो अगर ये नहीं होना है तो तुम लोग मतलब पब्लिक, या तो सरकार ने ऐसे प्रोग्राम्स चलाना चाहिए कि ट्रांसजेंडर का अवेयरनेस हो। एड्स का अवेयरनेस कैसे किया? आज एड्स से कोई डरता है? मैं नहीं डरती और ना एड्स पे बात करने से डरती हूँ। मैं मेरे माँ बाप के सामने मेरी सिस्टर को भी समझाती हूँ एड्स कैसे होता है, उसकी प्रॉब्लम्स क्या है, कुछ नहीं, मैं नहीं ये करती। लेकिन मैं ये चाहती हूँ अभी ट्रांसजेंडर के बारे में सरकार ने कुछ प्रोग्राम चलाए अवेयरनेस के। जैसे आज मैं बॉम्बे में जेंडर सेंसिटाइजेशन प्रोग्राम कर रही हूँ। 100 सवाल हमको पूछते हैं, मैं स्कूल्स में जाकर प्रिंसिपल्स टीचर्स के साथ जेंडर सेंसिटाइजेशन प्रोग्राम करती हूँ। बहुत अच्छा अनुभव मुझे मिला और मैंने बहुत अभिमान से कहा कि हाँ सच में आप अगर शिक्षक है ना, तो आप अगर बच्चों को बनाते हो, तो मैं भी स्कूल गई थी ना, मैं जब घर से बाहर निकली तो पहले छेड़ा मुझे बिल्डिंग वालों ने, बिल्डिंग के लड़के। स्कूल में तो बाद में, स्कूल में टीचर ये कुछ तो अलग है, क्लास बेंच पे बैठ, ये थोड़ा लड़की जैसे करता है, तो उसको बाहर खड़ा करो, हाथ खड़ा करके पूरा क्लास बंद होने के बाद स्कूल छुट्टी के बाद उसको बाहर देना। कोई सर आएगा हैरेस करेगा, कोई टीचर आएगी, बच्चे लोग हैरेस करेंगे, रास्ते से चल रहे सीटी मारेंगे, ये सब हमको बहुत तकलीफ देती है। तो इसके लिए हम चाहते हैं कुछ ऐसा हो, सर प्लीज कुछ ऐसा हो हमारे लिए कि दुनिया भी कहना चाहिए कि हाँ नहीं ये इंसान है, ये हिजड़ा नहीं, इंसान कहना चाहिए, मैं चाहती हूँ। और मैं और एक बात बोलना चाहती हूँ कि मेरे खुद के चेले ग्रेजुएट है, बहुत से अच्छे फोटोग्राफर्स वगैरह है, जब भी जॉब के लिए जाते हैं, मैं अभी थोड़ी देर पहले बोला नहीं बाबा तुमको कौन जॉब देगा, हमारे ऑफिस के बच्चे खराब हो जाएंगे। मैं खुद घर काम की हूँ, मैं बर्तन भी मांझी हूँ, आई लाइक दैट। तो मैं मुझे तो ऐसा कभी प्रॉब्लम नहीं हुआ क्योंकि वो टाइम मेरा अलग था, आज मैं साड़ी पे हूँ। लेकिन अभी जो मेरे चेले नाते काम करते हैं उनको यही सुनना पड़ता है कि बाबा तुम हमारे यहाँ काम पे मत आओ, हमारे बच्चे खराब। पढ़े लिखे हैं, जॉब देखने जाते तो जॉब भी नहीं मिलती, आइडेंटिटी खुद का डॉक्यूमेंट्स है वो सही नहीं है, उसकी वजह से उनको बहुत प्रॉब्लम है। एजुकेशन में प्रॉब्लम आ रही है, एजुकेशन ठीक से नहीं हो पा रहा उनका। कोई आज 4 साल में मैंने आज तक एक भी ऐसे ट्रांसजेंडर बच्चा नहीं देखा कि जो टीजी बोल के स्कूल गया उसको एडमिशन मिला है। क्यों नहीं गया? क्योंकि खुद डरती है, वो बच्चा भी डरता होगा, अरे मैं ऐसा हूं मैं कैसे बताऊं, और अगर मैं मेरे माँ बाप को बताऊं तो मेरे माँ बाप तो मेरे को शौक देंगे, चटके देंगे, खाना पीना नहीं देंगे, या तो ऐसे लड़कियां भी बहुत है जिनको घर वाले बहुत हैरेस करते हैं। तो लड़की है ये दिखाने के लिए उसको पूरा पहचान कराना पड़ता है उसके बॉडी का, लेकिन तुम उसका बॉडी का मत देखो, उसका दिल देखो ना, उसका दिल सच में लड़की है या लड़का है। जब लड़की पैदा हुई तो पिंक कलर का ड्रेस लेके गए, लड़का पैदा हो गया तो ब्लू कलर का शर्ट लेके गए, या कोई गाड़ी कार लेके गए लेडी। तो आप ये क्यों नहीं सोचते कि वो बच्चे को सच में गाड़ी पसंद है या गुड़िया पसंद है, या वो बच्चे को सच में पिंक कलर का टॉप पसंद है या शर्ट पहनना पसंद है। ये पहले समझना चाहिए, ये अवेयरनेस होना चाहिए लोगों में। और मैं चाहता हूँ कि इसके लिए जितना भी आगे काम होना चाहिए, मैं इसके लिए आगे हूँ। और ये मेरी बहुत रिक्वेस्ट है कि ये होना चाहिए, क्योंकि बहुत ट्रांसजेंडर लोग खुद को सुसाइड कर रहे हैं। हाल ही में बॉम्बे में मनसे के कुछ लोगों ने सेक्स वर्कर ट्रांसजेंडर को बहुत पीटा है, इतना पीटा है कि बस लड़की लोग ने वो लोग वहां पे जाके झूठ बोले। पहले बताया, पहले मैं नाइट में न्यूज जो सुना मैंने सुना, एक लड़की बोल रही मेरे पापा यहाँ से जा रहे थे, उसको छेड़ा। दूसरे दिन सुबह 6 बजे वही न्यूज सुनी मैंने, 4-5 ट्रांसजेंडर ने वो लड़की को छेड़ा। फिर ये न्यूज चेंज कैसी हो गई? वो ट्रांसजेंडर है इसलिए तुम लोग उसकी कदर नहीं कर रहे। उसने फिर सुसाइड करने का कोशिश किया तो भी वो कुछ नहीं हुआ। वो लोग जिन्होंने मारा, क्यों कोई कुछ नहीं कर सकता? पुलिस नहीं आगे आई, पॉलिटिकल्स लोग भी नहीं, वो तो पॉलिटिकल्स है। हमको लोकल गुंडों से प्रॉब्लम, पुलिस से प्रॉब्लम, पब्लिक से प्रॉब्लम, सबसे प्रॉब्लम। तो जिएंगे कैसे? ये कंडीशन है। बहुत से ट्रांसजेंडर, मैं एक जोगती कम्युनिटी से हूँ और बहुत से गांव में हमारे जोगती लोग गाना बजाना करते, देवी का रात भर जगराता करते और उसके ऊपर उनका घर चलता है। लेकिन आज खुद का घर भी नहीं है। कितने ट्रांसजेंडर्स लोग को, कितना जोगती लोग रात भर वो एक बार घर से निकलते तो 8 दिन के बाद खुद के घर पे आते, क्योंकि 8 दिन पूरा वो 4, 8, 10 गांव मांगेंगे तभी जाके आएंगे अपने घर पे, सिर्फ एक रात के लिए। सैटरडे नाइट, संडे को वापस निकल गया। ये उनका जीवन है। घरकुल योजना नहीं है हमारे लिए, कुछ पेंशन योजना है, उसमें बीच में कोई पैसा खा रहा है। काफी सालों से जोगती लोग के लिए पेंशन चालू है, लेकिन 700 रुपए पेंशन है, सिर्फ 200 रुपए हाथ में आता है। वो भी 6 महीने बाद 200 रुपए मिलता है, बाकी 5 महीने का मालूम नहीं कहाँ जाता है। उसके बाद जो भी गवर्नमेंट सेक्टर है और जो प्राइवेट सेक्टर है, वहां पे हमें जॉब अवेलेबल करने के लिए जो भी प्रयास हमें करना पड़े, या हमें हाई कोर्ट या सुप्रीम कोर्ट तक कुछ अपील करना पड़े, तो हम उसके लिए तैयार हैं। वो एक हमारा काम है। और मैं चाहूंगी, जैसे रचना जी ने नानसा में बहुत कुछ बताया है, हमारे यहाँ शिवानी करके एक ट्रांसजेंडर है, वो डांसर है और बार डांसर। उसने एक दिन अपना काम करके वो ओनर से अपना पैसा मांगने गई। ओनर ने उसको बाजू में लिया, 2-3 जन ने उसको लात, बुक्की, पट्टा, चप्पल सब चीज से मारा, बहुत मारा। उसको जे हॉस्पिटल में गई थी वो, और कोई पुलिस वाला उसको नहीं देख रहा था। हमारे ऑफिस की नेहा मैडम ने उसका केस हैंडल किया है। मैं खुद जे हॉस्पिटल गई, एक डॉक्टर उसके लिए आता था, उसको अंदर लेके जाता था, और बाद में अचानक 10-15 डॉक्टर लोग आते थे जो कि पढ़ाई कर रहे थे। वो उसको खोल के, नाप के, पट्टी से, ये एक बार मैंने बोला चलो एक बार चेक करो, मेरे सामने एक बार चेक हुआ। फिर वो बाहर आई, फिर कुछ अंदर बातचीत हुई, फिर उसको लेके गए, फिर उसको कपड़ा उतारने बोला तो वो मेरे को बताने आई कि वो मेरा कपड़ा उतार रहे वापस। तो बोला मैं आती हूँ तुम्हारे साथ अंदर, मुझे नहीं आने दिया। तो ये हैरेसमेंट डॉक्टर लोग ने नहीं करना चाहिए हमारे साथ। हमारे शरीर हम आपको क्यों दिखाए? आपके बॉयफ्रेंड हो हमारे, या पति हो हमारे? वो सोता है, उसको भी दिन में मैं नहीं दिखाती बदन। जो मेरे साथ सोता भी होगा, मैं दिन में उसको बदन नहीं दिखाती। तो रात में देख लाइट बंद करती, दिन में नहीं देखती। दिन में अगर करता तो इज्जत कर, रात में बेइज्जत, आदत हो गई। लड़की का रेप होता है तो पूरा ऐसा मीडिया खुल करता है। ट्रांसजेंडर पे रेप हुआ, कभी सुना? ट्रांसजेंडर पे रेप हुआ, कोई FIR दर्ज हुआ, किसको अरेस्ट हुआ? नहीं हुआ। हमारे यहाँ एक ट्रांसजेंडर को रेप करके से गाड़ी से फेंक दिया। आज वो बच्चा किसी बार में डांस कर, तब कि वो ट्रांसजेंडर नहीं था वो टाइम पे जब भी उसका रेप। वो बच्चा एक 16-17 साल का बच्चा है, लेकिन आज वो ट्रांसजेंडर है। किस लिए बना वो पता नहीं, वो बनेगा कि नहीं। काफी लोग हैं, मैं सोच सकती हूँ, अरे मैं जैसा रहना चाहूँ वैसे, किसी जबरदस्ती नहीं है मेरी। लेकिन मैं आज अगर वो बच्चे को वो इंसिडेंस नहीं होता तो आज शायद वो बच्चा किसी और टाइप में होता। मैं ये नहीं बोलती वो मेल होता, वो ट्रांसजेंडर होता या गे होता या बाइसेक्सुअल होता, लेकिन खुद का एक उसका हक रहता कि मैं हूँ। लेकिन अभी जब भी वो किसी को बताने जाता है तो वो इंसिडेंस उसको याद आता है कि बारिश मेरे सामने ही उसको फेंक दिया गया था, हम लोग नाके पे ही खड़े थे, बहुत बुरी हालत थी उसकी। ये हमारे साथ ऐसे बहुत हुआ है आज तक और इसके पहले भी। अभी तो नालसा आने के बाद भी कुछ चेंजेस नहीं है, हम चाहते हैं कुछ चेंजेस हो, तो प्लीज़ आप बहुत सारे स्टेट से लोग आए हो और आपके यहाँ पे भी बहुत ट्रांसजेंडर्स होंगे, अगर उनको कोई तकलीफ परेशानी हो तो प्लीज़ आप आगे बढ़ के आगे दोस्ती का और मदद का हाथ बढ़ाइए उनके लिए। बस इतना ही चाहूँगी। थैंक यू वेरी मच।
My name is Steve, and I actually have made my presentation in English and speaking Hindi so that it's easier. So, रचना ने ऑलरेडी बोल दिया नासा के बारे में। मैं बस दो चीज बोलना चाहूँगा नासा के बारे में कि एक है कि ये नासा जजमेंट को हम बोलते हैं कि हिस्टोरिक लैंडमार्क जजमेंट, क्योंकि सिर्फ नासा इसी जजमेंट में लिखा हुआ है ट्रांसजेंडर लोगों का सेल्फ आइडेंटिफिकेशन, मतलब वो अगर चाहे तो आपने आईडी कार्ड जो अपने होगा वोटर आईडी कार्ड, पैन कार्ड, आधार कार्ड, ये सब में वो अपना जेंडर चेंज कर सकते हैं, मेल फीमेल या ट्रांसजेंडर कर सकते हैं। और उसके लिए उन लोगों को कोई भी मेडिकल डॉक्यूमेंट्स का सबमिट नहीं करना पड़ेगा, क्योंकि मेरे ख्याल से इंडिया इज द सेकंड कंट्री जहाँ पे ये सेल्फ आइडेंटिफिकेशन का रिकॉग्निशन मिला है हम लोगों को। पहला देश है अर्जेंटीना और दूसरा देश है इंडिया जहाँ पे हम लोगों को सेल्फ आइडेंटिफिकेशन का रिकॉग्निशन मिला है। बाकी सब जगह पे अगर ट्रांसजेंडर लोग अपना आईडी कार्ड चेंज करना चाहते हैं तो उनको अपना मेडिकल जो उन लोगों का सर्टिफिकेट या वो सब डॉक्यूमेंट्स उन लोगों को सबमिट करना पड़ता है। तो लेकिन नासा के अनुसार हम लोगों को ये करना नहीं पड़ेगा, तो इसीलिए ये एक हिस्टोरिक लैंडमार्क जजमेंट है। और लेकिन नासा का भी बहुत सारा थिंकिंग है, उसमें मैं सिर्फ दो अभी बोलना चाहूँगा। एक है कि ये पूरा जजमेंट मतलब 130 पेजेस का जजमेंट है, वहाँ पे सिर्फ 2 जगह में ट्रांसजेंडर नेम के बारे में मेंशन किया गया। ट्रांसजेंडर नेम मतलब जो लोग फीमेल बॉर्न हुआ लेकिन वो लोग मेल होना पसंद करते हैं, सिर्फ 2 जगह पे उन लोगों के बारे में मेंशन किया गया। और सेकेंड ये है कि ये कंपनी के ट्रांसजेंडर लोगों का जो सेक्सुअल प्रेफरेंस है, जैसे कि उसको कोई लड़की पसंद है या लड़का पसंद है, या फिर उसका शादी का राइट्स या एडॉप्शन का राइट्स या इनहेरिटेंस का राइट्स, वो सब मतलब वो सब के बारे में नहीं लिखा है नासा में। तो ये सेकेंड क्रिटिक है नासा का। तो नासा के बाद तो और भी बहुत सारा कंफ्यूजन का जगह है नासा में, तो इसीलिए मिनिस्ट्री ऑफ सोशल जस्टिस एंड एम्पावरमेंट ने नासा के बाद एक क्लैरिफिकेशन पिटीशन फाइल किया सितंबर 2014 में। तो उसका फर्स्ट पॉइंट ये है कि हिजरा यूनास नासा में और मेंशन किया है कि हिजरा यूनास के 2 शब्द, तो ये 2 शब्द भी सिर्फ ट्रांसजेंडर कंसीडर होगा या फिर ट्रांसजेंडर, एक्चुअली ट्रांसजेंडर एक बहुत बड़ा कंप्लीट टर्म है। इसके अंदर हिजरा से क्योंकि हिजरा तो इंडिया में कभी कई जगह पे साउथ इंडिया में जैसे कि वो लोग मानते हैं कि ये कल्चरल आइडेंटिटी है, और जैसे हम लोग का बेसिक में कई लोग मानते हैं कि ये प्रोफेशन है, तो कहीं ये कल्चर है, कहीं ये प्रोफेशन है, तो ये एक आइडेंटिटी है ट्रांसजेंडर के अंदर जो पड़ता है। और ट्रांस वुमन जैसे कि जो लोग भी पहना करते हैं लेकिन वो फीमेल होना पसंद करते हैं, ट्रांस मेल, ये सब भी ट्रांसजेंडर ट्रांसजेंडर के अंदर के या सिर्फ पीड़ा और भिन्न कम्युनिटी का जो आएगा या फिर और भी ट्रांसजेंडर कम्युनिटी का जो डिफरेंट सेक्शन है वो भी है। सेकेंड पॉइंट उन्होंने ये दिया था कि इतना अभी जो इतना वर्ड जो है वो कोई यूज नहीं करते, वो अभी एक बहुत मतलब नेगेटिव क्रेडिबिलिटी हिसाब से लिखा जाता है कि और ट्रांसजेंडर का इक्विवेलेंट मीनिंग भी वो नहीं है, वो पहले यूज होता था कानून लेकिन अभी वो यूज नहीं होता है। अभी जो वर्ड यूज होते हैं वो है ट्रांसजेंडर। और थर्ड पॉइंट ये था नासा में लिखा हुआ है कि नासा का जो जज थे, नासा जज था, उन लोगों ने लिखा है जज में कि एक उन लोगों को पता है, मतलब जज को पता है कि एक एक्सपर्ट कमिटी कंस्टिट्यूट हुआ है और वो एक्सपर्ट कमिटी को निर्देश दिया गया कि वो लोग एक स्टार्टिंग करें ट्रांसजेंडर लोगों का जो प्रॉब्लम से के ऊपर और 3 महीने के अंदर वो अपना रिपोर्ट फाइल करें, पेश करें। लेकिन नासा के जज को भी पता नहीं था कि एनएचए ने ऑलरेडी अपना जो ये रिपोर्ट है ऑलरेडी जनवरी 2014 में सबमिट कर दिया, जो कि नासा के तरफ पहले ही है, लेकिन वो पता नहीं था नासा के जो जज थे उन लोगों को। और नेक्स्ट पॉइंट है ये सेक्सुअल ओरिएंटेशन और जेंडर आइडेंटिटी डिफरेंट चीज है। मतलब मेरा सेक्सुअल ओरिएंटेशन है, मेरा सेक्सुअल प्रेफरेंस, मुझे लड़का पसंद है, लड़की पसंद है, या दोनों पसंद है, या कुछ और पसंद है, या कुछ भी पसंद है, ये मेरा सेक्सुअल प्रेफरेंस है एंड दैट इज नॉट सेक्सुअल ओरिएंटेशन। और जेंडर आइडेंटिटी क्या है, मेरा मैं ट्रांस हूं या मैं जेंडर नॉन कन्फर्म हूं, मैं मेल हूं, मैं फीमेल हूं, तो ये दो डिफरेंट चीज है। तो लेकिन नासा में कहीं ये कंफ्यूजन है, तो एनएचए ने क्लैरिफिकेशन में यही डाला क्योंकि कोई ट्रांसजेंडर जेंडर आइडेंटिटी है, ट्रांसजेंडर लोगों का सेक्सुअल प्रेफरेंस भी लेस्बियन हो सकता है, गे हो सकता है, इंटरसेक्सुअल हो सकता है, बाइसेक्सुअल हो सकता है। तो ये नेक्स्ट पॉइंट। और लास्ट पॉइंट उनका ये था कि नासा में जैसे लिखा है कि ट्रांसजेंडर लोगों को अदर ओबीसी क्लास से कंसीडर करने के लिए और उन लोगों का जो रिजर्वेशन है वो भी उसमें ट्रांसजेंडर लोगों को इंक्लूड करने के लिए। लेकिन यहाँ पे एक प्रॉब्लम होगा क्योंकि जैसे कि ओबीसी का जैसे कैसे होता है, मेरे ख्याल से ये अगर हेरिडिटरी है, अगर मेरे पापा बायोलॉजिकली है, मतलब मेरे पापा के पास और मम्मी के पास अगर एससी एसटी या ओबीसी सर्टिफिकेट है तो वो ऑटोमेटिकली मेरे पास आएगा और मैं भी जाके वो रिजर्वेशन मांग सकता हूँ। लेकिन ये ट्रांसजेंडर का जो रिजर्वेशन होगा वो तो ऐसे नहीं होगा, मेरी मम्मी ट्रांसजेंडर है इसलिए मैं ट्रांसजेंडर हूँ, ऐसे तो होगा नहीं। तो इसीलिए इसका कैटेगरी, इसका क्राइटेरिया अलग होगा। अगर आप पूरी क्राइटेरिया में डालोगे, किसी का जो क्राइटेरिया है अगर उसमें या फिट करने की कोशिश करोगे तो वो यहाँ पे कोई एप्लीकेबल नहीं होगा। और ऊपर से कोई ट्रांसजेंडर लोग भी शेड्यूल कास्ट के हो सकते हैं, शेड्यूल ट्राइब के हो सकते हैं, ओबीसी हो सकते हैं। तो ये ओवरलैपिंग जो है तो उसको ख्याल रखने के लिए ये पॉइंट है। और ये सितंबर 2014 में हम लोगों ने फाइल किया था, लेकिन जून 2016 में इसका सिर्फ एक ही रिप्लाई आया था, सिर्फ ये पॉइंट पर कि नासा सिर्फ ट्रांसजेंडर लोगों का जो जेंडर आइडेंटिटी का रिकॉग्निशन है सिर्फ उसके ऊपर है। लेस्बियन, गे, बाइसेक्सुअल लोग यहाँ पे नासा में इंक्लूड नहीं होते हैं। और बाकी जो पॉइंट्स था जो नोटिफिकेशन में भी था उसका कोई रिप्लाई अभी तक नहीं आया। और मैं ट्रांसजेंडर बोर्ड जैसे नासा में लिखा हुआ था, ट्रांसजेंडर बोर्ड सेंट्रल और स्टेट गवर्नमेंट को निर्देश दिया गया था ट्रांसजेंडर बोर्ड डिफरेंट स्टेट में करने के लिए, जो बोर्ड देखभाल करेगा ट्रांसजेंडर इश्यूज को। तो ये कुछ हम लोगों ने ये बाकी फाउंडेशन को कैंसर के वहाँ से लोगों ने ये पेज निकाला 2008। एक्चुअली ये हम लोग मानते हैं कि इंडिया में सबसे ज़्यादा प्रोग्रेसिव स्टेट है तमिलनाडु ट्रांसजेंडर इशू के ऊपर, क्योंकि वहाँ पे 2008 से ही एक उनका अपना स्टेट का आर्गनी क्रेडिट होता है, आर्गनी इज द रीजनल टर्म। सो वो 2008 से ही वो बोर्ड था, लेकिन नासा के बाद
So what I said is that we belong to the organization called Center for Equality, which is based in Kolkata, and we primarily work with lesbian and bisexual women and trans men for last 18 years. Today we completed 19th year, and today is our 19th birthday. And there are a lot of differences between the issues of transmasculine and transfeminine communities, and definitely gender non-conforming communities. But as a movement, we are strong, held together across India, and as it was said yesterday by Shikari. Next thing to start with my presentation is बहुत लोग जैसे यहाँ पे भी और पहले भी एक चीज होता है कि पूछते हैं कि मैं ट्रांसजेंडर हूँ या नहीं, मैं ट्रांसजेंडर कम्युनिटी से हूँ या नहीं। ये क्वेश्चन मुझे बुरा नहीं लगता है, खराब नहीं लगता है। यहाँ भी लोगों ने मुझे पूछा क्योंकि मुझे देख के समझ में नहीं आता। People ask me whether I am a transgender or not, whether I belong to the transgender community or not. I don't feel bad about that because it comes from, it's a sense I can understand, ये समझ में आ जाता है कहाँ से ये क्वेश्चन आते हैं। कोई मुझे टीज करने के, टॉन्ट करने के लिए, खराब होने की कर रहे हैं या फिर समझने के लिए कर रहे हैं, इग्नोरेंस या अनअवेयरनेस से कर रहे हैं। फिर होता है कि भीख मांगने की क्वेश्चन आती है, अगर ये ट्रांस हूँ या नहीं हूँ, अगर मैं सालों से काफी सालों से मतलब hundreds of years स्ट्रक्चरली और हिस्टोरिकली ऐतिहासिक रूप से अगर मेरे ऊपर, अगर मेरे तरह के लोगों के ऊपर शोषण है तो मैं ट्रांस हूँ या नहीं हूँ, मैं भीख मांगूंगी, वो कोई डिफरेंस नहीं होता है। लेकिन हम लोगों को रास्ते पे ट्रांस लोग ही दिखते हैं और जब हम ट्रांस इशू पे बात करते हैं तो हमारा पहले बात ये आता है हम क्यों सपोर्ट करें, ये तो भीख मांगते हैं हमसे, ऐसे गाली देते हैं, वैसे करते हैं। तो ये ट्रांस होने की जरूरत नहीं है। ये सब जिनके पास रिसोर्सेज नहीं है, जिनके पास क्षमताएं नहीं है, क्षमताएं नहीं है, एजुकेशन नहीं है, चीजें नहीं है, वो ऐसे आ जाते हैं। कहाँ से ये होते हैं? ये लाइवलीहुड ऑप्शंस हो जाते हैं, चाहकर भी ये आगे नहीं जा सकते। तो थोड़ा सा मैं बोलूंगी कितने सालों से कैसे ये लीगल, जैसे लीगल ट्रेन है, तो लॉ कैसे इनविजिबलाइज करते आए हैं और लॉ कैसे ट्रांस पर्सन्स को और जेंडर नॉन-कन्फॉर्मिंग पर्सन्स को दबाते आए हैं, इनविजिबलाइज करके इनके इश्यूज को हटा के इनके बारे में बात ही नहीं करना चाहते हैं और क्रिमिनलाइज करते आए हैं। फर्स्ट जब ब्रिटिश, so I said it's the question of whenever we start thinking about transgender issues, the question comes why we are going to support transgender issues. Transgender persons beg on street and they ask for money and they do a lot of talks on streets. It's like if somebody is some community or somebody is marginalized for hundreds of years, they don't have resources. It can happen irrespective of being
respects, this act, it works in this way that ऐसे काम कर रहा है कि कोई 16 साल के नीचे इनके साथ इंजर्ड पर्सन्स के साथ हो तो उसको लेके जाकर रजिस्टर मेंटेन किया जाता है जिनमें आप इनके नाम लिखा जाता, पुलिस कुछ भी कर सकता है, इनके नाम लिख सकते हो। ऐसे काफी सारे पुलिस को बहुत पावर दे रहे हैं इनको इनके ऊपर सप्रेस करके रखने के लिए। सो ये है ब्रिटिश टाइम के जो हिस्ट्री है। और इनमें से अगर आप जो फीमेल बॉर्न लोग हैं जिनको जब पैदाइशी फीमेल बॉर्न के रूप से वो होते हैं तब अगर देखते हो तो इनका कोई मेंशन नहीं है। और 1860 में लॉर्ड मैकली ने विक्टोरिया से पूछा था ये जो है 377 को लेकर कि आप एंटी सोडोमी कर रहे हो उसमें औरतें कहाँ आएंगी, तो विक्टोरिया बोले थे नहीं औरतें इसमें नहीं आएंगी। और तो मतलब ये था औरतों को तो सेक्सुअलिटी नहीं होती, होमोसेक्सुअलिटी कैसी कौन सी चीज है। सो लॉ में इन जनरली women's sexuality is invisibilized within the way we imagine law, the law we see it, and when it comes to non-conforming gender sexuality, non-conforming gender identities going beyond two gender norms, there is complete invisibilization. इसके चलते 377 जो था वो चल रहा था 1860 से, वो अभी भी है, उसको लेके भी और एक लड़ाई चल रहा है। 2015 में नासा आया, आप लोगों ने सुना नासा आने के बाद क्या हुआ, क्या हुआ? हाँ, ये कुछ स्कीम्स है जो दिया गया है
377 जिसके अंदर क्रिमिनलाइज होते हैं वो एंटी सोडोमी लॉ है, जैसे होमोसेक्सुअल पर्सन और ट्रांसजेंडर पर्सन सब इसके अंदर बुक होता है। और ये कर्नाटका पुलिस एक्ट और हैदराबाद एक्ट के बारे में हमने बोला, वो बोल चुकी हूँ मैं। और पब्लिक न्यूसेंस एक्ट ये सेक्शन 268 है, ये पब्लिक स्पेस में न्यूसेंस करने के लिए है। ये ट्रांसपर्सन पब्लिक स्पेस में ट्रांस होने की वजह से वो लोग जैसे है वो होने की वजह से ही बुक हो जाते हैं। जस्ट बी ट्रांस दे आर बुक अंडर दिस एक्ट। और लास्ट सेशन में कुछ सेशन पहले एक बात हो रहा था वीडियोस हर्ट का सेक्शन 320 उसमें भी बुक होते हैं, क्योंकि स्टेट फ्री कोई हेल्थ जेंडर अफर्मेटिव सर्जरी या थेरेपी का कोई हेल्प नहीं देते हैं ट्रांस पर्सन्स को। सो ट्रांसजेंडर स्पेशली गो फॉर जेंडर अफर्मेटिव जो कैस्ट्रेशन मैस्ट्रेशन के लिए जाते हैं और दे आर बुक अंडर दैट अंडर वीडियोस हर्ट बिकॉज क्योंकि वो लोग अपने खुद को हर्ट कर रहे हैं ये बोल के। ये डिबेटेबल है क्योंकि फिर अलग से दैट आल्सो गिव्स लाइसेंस टू वो डॉक्टर को भी लाइसेंस देते हैं कि फिर ऐसे करते उनके ऊपर कुछ भी करने के लिए, लेकिन वो खुद से जाते हैं ये भी है। सो इट इज क्वाइट कॉम्प्लेक्स। I guess I have to stop doing और ये लॉज नहीं है, जैसे उन लोगों ने भी बोला कि सेक्सुअल हरासमेंट और सेक्सुअल असॉल्ट का कोई लॉ नहीं है, डिस्क्रिमिनेशन एंटी डिस्क्रिमिनेशन कोई लॉ नहीं है, मैरिज और पार्टनरशिप का लॉ नहीं है, इनहेरिटेंस का कोई लॉ नहीं है और अडॉप्शन का कोई लॉ नहीं है। ये इसके बारे में भी काम करना है। और क्योंकि नासा ये सब के बारे में कुछ बात नहीं किया है और बिल के तहत ये कितना आता है, क्योंकि बिल भी काफी दिनों से लटका है, वो हम सबको शायद देखना है। थैंक यू।
Hi everyone, I would like to start kind of discussion. I'm going to talk to you people. I don't want to give us a lecture. I'll start with Kamla Vasant's line. She beautifully said, nature creates diversity and the people, gender creates makes discrimination. So the transgender persons are not very recently created. I'm sure they will be they're from the 18th century, 5th century or something like that. So do you think we will be sleeping throughout the years and maybe in 2014 the Nalsa Judgment came, which is also we need to fight for everything to go to court, and for each thing we need to cite just Nalsa judgment. You think we don't have other judgments to actually work on it? So,
like we discussed earlier, EIL is one solution, the other solutions are the awareness drive, the protests on the street, lobbying the politicians, writing letters to the government, so on and so forth. So I'm aware that there are other solutions as part of that.
So how does the mobilization and it happen? It will happen by getting together, by the movement, by marching on the street, by bringing them with us, walking with them, and making the institution more stronger for the people. So let's go back to the short in the time. Let's only talk about the PIL. First, PIL we could file a report. Procedure for changing gender identity based on identity. Like all these people said, that it gives a lot of problems in getting the transgender change and the gender change. So like this file here, I did one of the cases in Supreme Court where my client petitioner, Richmond Basar, had a PAN card in the name of May. When answer judgment came, he provided the third gender, transgender gender. So she got her Aadhaar card made in the third category. So now when the notification of income tax department came in, gave your PAN card, the Aadhaar card, she failed to do that and she failed to set up a company. Because of which she faced a lot of economic problems. So she was identified as entrepreneur of the year by the government. So she failed to form a company. So these are there are small issues yet to hold a very importance in our society. So somehow we filed a petition to the Supreme Court and we succeeded, and now there is a third gender in PAN card. And secondly, gender neutral toilets. Third, education. So all of us have been to various big private institutions, government or private. So how many do we come across with transgender people? We barely have any person with us. We studied with lakhs of people. We just see them anywhere with us. No, I don't think. There are more than the survey tells. There are more than 5 lakh people. Yeah, 5 lakh transgender persons. And out of which, how many people go to the school? The question is still unanswered. The fourth is inheritance rights. Though marriages and inheritance rights are still governed by personal laws, so how do we deal with this question? Inheritance rights. Do we have the rights or not? Fifth would be protection of traditional practices. Third, transgender marriages. Seventh, segregation, security with dignity in jails and hospitals. This seventh point is very important because judicial practice, yes. They're begging, okay, they're dancing, singing, and so there are a lot of schemes of government, GO20, which says that to avail the pension and housing facility, you need to quit
different. And the Muslim or speak of responsibilities of services for the responsibilities of that transgender business board. Only one we know it will be just of time. Issues of gender identity certificate where transgender person based on the recommendation of the district we become transgender justice committee. The certificate issued by the self-identity that individual chooses male, female, TG, which can be used to revise all the legal documents such as voter ID, passport, driver's license, Aadhaar. The certificate should be acceptable to all authorities for indicating the transgender, gender, or all official documents and will avail access to all religious beliefs and benefits. Till this time, transgender certificate was not issued, identity certificate was not issued. We challenged this report. And another 2 points we challenged the report. Even though there is a transgender justice policy, the Kerala government violated 2 important points of the NALSA judgment. First one is, already Archana spoke about that. First one is, every transgender person has a legal right to decide and determine their gender identity. And another point by the NALSA judgment is that no one shall be forced to undergo medical procedures including SRS, sterilization or hormonal therapy as a requirement for legal recognition of their identity. And the Social Justice Department issued by the identity card does not mention the identity of the transgender, only the name, gender, date of birth. We challenge this also before. Include the identity of the transgender person. And another we challenge before that the Education Department of Kerala issued an order in 2018, March 2018, that they have special sanctions given to transgender persons that to include their name as a transgender if provided if they have undergone SRS. It's against the NALSA judgment, it's violation of NALSA judgment, it's violation against the policy. And these 2 things also we have in the court. The case is pending. Even though Kerala is the first state to implement the policy for transgender persons, HRD is the first organization to file a petition before Kerala High Court. It's already reported in all India that case is pending. Court asked for the instruction of the government.
Good evening, everyone. I am Arthur first from Socio-Legal. I would like to introduce myself first of all. I am HRL's first transgender lawyer, who is practicing since last 5 years in the court. So today I am here. Whatever today I am, once upon a time, if my friends of self-equality are here, if they did not discover me from Kolkata, today HRL can find me here. So I am very much thankful to my friend of self-equality and today is their birthday also, so I would like to happy congratulations. So now today I am here. If I want to say something in my state's context, there is nothing very special done by the government of West Bengal, except the Transgender Development Board, and it is a completely non-functioning board. Whatever we are aiming today, that is by the only PIAs. First, there was a judgment on the Education Department. It was a PIA, but it was not done by HRL, some other lawyers. But I am just referring here because that is a very important judgment in all over India sector. Next, another judgment was by O3 Court. That was the PIL filed by O3 Court. O3 have filed several PILs through HML Kolkata and have got some good orders from CCRI, like against the State Bank of India, against the Railway Equipment Board, against the West Bengal Public Service Commission, and some other boards also. She has made that column for the transgender people in the West Bengal Public Service Commission exams in offline system. Then I would like to, I am in favor of that situation where I am not getting the law in favor of myself. I try to use the law with the present legal context. So I have done a case like the 15th of April is very much significant for every transgender people's life. We celebrate in Kolkata also as the Transgender Day. This year, there was date of Bhasha Chetana Samiti of Kolkata. They are celebrating Bangali Sanskrit Utsav and etc. They were celebrating their all these festivals in the set side of London, and it was permitted by the police till 5:30 at the evening. Then they will leave the stage to the transgender people to celebrate their programs. But when it was past already 6 p.m., the Bhasha Chetana, the state self-proclaimed Bhasha Chetana Samiti did not leave the stage, and they started to make some noises with us, and they literally molested the transgender people. Along with some women, Alice was also there, presented. They were also supporting us. But literally they molested us, and then it was allowed to hand-to-hand fight. Then my community people came to the HML Kolkata's office to me. I made an FIR and then go for the STS Kolkata. So then when I registered STS only was asking that it was happened between the trans people and this Bhasha Chetana Samiti. Then why you are putting this 354B, the section of molestation in this case? I said that is under the NALSA principle, and you are bound to register an FIR under this NALSA principle, so you have to do it. Finally, they have registered the FIR, and that person of that Bhasha Chetana Samiti faced the court, and we have to get the belt. So this is my strategy to use the present law in the present context for my trans people. And another thing we are filing, that is the reservations in the West Bengal Transport Corporations by the PIL. We are making the reservations and going to file it the Calcutta High Court very soon. Thank you.
Open the floor.
सबको नमस्ते, जय हिंद। जो समस्या है करे सबको पता है, वहां पर समस्या का बात करने में नहीं आई हूँ, लेकिन जब समस्या को आप एनालिसिस नहीं करेंगे तब आप कोई भी कार्यक्रम उसका संगठन उसका जो आगे जाने नहीं जाएगा, कहीं भी आगे नहीं जाएगा। समस्या को बार बार दोहराना पड़ता है तब जाकर आप रणनीति बना पाएंगे। लेकिन मेरा कहना है, जहां पर दलित आदिवासी
गोविंद पर।
प्रैक्टिकल जो बात थी वो मेरे 2 महीने में कही है। कॉन्स्टिट्यूशन की बात करें हम तो कॉन्स्टिट्यूशन का जो आर्टिकल 17 है उसमें अनटचेबिलिटी की बात की है कि अब अनटचेबिलिटी नाबूद की जाती है। उसके बाद में जो एट्रोसिटी SC/ST एक्ट बना वो 1989 में बना और 2015 में नया अमेंडमेंट आया। पहले जो सेक्शन थी वो 15 तक सेक्शन थी, उसके बाद जेड तक सेक्शन लगाई और जो एट्रोसिटीज होती थी उसके बाद अमेंडमेंट आया। अब देखना यह है कि अब मैं गुजरात के संदर्भ में बात करूंगा कि पूरे देश में गुजरात एक मॉडल विकास का मॉडल देखा जा रहा है, मगर जहां मैं घटना हूं मैंने देखा है, काम किया है, तो गुजरात मॉडल ऐसा मॉडल है वो जातिवाद और कौमवाद है। जो उसकी सरकार आई है वो जातिवाद और कौमवाद के दौर पे आई है, कंधे कराते और जातिवाद भड़का के आई है। उसके मैं उदाहरण भी दे सकता हूँ कि हमारा जो सिस्टम है गुजरात में जुडिशरी का, पुलिस का, एजुकेशन का सब कैसा चल रहा है। मैं 3-4 केसेस शॉर्ट में कहूँगा कि रिसेंटली में एक महिला, दलित महिला कच्छ डिस्ट्रिक्ट में वो सिविल हॉस्पिटल में एक छोटा सा ऑपरेशन कराने आती है और उसके पेट में सीजर रह जाता है। वो सीजर रहता है 4 साल के साथ, 4 साल के बाद उसका ऑपरेशन किया जाता है। ऑपरेशन के बाद वो सीजर निकाला जाता है और वो उसकी डेथ हो जाती है। अब ये केस में हम लोगों ने बोला कि इसके सामने FIR करो डॉक्टर के सामने। बोले नहीं, अभी हम डायरेक्ट FIR नहीं करेंगे, पहले जांच करेंगे फिर हम FIR करेंगे। 6 महीने पहले का इंसिडेंट है, अभी मई महीने में 3 डॉक्टर के सामने FIR हुआ है। दूसरा ऐसा है कि मेघानी नगर जो एरिया है अहमदाबाद में, उसमें एक दलित महिला ने, वो राजपूत कम्युनिटी लोग चाहते थे कि ये दलित का घर यहाँ पे नहीं रहना चाहिए, नहीं होना चाहिए, तो वो दलित महिला को पूरी तरह से उनका मर्डर किया गया। 302 लगी, एट्रोसिटीज केस हुआ। 2014 का इंसिडेंट है, मगर 2017 में उसको आजीवन कैद की सजा दी हमने HRM की तरफ से करवाई। दूसरा एक केस है रिसेंटली में अहमदाबाद में, गुजरात में आपको पता है दारूबंदी है, मगर जितना सरल गुजरात में दिखता है उतना कहीं नहीं दिखता होगा। तो हमारा एक एरिया है अहमदाबाद में कि वहां पे कुटलेगर में बहुत सारा शराब उतारा वहां पे, तो दलित महिला ने उसको रोका कि नहीं ये यहाँ पे आप मत उतारो, हमारे बीवी बच्चे हैं, लड़के हैं। तो पूरा परिवार ने उनका विरोध किया। तो वजह ये हुई कि 3 लोगों ने उन पर अटैक किया और वो दलित महिला को यहाँ तक पूरा केस आप पहले का देखो, अभी का देखो, तो आपको ऐसा होगा कि इतना और इतनी बुरी तरह से तलवार मारा कि बहुत लंबे अरसे तक वो हॉस्पिटल में रहे। ठीक है। दूसरा ऐसा भी होता है कि दलित विधवा महिला शहरी एरिया में अगर मकान लेने के लिए जाती है तो मकान में उनको मिल जाता है, बाद में सवाल को पता चलता है कि ये दलित महिला है, तो फिर ये तो हमारे मंदिर में आए थे, हमारे प्रोग्राम में आए थे, तो फिर उनको कैसा भी करके मकान खाली करवाया जाता है। इंटरकास्ट मैरिज कोई दलित करती है, ये मेरे पास केसेस है, उसी हिसाब से मैं बात करता हूँ। इंटरकास्ट मैरिज की हुई है, दलित महिला को फ्लैट में फ्लैट वाले आप यहाँ पे नहीं रह सकते हो क्योंकि आप दलित हो। सिविल में दलित नर्स नौकरी करती है, वो अच्छी जगह पर रहना चाहती है, वहां फ्लैट वाला चेयरमैन बोलते हैं कि आप सिविल कास्ट के लोग हो, आपको यहाँ रहने का कोई अधिकार नहीं है, आप अपने काम करिए। एजुकेशनल इंस्टीट्यूट है, उसमें भी दलित एट्रोसिटी होती है। पाटन की बात मेरे साथी मंजुला करें एजुकेशन इंस्टीट्यूट होती है, उसमें भी दलित लड़कियों के साथ भी सेक्सुअल हरेसमेंट होता है। उसमें उसका भी एक केस हम लोग गुजरात में लड़े थे 2005 में, और उसके बाद में पाटन में भी एक रेप हुआ था, वो मंजुला में उसकी बात करी। अब मेरा कहने का ये है कि एट्रोसिटीज जो होती है उस पर हम क्या कर रहे हैं, लॉ है एट्रोसिटीज का। प्रॉब्लम ये होता है कि जो सेक्शन लगाई जानी चाहिए वो नहीं लगाई जाती। प्रॉब्लम ये होता है कि फर्दर इन्वेस्टिगेशन मांगते हैं कोर्ट में, तो जुडिशरी से हमको जो न्याय मिलना चाहिए वो भी बहुत कम मिलता है। हम जो केसेस में इन्वेस्टिगेशन सही तरह से नहीं हुआ है उसमें हमने किया है, तो हमको फर्दर इन्वेस्टिगेशन मिलना ही चाहिए। और दूसरा मैं जुडिशरी के बारे में ये कहना चाह रहा हूँ, जो ट्रायल चल रहा है वो डिले चल रहा है। एक पांसा का केस है जूनागढ़ डिस्ट्रिक्ट का, उसमें 1999 में इंसिडेंस बना है, उसमें 48 लोग इंजर्ड हुए थे और एक पे रेप हुआ था। आज 2018 है, तो भी वो केस का अभी जजमेंट नहीं आया और वो केस चालू है। और ज्यादातर ऐसा होता है कि एट्रोसिटीज की जो कंप्लेन होती है उसमें हाईकोर्ट में जाके लोग कॉस्ट करा देते हैं, और कॉस्ट में हाईकोर्ट जो होती है वो मना लोग दे देती है, और फिर वो केस कितना चलता है पता नहीं। इसीलिए आज गुजरात की पोजीशन ये है कि 3,879 केस गुजरात में पेंडिंग है। 56 कोर्ट स्पेशल कोर्ट होनी चाहिए, इसकी वजह से 16 स्पेशल कोर्ट अभी गुजरात में है। तो ये सिनेरियो है। अभी टाइम बहुत कम है इसलिए बात नहीं कर सकूंगा, मगर फिर से ये कहना चाहूंगा कि गुजरात में जो दिखता है वो है नहीं, ऐसा है। जय हिंद, जय हिंद।
मनीषा
जय भीम साथियों, जय भीम। सो गए हैं सारे। जय भीम। जय भीम साथियों, मेरा नाम मनीषा मशाल है, और आपने सिप्रा जी को, संध्या जी को और गोविंद भाई को भी सुना है कि किस तरह से जो जाति भेदभाव हमारे साथ हो रहा है। इसी के साथ में हरियाणा के संदर्भ में और पूरे भारत देश में किस तरह से दलितों पे और वो भी दलित महिलाओं पे जो अत्याचार हो रहा है, और उस
न्याय नहीं देता। हमारी आर्थिक कंडीशन बहुत बुरी दिखाई देती है। तो इस आर्थिक कंडीशन बुरी होने के कारण कोई भी दलित महिला इस तरह के अत्याचार होने के बावजूद इवन के स्कूल में रेप किया जाता है, कॉलेज में भी रेप किया जाता है, हर गांव में रेप होता, खेतों में रेप होता, पर कोई लोग इनको बाहर आके बात करने की हिम्मत नहीं रखता। और हिम्मत भी कहाँ करेंगे, क्योंकि हमें उन लोगों से तो काम पड़ता है हमारा जो आर्थिक स्टेटस है वो चलाने के लिए। तो अभी जब हम लोग समाज के मतलब हम लोगों ने मार्च में एक आंदोलन किया था, महादलित महिला आंदोलन। ये उन महिलाओं का आंदोलन था जो कि मतलब दलित में भी महादलित कम्युनिटी से आती और जो रेप विक्टिम थी। तो 10 लड़कियों ने शुरू किया था। उसके बाद मतलब लड़कियां रो रो के इस आंदोलन से जुड़ रही थी, जबकि गांव के लोग जो थे वो आने नहीं रहे थे, पर लड़कियां रो रही थी क्योंकि उनको पता चल रहा था कि ये जो आंदोलन है हमारे न्याय के लिए और कहीं ना कहीं हम सब लोग वायलेट हो रहे हैं और हमें इस आंदोलन से जुड़ना ही पड़ेगा। तो साथ ही तभी हमने ये आंदोलन शुरू किया। मतलब ये पहल थी, हरियाणा जैसे राज्य में आंदोलन का होना एक बहुत बड़ी बात है, क्योंकि वहाँ पे लोग तो मीटिंग में भी इकट्ठा नहीं होते और इस तरह के मतलब मूवमेंट के लिए कोई काम ही नहीं करना चाहता। उनको लगता ही नहीं कि ये कोई काम है या हमें जुड़ना चाहिए आंदोलन से, या हमें आंदोलन में लड़के कुछ न्याय मिलेगा, हमारे इंसाफ की बात होगी। तो साथियों, इस तरह की परिस्थिति में एक दलित महिलाओं का आंदोलन होना एक बहुत बड़ी बात है। तो उसके बाद हम लोगों ने ये स्ट्रेटेजी अपनाई थी कि हम लोग जहाँ जहाँ पे भी घटनाएं हुई थी वहाँ पे विक्टिम से घर पे गए थे, और फिर उसके बाद जो लड़कियां थी वो लीडरशिप में आई थी। तो हमारा नेक्स्ट स्ट्रेटेजी ये होगा कि जो लॉ कॉलेज की और उसमें लॉ स्टूडेंट थी, विक्टिम थी और दलित लड़कियां थी। और उसके बाद हमारा ये स्ट्रेटेजी है कि अभी जो हम लोग ये अत्याचार हो रहे हैं दलित महिलाओं पे, उनके खिलाफ हमें एक लीगल स्ट्रॉन्ग ग्रुप बनाने की जरूरत है। तो हम लोग जो यंग लड़कियां कानून की पढ़ाई कर रही है, मतलब लॉ के स्टूडेंट है, उनको अपने साथ जोड़ रहे हैं, और जो हमारे यंग लॉयर्स है कोर्ट में, उनका एक नेटवर्क बना रहे हैं, क्योंकि एक स्ट्रॉन्ग नेटवर्क के बिना, क्योंकि बिना कानून के भी कुछ नहीं है। अगर हम लोग कोर्ट में जाते हैं तो कोई अभी हमारे केस लड़ने के लिए तैयार नहीं है। इवन के जो हमारे दलित वकील भी है, लॉयर को भी हमारी बात सुनने के लिए तैयार नहीं होती, और उनको भी लगता है कि मतलब मुझे क्या मिलेगा ये केस लड़के, उनको भी पैसा चाहिए, क्योंकि उनकी भी कोई गलती नहीं है। क्योंकि इस बैकग्राउंड से हम लोग आते हैं और बड़ा पढ़ लिख के वो भी चाहते हैं कि हम कुछ पैसा कमाए, और उनको भी ये लगता नहीं कि महिलाओं के मुद्दे पे हम लोग क्यों काम करें। तो साथियों, जो हरियाणा में मतलब ये कंडीशन है, उसको लेकर के हम लोग बहुत कोशिश कर रहे थे। जो भी 110 केस है जो कि कॉम्प्रोमाइज हो चुके हैं रेप और मर्डर के, तो उन केसों के जो डॉक्यूमेंट्स है वो निकालने के लिए हमें बहुत प्रॉब्लम हो रही है पीआई फाइल करने के लिए, क्योंकि जो जब भी हम कोर्ट में जा रहे हैं तो वो डॉक्यूमेंट्स मिल नहीं पा रहे हमें, क्योंकि बहुत सारे केसेस में क्या हुआ है, जो फैमिली है वो माइग्रेट करके, जब भी ऐसी घटना होती है तो फैमिली वाले गाँव छोड़ के चले जाते हैं, और उसके बाद मतलब वो केस को आगे लेके जाना और उसके केस में पूरा ये करना तो बहुत मुश्किल हो जाता है, क्योंकि हमारे समाज के द्वारा इतना प्रेशराइज किया जाता है विक्टिम को, वो अपने जस्टिस के लिए लड़ने के लिए मजबूर हो जाता है कि वो लड़ने की बजाय उसको छोड़ के अपना घर ही छोड़ के चले जाए। तो इतना बुरी स्थिति में एक मतलब शर्म है हमें इंसान होने पे कि एक इंसान को हम इतना मजबूर कर रहे हैं। एक तो उसके साथ जो घटना हुई है उसने उसको तोड़ दिया, और दूसरी तरफ से समाज के द्वारा मतलब हम सब लोगों के द्वारा उसको इतना प्रेशराइज किया जाता है कि उसको अपना घर और गाँव छोड़ के जाने के लिए मजबूर होना पड़ता है। तो इस तरह की कंडीशन में हम सब लोगों को जरूरत है कि हम लोग मतलब जो भी ये काम कर रहे हैं अत्याचार के खिलाफ, हम सब लोगों को, जैसे आप लोग सब यहाँ पे आए, आपको भी हरियाणा में आके हमारे साथ आंदोलन करने की जरूरत है। और जो इस तरह का ये प्रशासन का जो रवैया, ताकि उसको भी एक बड़ी सीख मिले कि ये एक बहुत बड़ा मूवमेंट है, और इसके द्वारा जो प्रशासन पुलिस अधिकारी है उनको भी मतलब इसके लिए संवेदनशील होना पड़ेगा, और उन लोगों को हमारी बात सुननी पड़ेगी, और उसके लिए हम सब लोगों को इकट्ठा होकर मूवमेंट करना पड़ेगा, और जो लीगल स्ट्रेटेजी हमारी ये अपनानी पड़ेगी। इसी के साथ
Jai Hind friends, good evening to all
of you. My friends have already shared so much about the situation of our community, especially focusing on Dalits, and the session also includes the tribal communities. I would like to put a picture also of the tribal community with whom I have worked for the last 25 years. I joined the Dalit rights movement when I was just 22 in 92, and while traveling across in the field areas of Gujarat and witnessing sexual abuse and violence against Dalit and tribal women made me realize how important it is to organize them, and they were mainly the wives of mountain laborers. And I think that something which was very shocking for a state like Gujarat, talking about non-implementation of minimum wages and forming a union at the age of 25, I realized that I had put myself into a situation where I could become vulnerable to state violence. Where my office was attacked in 1999, and a state CID visited my home, and the time came when I had to leave my home to my parents, and I'm happy that I left them because it was a difficult time at that time. But I just want to put the context that while organizing tribal and Dalit women, I realized that when you're talking about legal aid, when you're talking about providing them justice, you also have to see the pattern of violence which happens across the community, and which includes sexual violence. So sexual violence cannot be seen as one form of violence when you're talking about women from the two marginalized communities. So I think yesterday Kamala also talked about the pattern of impunity, but she also talked about intersectionality. I think that's something which I focus a lot now in my work, which is looking at class with the class, ethnicity, religion, class, and which also includes the mobility and the awareness amongst the community. And I must say that while traveling across the country and also working very intensively in Gujarat, leading a very known organization, Socio-Legal, for 12 years, and working with that organization, I realized how strategically one can work in a state like Gujarat, which what Govind was talking about. I think Gujarat is one of the worst states in the country in terms of violence, not only against Dalits, tribals, and also Muslims. You all know that. But the point is how to address the issue of state impunity, state lawlessness in a Hindutva factor state, which always try to impose ourselves that we are economically developed. So which means that they say that Dalits are also developed, which is fake. Which is a fake information which they are providing. Because the majority of the Dalits and tribals in Gujarat, they are landless agricultural laborers. So one of the issues which I think one has to work upon in Gujarat, and at the moment it's burning in Gujarat, is the issue of land rights. We work a lot on the issue of land rights, but I would say that somewhere we tend to ignore the fact that we are talking about rights of Dalit and Adivasi women, who most of the times are ignored even when we are talking about the economic rights. So when we talk about Dalits and tribals, we say the community is homogeneous, we know that it's not. So somewhere I would say that there's a need to understand how many women from Dalit and Adivasi community, whether it is Gujarat or across the country, are landless agricultural laborers. How many of them are entitlement for land but they are not holding the land? Many of them would be having the land on paper and they might not be knowing about it, and they are not cultivating it. So I think that's a major issue, because majority of the atrocities and crimes against Dalits and Adivasis are based on land. And I feel that there have been killings in Gujarat. We are set with dead bodies in the police stations demanding arrest of the accused. I'm also not practicing law, and I became a lawyer because of a Dalit woman who was fighting for justice for her son who was brutally tortured in police custody. So I think one also has to understand that how do we legally frame a particular issue when we are talking about addressing it in the High Court and Supreme Court. Nafsat is the organization which I headed had taken up several cases, and we have filed PI, whether it was on manual scavenging, whether it is on enforcement of land reforms in Gujarat, whether it was on the issue of discrimination against Dalits in several public places. But I must say that what I have witnessed and seen is also that what is lacking. And it is not only for Gujarat, I think it is across the country. One is the Atrocity Act. We were already talking about 2015, where we formed a coalition of NGOs. More than 500 NGOs came together to form a coalition to bring the amendment in the Atrocity Act, which came. But the point is that the Atrocity Act talks about basket codes. The point is how many cases of sexual violence against Dalit women and tribal women really are
and we said that this is the situation of Dalit women. We want to change it. And is PI going to help us? That's also equally important to understand. We have done so much of authentic research, but those research are just put as research. We have never filed a PI, unfortunately. We could have done it. We did a study of Dalit women's participation in Tamil Nadu, Dalit women's participation in Punjab, in Tamil Nadu and Gujarat. We did go in the High Court, where it came out 63% of Dalit women can't enter the village council office. And we raised the issue, but we could have done it much more in a larger way. In 2006, we produced a document called Dalit Women Speak Out, covering 4 states: Tamil Nadu, Karnataka, Tamil Nadu, Andhra Pradesh, Bihar and UP. 500 Dalit women, only 7% of them had gone to the court, the cases out of 5. We had planned to take up certain cases of extreme forms of Dalit women who had faced a lot of violence to the Supreme Court. We didn't do that. Unfortunately, there was a study which was done by Dr. in Gujarat about understanding underduty, covering 1,589 villages, and we identified 98 forms of underduty practices. That included, we were talking about health as a basic right. We were talking since yesterday and today. We all know that who are the ones who suffer the most in access to reproductive rights? It's the Dalit and tribal women. 50% of Dalit and tribal women are anemic. We have the percentage, but we also need to get that qualitative and quantitative data to put it in the PI. That why is there discrimination in access to public health? Is there discrimination in access to maternal health? Which can give us a framework to take up the issues relating to discrimination against these two communities. In Gujarat, there were some village And that's something very shocking and very painful for us to realize how difficult for us it is to assert our rights. I would like to talk about also the issue of internal displacement. Like when I was, most of the cases which I handled in Gujarat of murders, of extreme forms of mass attacks, we realized that the families had to leave the village. Now, the UN came up with this exact warning of ID, they say that internal displacement, right? But Dalits, under the Atrocity Act, they have the protection, but the government doesn't accept that it is forced migration or internal displacement or social boycott. So, as you know, Haryana, what happened to Ghana and other cases, we know it, right? Which whatever cases. But we all know it that when this happens, the social boycott and forced migration, internal displacement, the women and the girls and the children, they suffer. They suffer. We have taken them for medical treatment. The collector office just there in Bukna, the murder case in Malanpur, they were putting the tents right in the forefront of the collector office. Collector had not never visited them for 1 month. The women have given birth to children right in the open. We went to these women for the vaccination. Now this is the situation of a state like Gujarat. We all know what is the situation in other parts of the country. Right? So I think this also needs to be understood. Now one more aspect which I want to highlight is about atrocity cases where Dalit men are also accused. Now in the Patan PTC gang rape, we got life imprisonment, right? 1 year and 1 month. I just focus on that case. And we got life imprisonment for these 6 accused. Within those 6 accused, there were 2 Dalit accused. And the point was that the judgment was given. The judgment was not given under Atrocity Act but under IPC section 47. So that is something which needs to be challenged. And I would say that it is not only in the context of Gujarat. I think we have to take up judgments across the country. Judgments where we got conviction in sexual violence against Dalit and Adivasi women, and to go through it. And where we have not, like he was talking about compromise, right? So we all have to study those cases. We have to take up those, what are the patterns of cases where we have to challenge the court. We have to challenge the High Court or the Supreme Court. I think not much work has been done on the rights of Dalit and Adivasi women, especially through the legal framework. So we need to work a lot on that. I will not go too much. I was just thinking about one more thing is about again coming back to the fast track court. Now, as per the fast track court, the trial should happen and it should get a judgment as early as possible. Especially I'm talking about, like we talked about Nirbhaya case. Now, Patan happened in 2008, Pipili happened in 2011, right? Khellanji happened in 2007, Babri Devi was 96, Vishaka, wildlife and whatever happened, and the new law, prevention of sexual harassment law is came out. Recently we have in Korapur, this minor Dalit girl, she committed suicide, who was raped by armed forces, like man from the armed forces. We have Delta Megawal, we have Nandini from Tamil Nadu. We can go on and on. The point is, only Dhaka, Khellanji, Patan PTC, we got conviction. The rest, we don't know what is the future. And many of the cases we have lost the case, like there is acquittal. So there is a need to understand that if we want to work with the legal framework strategy, how do we organize our own women? I don't want to include the men. I don't want to include the men. I don't want to include the community. I want to include only the women leaders who have the courage and the commitment, and we can organize them because there are so many Dalit women now pursuing law. But taking the law in your hand and like doing the degree, getting the degree is not the end result. Because they need to be trained how to defend themselves, they face the court.
dedicated to we have already covered most of things, and we all know the condition related cases, the other cases are very low for comorbidity, and the victims of caste discrimination, especially the women, they face barriers at every stage of the litigation process. So I would like to give some legal strategies and suggestions to improve the condition and minimize the attitude. And in a research undertaken by Council for Social Justice Ahmedabad, it was revealed that the IPC cases against abuse were but the SAC cases provision offences and the SAC provisions were not able to improve. And it was also observed that the inadequate representation of Dalit lawyers as self-appointed public prosecutors, special public prosecutors, is also a great barrier in access to justice of Dalit people. So in that case, the reasons for appeals are evidence is not corroborated, victims did not identify the accused person, offences committed not under the ground of SAC, investigation not under competent authority, who is the DSC, not below the rank of DSC, and after the Supreme Court decision of the misuse of SAC Act, it has become SC who are to conduct preliminary investigation and then to register the case. And report not given by the victim. Caste was not mentioned in the FIR of the company. Medical evidence not produced. Victim died during the trial. Victim did not belong to SAC, which is nothing that the caste of the victim is not true. So I have some suggestions today. Usually what we do is we send the victim for medical examination within 40 hours. But most of the time the doctors get used to examine the victim, or the police officials send the victim for examination after 40 hours. And another situation is registration of FIR and taking statement from the victim. Both are different, having different facts and having different situations mentioned. So the very problem we have is recording statement and registration of FIR, and both in the similar manner. There should be no difference in the statements given by the victim. And thirdly, charge sheet. So most of the cases, though we have required after the case struggle or protest and all, charge sheets are not filed. And in the cases go for trial, victims are not informed of the trial date, or they are not provided with the travel expenses or other expenses. They are entitled under the SAC Act. So we need legal assistance at every stage of due process of law. And right from the complaint stage till the appeal stage, we have to accompany a lawyer who is willing and committed to the cause of social equality to be accompanied with the victim at all the stages. For instance, I had a rape case in Madras High Court where immediately knowing that the FIR was registered, we were tracking the anticipatory petitions, and we found that the appellants had already filed anticipatory petition in the High Court, and we intervened, and the anticipatory petition was dismissed for 3 times. But later the appellant was in the lower court, and he was granted bail by the lower court, but still, we found it very important to intervene at all stages of bail applications and other applications. For instance, there can be intervention during anticipatory petition, and also we can file applications for cancellation of bails, and we can file applications to include provisions of SAC and etc. We can file the action petitions before the High Court to file charge within the concerned date, and we can also file petitions before the High Court asking for investigation, and also for any cause we wanted to be implemented as per law, we can approach High Court and file the action petitions. But most of the time, the victims inaccessibility to appoint their own lawyer, it is not happening. And the second thing is appointment of special public prosecutor who have to have 7 years experience. 7 years experience. Mostly, those who have 7 years experience, either they specialize their
practice area of practice into some civil property, or even if it comes to criminal matters, is socialized to some other crimes that are not counted into SAC crimes. And we people who practice in Supreme Court or High Court, we never get to go on academic trials and district courts. So special training of lawyers from minority and oppressed communities with their legal strategies is very intersectional. Like for instance, I'll tell you, when government has given us sexually attack online, she's touching. But when another woman is attacked, her worthiness to be raped is being discussed. When I do something, my worthiness to be raped was discussed, my physical appearance and the background I come from, my habit of breathing, everything was discussed. But this unique harassment or this unique humiliation doesn't happen to dominant class or privileged women. And another thing, whenever this moral policing happens in the minority items, most of the time it happens to a black, fat woman and not a fat woman. When I used to post pictures of serious dresses, I was abused like anything, and I was even questioned if I deserve to practice in the Supreme Court. So despite my social position of lawyer practicing in the Supreme Court, I was criticized for the way I was dressed. But whereas a thin or a fair woman is wearing a model, she was not criticized with dignity, she was not abused with dignity and abused. So this online violence against Dalit women and caste-based and sexual violence against Dalit women in the intimate space have to be considered. And I will give one example of how this law enforcement agencies treat privileged women and Dalit women in cases of online violence. Danya, who is the editor of this women, and actually who is a single popular Tamil who comes from the Tamil community, they face online cases and then they launch campaign. Even before the repealing of 6A and even after the repealing of 6A provision I had, both the officials actions were taken by the police officials. Exclusively, when Danya made campaign, 354B IPC, 5061 IPC, 507 IPC, 509 IPC, and 67 ITAC, and Permanent Prohibition of Harassment of Women Act, Indecent Representation of Women Act, everything was invoked, and the abusers were also arrested. But in my case, after I applied several times of Delhi to China and China to Delhi, nothing happened, and I was advised to save and protect my dignity and my respect as a lawyer practicing in the Supreme Court. And Chinmay, she posted on Facebook, there is no wrongly killing Fisher man who kills fish. She posted this on Facebook justifying the restriction and taking off contradiction. Then people started abusing her. At no point in time we support abuse of any woman, but still in these conditions the police act very fast. And the support, these unconditional support these women get from the law enforcement agencies are very good. But whereas the women who face caste-based violence online, they are not supported, and these legal provisions are not invoked in cases where we are abused. So these online violence spaces have to be taken seriously, I think. And today not also we were talking about marital rape, and I want to add one point to that. During I have known several husbands who have forced their wife to have sex during the menstrual cycle. That forcing to have sex during the menstrual cycle is also a sort of marital rape violence, because the women I have known they have reduced several times, despite of their non-consent, they are being forced to have sex. So these are the things that we found under marital rape. And yesterday I wanted to give a response, but there are so many responses on child marriage, so I went quiet, but I want to make the point now. While talking about child marriages, there was a point raised that education and poverty are the main reasons. Education and poverty are the main reasons for child marriage, increasing number of child marriages. But I personally think child marriages, sati, and humiliating women, everything the marginalized communities. For instance, shaving the head and making you wear white sarees or salmon sarees was very much providing money on the Brahmin communities, and it was not about the marginalized communities. If education could change anything in the society, then why doctors are willing to treat Dalit patients in the rural areas? Why educated MBBS doctors, and today you know online, all those educated engineers sitting in university in Europe, they are screaming against social equality and Dalit rights. So I don't think education is the main problem. And I have also known several illiterate parents like my parents who are very much determined to make their children professionals. And we have also had the dream of becoming professionals. So I have seen several Dalit families from marginalized communities who have sent their children as child leaders, and I have known several children who have ended up in child leaders. But still, I have not seen that number of child marriages among the marginalized communities. If you want, you can also watch modern movie, and there are several movies that say how preparation is well, and specifically, I would like to see there was a term in Tamil, Motta Papati. Motta Papati is head-shaped Brahmin women. Head-shaped Brahmin women, and it was Periyar to fight against their rights and talk of the rights. And when property rights was advocated for women, it was Brahmins who told if women were given property rights, they will elope with down marginalized caste women and other caste women. So I at no point of time admit that education and poverty are the sole reason for gender. The main reasons are not primary reason, and caste and religion, which is a primary social issue in India, has a very big role in this child marriage. Thank you so much.
Thank you. Anybody? Yes. Okay. Good evening. Good evening. I promise to be very fast because you all will be exhausted. Namaskar, Jai. Okay. So I'm going to talk about what we began today with, which is the question, and yesterday as well, which is the question on consent. But I want to begin, before I even talk about consent, what I want to talk about is I want to make a confession. मैं वकील नहीं हूँ, तो please मुझे माफ मत. So with that, I'm not a lawyer. I want to begin with consent because of the story. Let me begin with the story first. Let me call this girl Pooja. मैं हरियाणा में काम करती हूँ पिछले 2-2.5 साल से. मनीषा मेरी गुरु है, उन्होंने बहुत सारी चीजें सिखाया है, वाकई. Manisha taught me a whole lot. I work in Haryana, I do research, and then I've been working there for the last 2.5 years. In a district in Haryana, in the case of a young woman called Pooja, I went to see her on a hot summer day. It's incredibly hot. We go into her house. Her father is sitting there, who I noticed is paralympic, जिनके टांगे घुटनों के नीचे से कटे हुए हैं. And we speak with him for a few minutes. We go inside and speak to Pooja. Pooja is a young woman, short, with bright, beautiful eyes and a lovely smile. And after I speak to her mother, she finally I ask her, "Kya hua?" So she sighs and she says, "Well, in this tone of repetition, दो लड़के आए, मेरे को ले गए, मेरे मुंह पे कुछ उन्होंने डाला और मैं बेहोश हो गई, तो मुझे लेकर और फिर सुबह मेरे घर के चौखट पे मैं छोड़ के चले गए. 2 men came in and around at my job. They put a cloth over my mouth, which made me unconscious, which took me away, and left me unconscious at my doorstep the next morning. The 2 men were charged. This young woman, Pooja, is Dalit. The case was filed against the 2 men. They were eventually taken into custody within a series of very rapid events. A compromise was reached for 6 lakhs. That's the story. What's remarkable about this story is that it's not unusual. In fact, ऐसी कहानियाँ आप लोगों को सबको लगेगी कि ये कहानियाँ तो हमने बहुत ज़्यादा सुनी है. चाहे आप तमिलनाडु की बात करें या हरियाणा या पंजाब या गुजरात या हैदराबाद, ये सारी कहानियाँ हम बहुत सुनने में आए हैं. मगर इस कहानी की खूबियाँ क्या, खास चीज़ क्या है? What is interesting or important about the story? What is important about the story dates me back to when I first came to Haryana to see.
नमस्कार. तुम्हाला मराठी प्रश्न असा आहे की मी सध्या तासगाव पोलीस स्टेशनला काउन्सिलर म्हणून काम करतोय आणि तासगाव पोलीस स्टेशनला मी सध्या काउन्सिलर म्हणून काम करतोय. माझी एक केस आलेली त्या इंटरव्हेन्शनमध्ये 2 ट्रान्सजेंडर आलेले. मग जेव्हा ती केस सॉल्व्ह झाली आणि कनेक्टिव्हिटी चांगली झाली पण असं चर्चेमध्ये आले की त्यांना काय म्हणलं
तुम्ही जरा पुढे घ्या हळू आवाज
प्रश्न असा आहे
त्या ट्रान्सजेंडरला कम्युनिटीकडून प्रॉब्लेम शिकण्याचा आणि तो जर शिकला तर तुम्हाला
तुम्ही मला प्रोत्साहन केलेलं आमच्या कम्युनिटीमध्ये समजलं तर तुम्हाला मग त्याला आता शिकायची इच्छा आहे. आता मुंबई युनिव्हर्सिटी शिक्षणाचे डिस्टन्समध्ये बरेचसे प्रोग्राम करू त्याला मी काय मदत करू शकते किंवा कशा पद्धतीने
हाँ समझना मैं इनका सवाल है 2 ट्रांसजेंडर आए इनके बॉयफ्रेंड्स तो उसमें से एक पढ़ा लिखा है लेकिन वो आगे पढ़ना चाहता है लेकिन पढ़ नहीं पाता और इन्होंने काफी कोशिश की कि वो आगे जाके पढ़ सके लेकिन वो ट्रांसजेंडर उनको कह रहा है कि अगर मैं पढ़ूं लिखूं तो मेरी कम्युनिटी भी मेरे को प्रॉब्लम करेगी और आपको भी प्रॉब्लम होगा. तो मैं तो ये चाहूँगी ऐसा कुछ नहीं होता. मैं खुद MSc टैली कोर्सेज अभी ट्रांसजेंडर की छात्र हूँ मैं कर ली थी. तो आप जैसे भी वो हेल्प कर सकते हो. कम्युनिटी का टेंशन मत लो. कम्युनिटी सिर्फ उसको जो कल्चरल है वही बताएगा और अगर वो खुद आगे होकर पढ़ना चाहता है तो कोई कम्युनिटी उसको पीछे नहीं खींचेगी. आई गारंटी.
और कोई सवाल
ट्रांसजेंडर का आइडेंटिटी कार्ड बनाने के लिए कौन कौन से कार्ड चल सकते हैं? क्योंकि पहले होता है कि कहना है कि हम गैजेट के लिए गवर्नमेंट को देते हैं तो गवर्नमेंट ऐसा बोलती है कि हमको मेडिकल सर्टिफिकेट चाहिए. ऐसे 9 पैसे हमारे पास नेचर में आए.
आपका ये क्वेश्चन का आंसर मैं देता हूँ एज नॉर्मल लॉयर. तो अभी देखिए ऐसे ट्रांसजेंडर आइडेंटिटी कार्ड के लिए कोई सरकारी कोई मॉड्यूल हम लोग के पास यूनिवर्सिटी नहीं है. अभी ये आपका गुजरात सरकार एजेंट नोटिफिकेशन पब्लिकेशन करवाने के लिए जो SMS का डॉक्यूमेंट्स मांग रहे हैं ना ये बिल्कुल गलत है. ये अगेंस्ट द नालसा का प्रिंसिपल जाता है. तो आप अगर चाहो तो इसके ऊपर आप लोग PIA डाल सकते हो क्योंकि एकदम ही अगेंस्ट द प्रिंसिपल ऑफ नालसा. ये तो जजमेंट का वायलेशन हो रहा है क्योंकि ऐसे को कहीं भी इंडिया के कहीं भी ये सब नहीं मांगा जाता.
नालसा कोड करके आपने किया है.
हाँ
नालसा का कोड किया है कि इसे जजमेंट की है और आप नहीं मांग सकते तो भी वो
आप PIA डालो केस हाईकोर्ट पे आने दो उसके बाद देखो क्या करना है.
हमारा एक दोस्त थी माया शर्मा गुजरात में. हालांकि उसका डिपार्टमेंट से मीटिंग भी हुआ है और ID कार्ड को लेकर वो कानूनी तरीके से लड़ने के लिए तैयारी भी की. हाँ आपको पता है. अच्छा तो माया शर्मा का आपको नंबर दे देंगे आप उनसे कॉल करें.
Ministry of Social Justice and Empowerment issued a notification based on the expert committee reports regarding 5 umbrella schemes consisting of 5 schemes for the welfare of the transgender. Has this been implemented anywhere in any state? Or what is the current status of that social welfare scheme?
Which state is this?
No, I'm sure my question is, has it been implemented anywhere? The Ministry of Social Justice issued a notification consisting of 5 umbrella schemes, centrally sponsored schemes. So my question is, has it been implemented anywhere? What is the current status of that scheme?
So actually there is a political intervention and the administrative intervention also for the livelihood options of the transgender people. For example, NIRD-PR has updated their website with the DDJY scheme, RCT schemes, as I had told yesterday. So in that, they have added transgender people also along with the unemployed youth. And this 5 umbrella schemes, I don't know which schemes you are referring to. Every state has their own schemes also come up with their own policies. So, for example, Andhra Pradesh has come out with the housing scheme. They are giving plots and also lending the loans for the transgender people, which few districts they have already completed. They are given the loans and they have completed the housing scheme. The thing is how there are a lot of variation between the state schemes and central schemes also. So, state has its own budget in order to meet the sustainable development goals which Niti Aayog will coordinate globally. So they are linked with those schemes and those goals. So every state is putting their own efforts and own money in it. For example, Andhra Pradesh has given 20 crores for the upliftment of transgender rights, transgender people's rights. Kerala has allotted 14 crores for that. So every state has its own budget and own schemes, including pension schemes also. Apart from that, the Ministry of Social Justice is connected with various multiple organizations at the central level which now are making policies. Because what is happening at one hand, government is pushing the bill, and this bill, when it came in front of the Parliamentary Standing Committee, the committee also questioned, you want to remove the begging and you want to criminalize the begging. So what options you are showing them to the other alternative livelihoods? Then the government came out with an explanation saying that here we are dealing with this other departments for the other livelihood options, which we cannot put in the bill. So that is the update. So the central schemes will be very much different, which can be through the central schemes which are now for the unemployed youth or female collectives, all those things, and the state schemes can be different.
I would like to add one more thing in Maharashtra this year, that for our Right to Education Act, there are 25% reservations for poor children, especially marginalized communities. So from this year, they have included cross-gender in this 25% reservation, along with the disabled and other marginalized communities. So this is one important thing happened this year in our government message.
So I literally my perception is contrary to that views, because merely providing through RTI or a specific space in schools for transgender people itself, that itself won't work out, what I feel. For example, in Tiruchi, he have suggested a clause saying that to incentivize the families who have transgender children and gender non-conforming. Because as you all know, there is also a central scheme, Beti Bachao Beti Padhao scheme. So in that way, family is the first social unit where transgender children and gender non-conforming children are disowned by the families. That is the first place where children feel very transporting and children feel discriminated and run out of their homes. They are forced to run out. It's not the problem with the families, but the immense transphobia around the family structure. It can be by the neighbors, it can be by the school administration, everything. So Tiruchi Shiva has prescribed to incentivize the family so that the poor families how they hold the girl child and they get educated the girl child, they may hold the trans child also.
That's true actually, but the same thing is even the children from Dalit communities face these things. And I think we have, like in initial stage, everybody has to face this. If we really wanted to prove our existence, so this children has to go through it. All other children are facing this problem.
No, but the onus of not getting beaten up and raped in school should not lie upon the children. That onus should lie upon the administration, right? Even with Dalit children. That we say, I wonder what it is to say that the children have to prove themselves because it is not as if they are doing what other children are doing. They are protecting themselves from being beaten up and raped every day, be it Dalit kids or be it transgender kids. So I think we need to have that clear distinction that the onus falls upon the state to provide security and trans-friendly environment if they have a scheme. Otherwise, don't have a scheme, don't have a school. Yeah.
That's a good point. And I want to add to that point one thing is like being a class marginalized and a gender marginalized is very different things. Because if you are gender marginalized, you are marginalized as your own people also. Even father, mother doesn't hold the children being a gender varying children or gender non-conforming children, which is different with the caste different, So that rezoning is it's a very tough journey for the child. It gives a lot of burden on the child to negotiate with the parents also. At any point of time, they will give up, they will run away. Now it's over there, it's not up to me. This is not my place. And end up on the roads, on the making of sex. That's what I think.
I have a question. Can you tell us a little bit about the plight of transgender prisoners in jails across the country? I know View has a separate block for trans prisoners, but does the community want separate blocks? Because then we can also talk about isolation. Or how is the community thinking about it, and what is really the state of trans prisoners? They're definitely they're playing by gender in prisons for sure. Because masculine or trans-masculine people, they are put in male jobs and transgender are put in female jobs. But is that what the community wants, or does the community want separate, not just blocks, but also then should the jail be providing for SRS, because it is a life-saving surgery? Should the jail, if they are already on hormonal treatment, should the jail then be providing for finishing that treatment, because you can't just leave it halfway? So what does the community think about it?
See, I can say you about the homes, juvenile homes. I have visited some juvenile homes in my state, that is state of West Bengal. I found that there are some trans persons, they are staying at the male home for the male child. They are staying at there, but now the problem is they are facing like the male children are literally they are just disturbing her. Literally they are disturbing and trying to molest her, literally. And now I go for a girl's home. There was also a trans person who was a trans-masculine person. Now the other girls of that home, they are saying they are denying literally to stay with him. And now I think, it is very much required for a separate trans prison, because if these people are in the so-called cis-normative, जो पहले लोग हैं cis-normative, अभी ये लोगों के साथ अगर ये लोग रहे तो ये लोग नहीं चाहते हैं उन लोगों के साथ रहना. अगर रहते वो लोग रहते भी हैं तो फिर उन लोगों को मॉलेस्ट किया जाता है. ये मैंने देखा है. तो इसलिए बहुत ही जरूरी है ये, क्योंकि और दूसरी बात ये है अभी तो जेल तो करेक्शनल होम हो चुका है। अभी ये जेल नहीं तो फिर करेक्शनल होम ही है। तो I think starting point of that humanitarian ground, these things should be provided. These things should be provided.
I would want to talk about my own experiences. Like you all know that prisoners, like they are prisoners, they are the rights of people, and the staff of the prisons behave very willingly, and police also behave very willingly, and they can't complain also. And we have two experiences in Telangana. The two variant people. One is who have been emasculated, the trans women, who mostly have been arrested in crimes who they mean, or in the sex work they have been like. So they first will take them and they will strip them. They will strip them, they will make them new, and they will examine them, which is not done in other prisoners like these. So this examination happens with them, and there is no proper guidelines also for the based on which guidelines they are doing this checking and examination. One thing, this is emasculated women, and they are kept in women prison who have been emasculated trans. Now coming to the non-emasculated trans women, the guideline is very important. They not only strip them, they weigh them, they measure the organs, and they weigh them, walk in front of the police personnel, and their blood has been collected without their permission, and they say that we check your hormones whether you are trans. And this all works on their psychology, and it becomes a lot of burden on them to take this, and it hurts their pride and dignity. And almost 90% of the people who are non-emasculated, once they have get through this presence, because 80 to 90% of the transgender people are fertilized, similar to Muslims, that is not. Because they are either sex work or baby, and they have to somewhere they will catch up, and they will have, even I have been affected. The thing is, now after getting to this payment level, a client came out of the prison and this thing has happened. Soon the day, after 2 days or 1 month, they go and get emasculated. Now the things changes for them. Once they get emasculated, we have also seen 81 case on 377 also. And at a particular point of journey, the judges and the advocates, they got this empathy and sympathy in their heart, being fully transformed into biologically, and even the judgment also varies. So what I am saying is again the judgment and the ravaya of the prison staff and police, again it is rotating around the bodies. Everything is around the bodies of the trans bodies, which we have to acknowledge. So if you want to put everything in a proper place, you have to question all the procedures starting from day one. If trans people are prisoners, irrespective of their body changes, surgery or anything, which also speaks about, we have to get we have to ask, question each and every thing of this.